My lord, for my personal reason, my lord, may I only be permitted to mention one matter? My lord has
If
fixed
you
it
want
tomorrow.
leave granted.
No, my lord, no, not asking for leave, my lord. My lord is pleased to fix, my lord, WPO 374 of 2023 tomorrow for my personal reason. I will not be in
Very
town.
well. Ask somebody to mention. when the
Very
matter
well. I'm
is
grateful,
called.
my lord.
Yes.
Grateful.
Call on the matter. No, mentioning is on Thursday. If you want leave granted. Call on the list, please.
Do we mention item number 1?
Lord, I am praying
Yes.
Lord, I am praying unconditional apology. Kindly excuse me, my Lord.
What, excuse me?
Lord, I missed the order. I could not find out the matter. This is for default.
I can't hear you. Come here.
I am for the. I am for the petition, my Lord. I could not follow the file, my Lord. The matter this is for default long back.
The matter was dismissed for default by Justice Chakraborty
Yes, my Lord.
when Justice Chakraborty was taking residuary matters.
Yes, my Lord.
That was in 2018, I think. And
Yes.
you're telling me you want to do the matter now.
No, I am
And
praying,
the, and the order, if I had not asked the IT department to file a report as to what I wouldn't even have known, I would have heard you and passed orders. And the matter was dismissed not for default. Justice Chakraborty passed an order saying on your prayer that that you wanted to withdraw the petition. It not even dismissed for default.
No, I am praying unconditional apology, my Lord. Kindly, my Lord.
The report of the registrar, IT, capital R, encloses an order passed by a learned single judge on 11th September 2018, recording that the writ petition was dismissed as withdrawn on the prayer of learned advocate appearing for the petitioner. Stop. The petitioner was given liberty to file a fresh writ petition on the self-same facts and cause of action. Stop. Next. Yes. Next, it must be recorded that this matter was kept on 17th April 2023 as a last chance to counsel appearing for the applicant, since no one appeared for the petitioner yesterday when the matter was taken up. Stop. Next. Learned counsel is, however, present in court today. Stop. The matter was kept as to be mentioned today, since these facts were brought to the record, since these facts, the above facts were brought to the notice of the court, were brought to the knowledge of the court. Stop. Counsel is present today, and hence appropriate orders are being passed today. Stop. Next. Yes, can 1 of 2020, both the cans of 2022 are dismissed. Stop. Since the writ petition was also already dismissed as withdrawn by the order dated 11/9/2018, nothing further remains to be decided in the writ petition. Stop.
Get put your lordship. I mean, record.
Item number 2.
For the state lordship. Yesterday also matter was appearing before a lordship with an indication that matter to be released. And yesterday also matter was listed, and it was indicated in the list that matter for release. Now the petitioner appeared and your lordship asked why release. Well, he could not answer. So your lordship directed the matter to appear today also.
Probably scared of me, that's why I didn't answer. Yes. This matter was listed yesterday on the prayer of, on the mentioning of counsel appearing for the petitioners for release of the matter. Stop. Next, however, when counsel was asked yesterday as to why he wants release of the matter, counsel could not give an answer. Stop. Next, no one appears for the petitioners today when the matter is called on. Stop. Next, list this matter. In the, why do they want release? What is the prayer?
No, I do not know.
It's not residuary.
100% residuary. This matter should be a Heard by your lordship.
List this matter um, in the first week of May 2023.
Grateful lordship.
Item number 3.
My lord, this is for non-prosecution. Since DRT3 is properly functioning, the petitioner wishes to withdraw. My lord, since DRT3
Yes,
is
yes, Avans. Yes, learned counsel appearing for the petitioner submits that the petitioner would like to withdraw the writ petition since DRT3 is functioning, is presently functioning. Stop. Counsel hands up a letter from the petitioner dated 10/4/2023, which is kept on record. Stop. Next, WPA 5792 of 2023 is accordingly dismissed as not pressed, dismissed as withdrawn. Stop. The letter is kept on record.
Item number 4.
I pay for respond number 5.
My lord, I am appealing for the appellant. I am withdrawing the instant matter as DRT3 is functioning.
Do you have a letter?
Yes, my lord, I have submitted it yesterday. কালকে mention আছে মধ্যে।
একই অর্ডার হবে, শুধু লেটারটা বাদ দিয়ে দাও। There is no letter.
No, my lord, as of now.
লেটারটা বাদ দিয়ে, লেটারের এটা বাদ দিয়ে দাও।
Grateful, my lord.
আপনি কি এইটা বলছেন? এটা কি এইটা বলছেন? এটাতে কি আছে? এটা চিঠি নয়।
Item number 5.
On item 5, I beg to appear on behalf of the petitioner.
My lord, I appear for the
On
respondent.
the interim order till yesterday, 10th of April 2020.
I can't understand what you're saying. When is the interim order?
On the interim order passed by the Honorable Coordinator Bench on 16th of March 2023. My lord has been pleased to extend by an order dated 28th of February 2023.
Don't say 16th of March, it's 16th of January.
Sorry.
Why is it 16th of March?
16th of January.
That's why I could not find the order.
This is a mistake on my part.
Very well. Yes. I can't hear you.
My lord, on for the state respondent, my lord.
আপনাদের নিজেদের দিকে একটু টান।
And pursuant to your lordship's
My
direction
lord.
on 27th of March
Very well.
2023.
Yes, the interim order passed by a coordinate bench on 16 January 2023 and extended thereafter by this court expired on
10th April.
10th March. 10th March.
No, 10th April.
10th
Yes.
April 2023. Stop. Next, the railway is represented. Stop. The interim order is extended till.
My lord, I'm led by Mr. Madan Murari Verma, my lord. He is hospitalized, my lord. So I'm bringing a little bit longer time, my lord. My lord,
Longer
in this
time?
longer time to list the matter, my lord, for hearing.
The interim order is extended till
My lord, second week of May.
9th June 2023. Stop. Next, learned counsel appearing for the railway seeks a longer time before the matter is heard out on the
For the count.
basis that senior counsel is presently not well.
Grateful lordship.
Grateful to us.
ম্যাটারটা কবে?
Yes, list this matter. When do you want the matter?
My lord, any week on June. My lord,
In
any day on
June?
June or May, my lord, and we before the holidays, my lord.
List this matter on 15th May 2023 as
Grateful,
prayed for.
Grateful lordship.
As your lordship.
And have they unlocked the place?
Yes.
My
On
lord.
that, for the mind of
My lord,
order,
we have
very
ordered
next day, they have unlocked.
Very well. Yes.
Grateful to your lordship.
Item number 6.
I appear for the petitioner.
My lord, Mr. Tarunjoti Tiwari is appearing for the Union of India. My lord, he's engaged in code number 30.
Sorry, who?
Tarunjoti Tiwari is appearing for the Union of India. My lord, he's engaged in code number 13. My lord.
Yes.
Last occasion, your lordship, my lord, directed me to, my lord, file a bullet points of submission, my lord, before, my lord, the hearing comments. I have prepared that, my lord.
I'm giving the matter tomorrow, file it. All right. Yes, adjournment is prayed for on behalf of the Union of India. Stop. List this matter tomorrow. Stop. What is the matter about?
My lord, this relates to, my lord, technology upgradation scheme, my lord. IAS granted benefit. They have unilaterally recalled, my lord, the benefit amount which was granted as benefit. I challenged, my lord, in the writ petition that I was not given an opportunity before, my lord, the order was passed. During the proceeding, my lord, they come up with a joint inspection report, my lord, and 2 grounds were taken. I have in my affidavit in reply, my lord, I have substantiated.
I've remembered. Yes, Poshudin Kurda.
You have to.
13th. Next.
Item number 7.
I appear for the petitioner, your lordship. I am aggrieved by I appear for the petitioner. I am aggrieved by non-disposal of my
Affidavit of
1614
service.
lordship. The writ petition is filed in August 21, your lordship, and that time it was served. So service was complete, but it has been long back.
Miss Oja, you have to, last time the matter was heard by a coordinate bench is on 25th November 2021.
Yes, your lordship, it was released because
It
since
was
that-
released. Have you
that-
served them after that?
No, your lordship.
No, please serve them and then come. All right. We are almost 2 years from that date. So they have to know, the borrower must know that the matter is before the court once again. Yes, the records show that a coordinate bench released the matter on by an order dated 25th November 2021. Stop. This matter is appearing in the list for the first time after that date. Stop. Next. Hence, the petitioner must serve the respondents once again. Stop. Next, list this matter. When do you want it?
Oh, a week's time, your lordship, within a
List
week.
this matter on 18th April 2023 as prayed for.
Item number 8.
Item number 8, my lord, I am for the petitioner led by Mr. Tanmay Chaudhary. My lord, actually in the morning, Mr. Chaudhary had to take his mother to the hospital, my lord. I'm only praying for a
When do you want to come back?
My lord, on Thursday, my lord.
Yes, adjournment is sought for on behalf of the petitioner. Stop. List this matter on 13th April 2023 as prayed for.
Item number 9.
Lordship, I'm appearing for the petitioner in this matter, Lordship. I'm led by Mr. Rotnanku Banji and Ms. Manju Bhuteria, Lordship. This is a matter, Lordship, wherein we had argued our matter on 6th of December, Lordship. On the previous occasion on 3rd April, Lordship, the other side had come and sought time to seek instructions on some documents that we had filed with respect to the affidavit in reply, Lordship. Lordship, they are required to make their submissions, Lordship.
Yes, microphone, please.
My lord, I am for the respondents. I am ready to argue the matter.
You're ready. You're for the Reserve Bank of India. I can't understand. Microphone, please. And in any case, you're wearing a mask. I can't understand a single word you're saying.
I'm sorry. My lord, I am appearing for the respondents. I am ready to argue the case. On the other side, other day, my learned
Yes,
friend.
yes, please argue. You are Mr. Nayak?
Yes.
Yes, please argue. You're for who? Which respondent?
I am for all the respondents. There are 2 respondents. I am for all of them.
You don't know which, you don't know who the respondent is?
Yeah, state officer and the Union of India.
Yes.
Now, my lord, there is a complaint.
What problem? Microphone. What problem?
There is a complaint received
Complaint.
received
Yes.
by the railway authorities that some portion of the railway land had been encroached and a construction is being made by the petitioner. Now, my lord, relating to that, my lord, a
Use the
notice-
microphone properly, please. Yes.
relating to that, my lord, a notice to show cause
Complaint with regard to what?
for encroachment and illegal construction of the railway land.
Take your seat, please. Yes.
Now, my lord, a show cause notice was served upon the petitions. That is on 29th of March 2022, asking them to show cause why the unauthorized construction is being made on the railway land. That is their annexure P2. Now, my lord, in relation to that, show cause notice, my lord, on 28th of April, the petitioner appeared before the authority concerned, means the state officer, and replied that the note submitted a reply, written reply, that the notice is vague and illegal, and he demanded a fresh inspection. That is also their annexure.
So the show cause notice was issued by you pursuant to an inspection?
Show cause notice was issued by the state officer, asking him to show cause the why the unauthorized construction on being made on the railway land.
No, you're saying petitioner asked for a fresh inspection. So there was an inspection which took place before.
No, there was inspection before.
Yes, you tell me that. I
There
would
was
have to ask you.
There was an inspection before, my lord, and that took place. No, my lord. Afterwards, there is when the my lord, the petitioner appeared and asked for the time to submitted the petition. Then the
Asked for
respondent,
the time to do what? You said they asked for a fresh inspection.
they asked for fresh inspection afterwards. Prior to that, they appeared and submitted that these show cause notice is vague and illegal and should be withdrawn. And they also demanded in that same petition that there should be a fresh inspection on the railway land in their presence. Now, my lord, by the later dated respondent, meeting fixed the same meeting on 5th of May 2022. My lord, hearing took place about this, my lord, inspection and other demands on 5th of May, and the one Gauri Hari Das, the officer of the state department, represented the state officer, and he took the my lord hearing, and after the hearing, the state officer, my lord, submitted minutes with all other relevant documents to the petitioner, Anup Saxena.
Are you being led by somebody?
No, my lord.
No.
No.
Yes. Speak clearly and give me the chronology of the events, please. Yes.
Then, my lord, the all documents and the minutes of that meeting were handed over to the petitioner. But later dated 13th of May, the petitioner prayed for 30 days time as his father was ill. So he said that I will be appearing, but give me some time because of my father. Then, my lord, by later dated 17th of June, the petitioner, my lord, informed that his father expired, and he needs some more time.
Come to page 75, please. Page 75.
Page 75, yes.
Of the writ petition. '54 and 75. Page 54 first.
'54.
What is 54?
Lordship will kindly give me a moment. 54.
What is 54?
My lord, in 54, that is a notice under section 4, subsection 1 of the public premises eviction unauthorized occupation of 1971. That is the act.
Very well.
Under
How do you defend this? How do you defend this notice?
this note was given by the estate officer himself to Jiwan Lal Saxena and Anup Saxena.
How do you defend this under the statute? The 1971 Act.
Yes.
You know what happens in this court if you're not ready for your matter? And this is not the first time. I impose costs on the council concerned. If you're not ready and you're wasting the court's time. This is not the first time.
No, this is for the first time I am arguing before your lordship.
54 is one of the documents challenged in the writ petition.
That's true.
How do you defend it under the 1971 Act? Just tell me that.
That notice was given under that act, and my lord, as because it lordship will kindly say, I understand the opinion of the ground specified below. You are
24 hours to get ready?
beg your pardon?
Do you take 24 hours to get ready? I will give you that.
I will.
List this matter tomorrow for learned counsel appearing for the railways to get ready in the matter. Next.
Item number 10.
I beg to pay for the petitioner. No, the previous occasion, Lord, the respondents are not present. Your lordship directed us to serve a notice upon the respondents. You have served a notice.
Who is the answering respondent?
They appeared. West Bengal State Rural Development Agency, they appeared for them on the previous occasion.
Very well. Yes.
Report.
Microphone, please.
My lord.
You want a restraint on them from terminating your contract?
No, my lord. I'm challenging, Lord, the action. I'm challenging the action of invocation of bank guarantee by them, which is vitiated by fraud. Now, bank guarantee has been, my lord, invoked.
Already invoked?
Already invoked.
What is the interim relief you want then?
No, my lord, it is not an interim statement. The court directed. The court directed them to disclose the letter of termination. Disclose.
Yes.
Then, my lord, direction was given to file an affidavit. No affidavit has been used by them.
Yes.
And the matter was made returnable, my lord. It has come as a returnable matter. This is the position. Now, the only point is this, my lord. They invoked on the ground that on termination, we are invoking the bank guarantee. And we pointed out that there was no termination at all. So the action itself was fraudulent. The honorable court, my lord, while appreciating that fact, my lord, directed them to disclose the termination. They couldn't. Then, my lord, the court directed.
No, what does the contract say?
The contract says, my lord, bank guarantee, my lord, can be, if there's a termination, my lord, it can be invoked. But fact is, there is no termination at all. There was a recommendation for termination in 2021 June, to which we replied saying that since the site is not available, we are unable to complete the work. So kindly revoke that.
So what is the fraud? That there's no termination?
There is no termination. In reply, my lord, they, my lord, didn't terminate. They, on the contrary, requested us to extend the bank guarantee for the in connection with the said work for a further period of 1 year. So they accepted our explanation and didn't terminate, but directed us to extend the bank guarantee for a period of 1 year. We
So the
extended
writ
it.
petition was filed against invocation.
After that, my lord, after extension, I extended the bank guarantee. It had already expired. I extended it. After the extension, they have given a letter to the bank that upon termination, it is invoked. I am challenging that action, saying that firstly, there is no termination. And secondly, the fraud is that, my lord, when we replied to them against the
So what is Prayer D? What is 13/6/2022? Prayer D at page 24. What is this memo dated 13/6/2022?
the invocation, my lord, page 143. This is the, my lord, letter of invocation given to the bank, which we say is fraudulent because it says on termination and there is no termination. This is the, my lord, sole point. So that is fraud. And fraud is, my lord, that they, on reply to this recommendation, we said that site is not available. Kindly give us the free site. Then they gave a letter to us saying that all right, it's all right. You
So
extend
the
the
contract, you are going on working now?
No.
No.
The site is not available. No. Site, my lord, is there are concrete
Yes,
statements.
yes. You are appearing for
Lord,
whom?
will kindly allow me to place My lord, will kindly allow me to place the order which was passed on the first day by Honorable Justice Bhattacharya when the matter was taken up.
Yes.
Lord, here it is. Lord, may I place the entire order?
Which page?
My lord, the order is in the, my lord, it is passed on the 26th of August, my lord, which will be available in the file, my lord, report.
What is the date of the order?
My lord, 26th of August.
Yes.
My lord, says, learned counsel for the petitioner has raised an issue
Please,
at
please, not the whole order, just the relevant
the operative part.
Yes.
My lord, I will, my lord, will kindly take up the internal page 5. My lord, in between, my lord, there is the word however starts, my lord, from the second paragraph, my lord. Internal page 5, my lord.
Yes.
However, since the bank guarantee has already stands invoked, no injunction can be passed at this juncture as the prayer of the petitioner in respect of such bank guarantee, since an order directing refund of an amount will tantamount to granting the final relief to the petitioner. Inasmuch as the question of cancellation is concerned, the respondent authorities ought to have given an opportunity to explain and or bring sufficient material before the court to indicate
Very well.
whether
Yes. So no interim relief.
no interim relief, my lord, the only
Affidavits are over now.
my lord, the affidavits has not been exchanged, my lord. That is the only fault. Perhaps I stand, my lord. I would not.
But there was a direction for that for 3 weeks.
My lord, there was, my lord. I tender my unconditional apology on behalf of the clients, my lord. That is the only difficulty we are standing today, my lord. We have not been able to. However, the affidavits are ready. It has not come to us.
On costs, please.
My lord.
Which respondent?
My lord,
2 to 4, my lord. West Bengal Rural Development Agency.
The answering respondent should be.
You're for all of them?
My lord, I shall.
Yes. The order passed by a coordinate bench on 26th August 2022 indicates that the petitioners were not given any interim relief. The petitioner was not given any interim relief. Stop. The learned single judge, however, passed a direction for affidavits. Stop. The respondents were to file their affidavit in opposition within 3 weeks from the date of the order. Stop. Next, learned counsel appearing for the state respondents submits that affidavit that the direction for affidavits has not been complied with and seeks time to file the affidavit. Stop. Next. It is evident from the order that the affidavit in opposition was to be filed by 20th September 2022. Stop. We are now in April 2023. Stop. Next. Affidavit in opposition to be filed by, yes, when?
2 days.
By 17th April 2023 upon costs of rupees blank being paid by the state respondents to blank within a fortnight from date. Stop. Reply within
1 week, my lord.
Reply within 25th April 2023. Stop. List this matter on 27th April 2023.
Only a humble prayer of reconciliation of the cost.
Next.
Item number 11.
My application.
I appear for the respondent.
Yes.
So my learned friend begins. It might take some time. I'm a little handicapped. The advocate, my junior who's looking after the matter, he is not coming to court for this week for personal reasons, for happy reasons, but he is not. He's just had a child yesterday.
Do you want an order today, Mr.
Well, it was coming after exchange of pleadings. So
exchange of pleadings?
yes.
Very well, you start. We can hear Mr. Ghosh on the next day. Yes. How much time will you take?
It'll take some time.
You also don't want to do the matter?
No, I want to do the matter.
What's the unhappy reason for that?
There is no unhappy reason. I want to do the matter. I'm otherwise ready. But it'll take a little time because there'll be some
Doesn't matter.
documents.
Give me the outline, please.
Yes, just the outline is simple, my lord. Factually, I'll indicate 4 things. There is an There is an agreement by which I am entitled to collect. Lordship needn't be troubled by the papers. Now I'll just give a brief background of what the matter pertains to, the dispute, their objection, and what I need to address your Lordship on. 4 important facts. One, I have an agreement in 2009
against DVC.
Against DVC. I have an agreement in 2009 by which I'm entitled to lift dry fly ash and use that.
Yes.
There is another agreement. I'll come to a tenure, terms, all that later. I'll just indicate what the dispute. There's another agreement in 2019.
Have you got an interim order or not?
No, my lord.
No.
No. Interim order would have, your lordship has held that it would amount to giving the final relief, and therefore.
Yes.
But there was one part of the order that they've not possibly complied with, but I'll come to that later. That's with regard to their affidavit. Now, 2019, there's another agreement which changes the rate and my entitlement in terms of how much quantity I can get of that dry fly ash.
So after 10 years?
After 10 years. So the first agreement of 2009 entitled me to 1,000 metric tons for a tenure of 20 years at 1 rupee. 2019 is tenure is the same. It becomes 6 rupees for 1,000 metric tons. Total becomes 1250. The remaining 250 on the price at which it is auctioned. Then the dispute begins after 2019, where they say that the ministry has come up with a guideline which has now recognized that this dry fly ash is a very important and a valuable commodity. Therefore, everything will have to now be by way of an auction. So you enter into a fresh agreement with me. This is the impugned letter, that you enter into a fresh agreement with me, based on which now for all future, you are going to participate in tender. Basically, the agreement that I have is going to be given a go-by. I have to enter into a fresh agreement that henceforth I will participate in tender only, then collect. This is poised on 2 counts. One is that this is the guideline of the ministry. Second, this is a very valuable commodity, and the DVC is making a loss by going by the existing commitments. So the challenge is on 2 counts. One is there's a complete lack of understanding of what the ministry guidelines say, because the guidelines are very, very categoric, and now that is born from the guidelines.
So the guidelines save the existing arrangements.
That's right. Guidelines specifically pertain to new commitments. 1, guidelines mention that you honor the existing commitments. 2, the purport of the guideline has been now clarified by the ministry itself in an affidavit before the National Green Tribunal, where it's categorically said that it pertains to only future.
What was the interim relief you sought for?
Well, I was not there then, but
why did you not get it? If it's such a clear case, then.
Well, that would have really been, that would have amounted to a final relief, because interim order would have been that allow me to carry on.
And why should I not, why should I decide not to interfere? Because it's a policy decision of the government?
No, the policy decision, that your lordship can refrain from interfering. I'm showing this contrary to the policy decision. In fact, this is in breach of the decision itself. That's one.
No, the government decides that for whatever reason, that fly ash is now a valuable commodity.
Yes. So
and therefore, you will have to enter into a fresh tender or auction process, from what I've been able to understand.
Well, that is, if I may, that is DVC's understanding of the guideline. So if I take the guideline to be the policy, then this step that is impugned here is contrary to that policy. Because now it will come down to, my lord, whether what is the interpretation of that policy, whether the policy prohibits existing arrangements to carry on the basis of the existing arrangement, or the policy applies to new arrangements saving the existing arrangement. That's one. Secondly, in the unlikely event that your lordship holds that this is for future, this is for present existing also, then that policy will also have to be tested on the anvil of Article 14, where once.
So your interpretation of the policy is not on the same ground as DVC's?
DVC's is in my respectful submission, it's a deliberate misunderstanding of the policy. Because now the policy is absolutely clear that it is prospective. In the event your lordship holds otherwise, even then legally I'll be covered, because a policy has to be prospective. This is not a legislative policy by which, this is a policy by which the executive is taking a step. So these policies, the law is clear now that policies have to be prospective. So existing arrangements, for example, your lordships have held land policy, allotments which have been there prior to land policy. When the policy comes in, existing arrangements can't get disturbed. Similarly, my right to performance of an obligation stems from a document that precedes the policy. Whether a policy decision can come and curb that. So it's twofold, but I don't think I'll need to really argue on the second bit of it, because in my understanding, the policy is clear that it is not retrospective. It is.
Yes.
So this is more or less it. There is a minor, in my understanding, a minor issue that they have taken with regard to the maintainability. I'll address your lordship on that. Lastly,
maintainability of the writ petition. On what grounds?
Standard grounds, contractual that and arbitration clause that. But so I'll.
It's a minor ground.
Yes.
Yes.
But, minor grounds only because I'm covered by your lordship's judgment. And the law is also clear, my lord, as recent as 2023.
Why my judgment? There's Harbanslal Sahani before that.
Harbanslal Sahani, as recent as 2023 to SCC, it's there. So that's really not something I'll need
MP power.
That's right, MP power. MP power.
But that is more on the non-statutory contract.
That's one of the grounds.
Yes.
That non-statutory contract, this is, according to them, I'm seeking enforcement specific performance of a contract. That is.
Can you do that in a 226?
Well, even if I take it to be true, though it is not, even then I possibly will be able to.
You can seek a specific performance in a 226.
226 of a contract of an instrumentality of a state, if I can show that it is in breach of the standards prescribed under Article 14. In other words, not really going under Specific Relief Act, if I can show that non-adherence is arbitrary, then that arbitrariness is subject to judicial review. I'm not looking at it from the perspective of the Specific Relief Act.
The arbitrariness in not enforcing the contract, that is subject to judicial review.
That will be subject to judicial review. It's clear. From ABL International, your lordships have held. Same.
ABL International, now it's all covered in that.
The last one.
Yes.
So that is a non-statutory contract. A non-statutory contract, if there's arbitrariness.
Anything else, Mr.
This is the larger picture. I'll have to just take your lordship through the offending letter, the circular, the ministry's stand on affidavit apropos the guideline. Even if I give the guideline its highest credence and call it a policy, to show otherwise that a policy is prospective, it can't have a retrospective effect. And this ostensible defense of this being an extremely valuable dry fly ash commodity, it by their own reply to my Right to Information Act application, this possibly gets dislodged. Because from the 100% that they say they have, they use 15% of that by way of tender. 15% is giving to long-term existing agreement holders like me and Novoco. Novoco is on a slightly different footing. But so there are two long-term, which is me and another party. And only 15% actually goes. And we've been able to collect from their own data, which has come by way of a reply, that the government, that DVC actually expends more in disposing of dry fly ash than what they've been able to earn through process of online auction. And recently, they've initiated an online action at ₹1, 46,000 metric tons, if I could get the figure wrong, but at ₹1 is being auctioned.
The reserve price is ₹1.
₹1. So this other question might also come up. Today, a state instrumentality is to therefore come and have to indicate to your lordship that if I have entered into a contract with a citizen and post that prices have gone up, I can repudiate.
Mr. Banerjee, on the next day, whenever that is, first on the maintainability, that you can seek this sort of relief in a 226 jurisdiction.
Well,
specific performance.
I am not, that is their defense. I'll just indicate that this is not, I'm not seeking specific performance. The rules of the policy,
well,
yes, on the maintainability.
Whatever the ground raised, whatever the merit be, you please answer to that.
Yes, ma'am.
Yes. When do you want to come back?
Whenever.
And Mr. Banerjee, please make it short. Don't say I need a lot of time.
No,
because you will not get it.
No.
How much time will you?
I have a leader. I'm being led by Mrs. Manju Bhutoria. So
that doesn't preclude you from telling the court how much time you want.
So if I am arguing, lordship will give me half an hour on facts and half an hour on the judgments.
Very well. 20 minutes to you, 5 minutes to Ms. Bhutoria. Yes, learned counsel appearing for the petitioner has placed the outlines of his submissions. Stop. This is an individual writ petitioner, not a
Yes,
company.
Not a company, individual.
What is he doing? He's the contractor.
He's a contractor
Of who? Of DVC?
of DVC. Not really a contractor. I have an agreement with a long-term agreement with DVC where I collect the dry fly ash.
Yes, list this matter. Tell me when, Mr. Banerjee.
I can come whenever, 13th, tomorrow,
Yes,
whenever it is.
list this matter.
Well, Mr. Ghosh wants it next week.
From Monday, he won't be.
List this matter on 19th April 2023 as prayed for.
Great.
As prayed for on behalf of the respondent. Next.
Grateful.
Item number 12.
Madam, for the petitioner. Appearing for the oil company.
I appear on behalf of the respondent number 9.
I can't hear you. That side, please.
Your Lordship heard this matter 2-3 occasions. Matter relates to a partnership firm.
Yes.
Where two brothers is one side and the sister is the other side. But a
Yes.
supplementary partnership deed has been
You're appearing for the sister. No, somebody retired from the matter.
That's why I have got.
I can't understand. Microphone, please.
My lords, after retirement, my lord say yes. Given no objection, I have engaged in this matter subsequently.
Yes. So what is the problem?
So the problem, no problem, my lord. There is the certain document which has not been, my lord, annexed to the writ petition. Though, my lord, this document, unless the affidavit in opposition is filed, my lord, this matter can't be, my lord.
No, you just file it in court. I will treat it as part of the affidavit in opposition. You don't have to file a separate affidavit in opposition for that.
No, my lord, then, my lord, I have to, my lord, then.
Yes. Give me the document, please.
So, my lord, may I submit?
Have you got copies? You have to give to the others, your learned friends.
No, my lord, the document which has been, my lord, the issued, my lord, by the, my lord, oil company to the, my lord, the petitioner as well as the, my lord, the sister, that has not been annexed, which is very vital document. Because of that, so, my lord, this the initially, my lord, this the dealership has been
What does
granted.
the document say?
Because of that, the supplementary, my lord, the agreement, shareholder agreement, which has been executed in 1993. So, my lord, that has not been accepted by the oil company. They have not challenged this order. So now in...
Who will challenge the order?
Because of that, the agreement, my lord, shareholder agreement executed, my lord, initially the oil company, my lord, granted, my lord, dealership in favor of the sister in 1989. So thereafter, my, this is the proprietorship business. Then, my lord, their shareholder, my lord, partnership business transfer in 1992. My lord, in the 1992, there is the, my lord, the percentage of the share, there is a 52%. So now that shareholder...
52% in whose favor?
In favor of the sister.
Say that, please. Yes.
Now, after my lord executing the said, my lord, the partnership...
So 52 in favor of the sister, 48 in favor of the two brothers.
So now in 1992, that, my lord, the agreement has been accepted by the, my lord, the Bharat Petroleum Corporation, that is, my lord, the gas company, my lords, and
this is a retail outlet, LPG.
Lords. So now they have informed, my lord, to the, my lord, the both the partners that after within 5 years, no further change will be granted by the oil company. Subsequently, in 1993, a supplementary, my lord, the agreement has been executed between the, my lord, all the partners. So now that has not been accepted by the corporate, my lord, the company, Bharat Petroleum Company. Subsequent, my lord, in 1997, my lord, 99, my lord, the oil company intimated to all the partners that.
So how did the sisters' share become from 52 to 1%? 1%. How did it become?
Supplementary, my lord, partnership agreement, which has been, my lord, executed in, my lord, 1993. So that, my lord, is the fraudulent, that suit is pending, the suit filed by my lord, petitioner hearing, my lords, the now subsequently obtained the injunction order, my lord. Injunction order has already been vacated.
Injunction with respect to what?
My lord, not to interfere the business of the petition.
Who will not? The sister will not.
No, my lord, I have been restrained.
That's
the sister has been restrained. So subsequent that injunction vacated. by the my lord, I have been informed, my lord, that copy is not received till today. So now in 1997, my lord, 2000, my lord, 1989, my lord, that also informed by the oil company that the share of the petitioner
The learned counsel representing the private respondent slash sister of the two petitioners, comma, retired from the matter on the last occasion, on receiving appropriate instructions from the private respondent. Stop. Next, the private respondent is now represented by you. I don't have your name. Sorry. Yes.
Pankaj Haldar.
Pankaj?
Haldar.
By Mr. Pankaj Haldar. Stop. Next, counsel counsel seeks to file a document by way of a supplementary affidavit, which appears to contain certain relevant facts with regard to reconstitution of the partnership. Stop. It appears that from 1993, did you say?
Supplementary agreement which has been executed in 1993.
It appears that 1993.
93.
It appears that the
one
private
document.
respondent's share reduced from 58% to 1%.
52% to my lord is the
52% to 1% from 1993 to 2022.
From my lord, 1% 1993. That has not been accepted.
Last time কি বললাম? এই লাইনটাই কেটে দাও। The private respondent counsel is given leave to bring this document and any other relevant documents by way of a supplementary affidavit, which should be filed by 17 April 2023. Stop. List this matter on 18th April 2023. Stop. Copies of the supplementary affidavit shall be made available to the other parties before the returnable date. Next.
Can it be on 19th, my lord, instead of?
No.
19th.
My lord, 19th, I have some problem.
Agree on a date, please, and tell me.
My lord, 21.
When do you want it?
21. My lord,
21st.
20th.
21st, my lord.
21st, as prayed for. Next.
Item number 13.
My lord, this is my writ petition. My lord, if my affidavit of service may be taken on record. My lord, I'll just indicate in a nutshell, my lord, my prayer is against the respondent registrar of assurances to record my sales certificate in terms of section 89 of the Registration Act. My lord, I am the successful auction purchaser. Auction is conducted on 23rd of March 2022 by State Bank of India, Sambi branch 2, my lord, Kolkata.
What is Sambi branch?
My lord, stressed asset management branch, my lord. I apologize, my lord.
Yes.
Well, thereafter, my lord, a sales certificate is issued in my favor. Sales certificate is dated 6th of April 2022. My lord, will find that sales certificate on page number 20 of my writ petition.
Yes.
My lord, thereafter, my lord, State Bank of India, my lord, the authorized officer had forwarded a copy of the sales certificate to the additional registrar of assurances, my lord. But they have not recorded the same in book 1 in terms of section 89(4) of the Registration Act. My lord, the last response that I get from them upon my representation was that it has to be registered in terms of section 17 because it amounts to a deed of conveyance. My lord, I send a representation after that, my lord, my last representation, which is 22nd of September 2022, where I had indicated that this is a sales certificate in terms of 89(4). Once the authorized officer hands over a copy of the certificate, it just needs to be filed and recorded. And there's no question of payment of any additional stamp duty, my lord.
They want you to be to go through section 17.
My lord, the rigors of section 17, which I have to pay the requisite stamp duty.
And you are saying 89(4).
89(4), my lord. My lord, see 89(4). And my lord, there are a few decisions, my lord, as also they've clarified this, my lord.
No, first the provisions, please. Yes. What do you have to say?
So far, my instruction is
Microphone, please.
So far, my instruction is the registration procedure nowadays in the interstate is
Learn how to use the microphone, please.
Yes.
Yes.
The entire registration procedure in the state is carried out by the departmental software, my lord. nowadays. That is, my lord, Noti Karan, my lord. And my lord, there is no mechanism in the my lord, software to receive any my lord, sales certificate under section 89. My lord, your lordship kindly grant some time to upgrade that, my lord.
What do you mean? If the software can't deal with a section 89 application?
My lord, so far my
It can only deal with an application which is routed through 17. What are you saying?
that has been instructed.
What software is this?
Well, sometimes
You are the registrar of assurances.
yes, my lord.
Yes.
My lord, some time is required to, my lord, upgrade that software, my lord.
What do you mean by some time is required? How much time? You will make these people wait.
Or your lordship can direct to do it manually.
Do it in whatever way you can. That's all.
Lordship.
But because if I may just indicate, my lord, today the authorized officer of the bank just has to hand over a copy of the sales certificate in terms of 89(4) of the Registration Act. Now, thereafter, in what manner they record it in Book 1, my lord, is their prerogative. My lord, I'm not aware of whether or not this system of e-filing is there or whether it's physical filing. So today, my lord, the authorized officer of SBI has in fact handed it over. Now, if they're asking me to do it manually, my lord, I don't understand what more do I have to do manually.
No, so the sales certificate is of 6th April 2022.
6th April 2020.
And when did SBI hand it over to the registrar of assurances?
My lord, will kindly take page number 26, my lord. There's a letter 6th of June 2022, my lord. I believe this may have been the second time. I'm bereft of some instructions on this point, my lord, but 6th of June 2022, it was definitely sent. Because this was in response to an RTI that I had made as to whether or not the registrar of assurances received any sales certificate from SBI. Thereafter, my lord, the registrar of assurances tells me that 89(4), you hand over a copy to me. Ask the authorized officer.
Show me the letter, please. Their letter.
Their letter, my lord, will kindly take 4th of June 2022 at page 25, my lord. This was in response to my RTI application.
And so far, my lord, respondent number 3 is concerned. He has instructed me. He has not received any sales certificate. That means, my lord.
No, what you have page 25.
Yes.
See what page 25 says.
Yes. My lord, he has.
It's a letter on record.
Yes, such certificate to the registering office within the local limits of whose jurisdiction the whole or any part of the immovable property comprised in such certificate is situate. My lord, that is
page 26.
26, my lord. Yes.
That is SBI's letter to you. Why are you saying that you haven't received it?
So far, the respondent number 3 is concerned. My lord, respondent number 3 is, my lord, additional sub-register Rajarhat.
So that is up to you. Give it to the respondent number 3. Who will give it? You. You give it over to make it over. Make over the document to respondent number 3. And how much time will you take to do it manually or in whichever form you have to do it? 89(4).
Well, it's kind of taken. If I may place.
Just show that it's not to be routed through 17. It has to be done by 89(2) and 89(4). That's all.
Well, 89(4), if I may just read. Every revenue officer granting a certificate of sale to the purchaser of immovable property sold by public auction shall send a copy of the certificate to the registering officer within the local limits of whose jurisdiction the whole or any part of the property comprised in the certificate is situate. And such officer shall file the copy in Book 1. Well, so this does not contemplate registration, my lord. It contemplates filing. My lord, I'll show decisions, my lord, which have clarified this.
17, please, first.
My lord, 17. I'll show 17. Documents of which registration is compulsory.
Yes. Just show that you don't come under 17, but you go directly under 89(4). That's all.
Well, this is a non-tested, this is 17(1)(c), my lord. which I would have otherwise fallen under. Non-testamentary instruments which acknowledge the receipt of payment of any consideration on account of any creation, declaration, assignment, limitation, or extension of any such right, title, or interest. But it is my humble submission in terms of Supreme Court decisions now that this does not apply to me any longer. That 17 does not apply to me because 17 contemplates registration. Whereas, my lord, 89.4 contemplates mere filing and recording it in book 1.
Yes, where is their letter asking you to register?
Well, there's one communication which I received from them, my lord.
Page?
Well, it will kindly take page 31, my lord.
Yes. This is under challenge.
This, my lord, I believe it is.
What have you challenged in the writ petition?
My lord, I'll just indicate one.
This is not under challenge.
No, sit. So P7. P7.
17th August 2022 and 28th July 2022. What are these documents? Prayer.
Well, 28th July, my lord, is the notice dated at page as 31, my lord. Is the notice at page 31 is 28th July.
Yes. The other one?
17th August, my lord, is at page 30.
What is that?
My lord, this is a covering letter to the RTI response that they give to me. My lord, will kindly see.
Yes, 31, where do they say that you have to go through, say, 17?
My lord, kindly sees, my lord, as per section 57, my lord, they've laid down the entire procedure that I need to follow.
Very well. Show me one Supreme Court decision, please.
My lord. Well, this is 2007, volume 5, SCC 745, my lord. I'll just take out the relevant paragraph.
Only one on the point, please.
My lord, I'll take.
So you can choose your best one.
My lord, I would have shown a Madras High Court judgment which covers several of them. But I believe this was the first one. This Madras High Court relies on this.
Justice Ravindran is one of the best. So this is fine. Yes.
Very well, madam. Very well.
Which paragraph?
My lord, will kindly take paragraph number 12 of the decision. 12. 2007, volume 5, SCC 745. Copy. Well, if I may just place the decision.
Where does it say in paragraph 12 about 89.4? It refers to 17.2.
Yes, my lord. My lord, kindly takes when a property is sold by public auction in pursuance of an order of the court and a bid is accepted in the sale.
Paragraph 12.
My lord, paragraph 12. My lord.
Says the plaintiff has produced the original. Where are you reading from?
I'm sorry, my lord. I'll just. My lord, these are on facts, my lord. I'm just taking the point of law, my lord, which is I think line number 1, 2. My lord, 9th line.
Very well. Yes.
Yes, my lord. When a property is sold by public auction in pursuance of an order of the court and the bid is accepted and the sale is confirmed by the court in favor of the purchaser, the sale becomes absolute and the title vests in the purchaser. A sale certificate is issued to the purchaser only when the sale becomes absolute. The sale certificate is merely the evidence of such title. It is well settled that when an auction purchaser derives title on confirmation of sale in his favor and a sale certificate is issued, evidencing such sale and title, no further deed of transfer from the court is contemplated or required. In this case, the sale certificate itself was registered through such a though such a sale certificate issued by a court or an officer authorized by the court does not require registration. Section 17(2)(12) of the Registration Act does not specifically provide that a certificate of sale granted to any purchaser or any property sold by public auction by a revenue officer does not fall under the category of non-testamentary documents which require registration under subsection B and C of section
Very
17(1).
well. Yes, that's all. Yes, sir. What do you have to say?
Therefore, no further registration is required, my lord. But my lord.
Oh, you agree? You agree to the position?
Yes, my lord.
Legal position. How much time do you want?
My lord, that high.
The petitioners claim to be the auction-purchasers of a property sold by the State Bank of India under an e-auction on 23rd March 2022 under the provisions of the SARFAESI Act 2002. Stop. The petitioners, the bank, capital B, made over the sale certificate to the petitioners on 6th April 2022. Stop. The petitioners wrote to the Registrar of Assurances. And the petitioners wrote to the District Registrar and State Information Officer Now, the petitioners wrote to the Registrar of Assurances on 4th June 2022 No, the petitioners were informed by a letter dated 4th June 2022 by the Registrar of Assurances that the petitioners were required to send a copy of the sale certificate to the local registration office for due steps under the for the steps required to be taken under the Registration Act, the capital, 1908. Stop. The petitioners, next paragraph, the petitioners are aggrieved by a letter dated 28th July 2022 from the Additional Registrar of Assurances, Rajarhat, by which the said authority expressed its inability to take the required steps under section 89 within brackets 4 of the 1908 Act of the Act. Stop. The ADSR, Rajarhat, also relied on section 57 of the Act and advised the petitioner to take appropriate steps through the official website. Stop. Next. Learned Counsel appearing for the state submits that the existing website
does not accept
submits that the existing website does not accept any application
under section
for direct registration in Book 1 under section 89 within brackets 4 of the Act, and that any steps which are required to be taken under the said provision would have to be manually done. Stop. Next. Section 89 within brackets 4 of the Registration Act, 1908,
respondent number 3 has not
casts an obligation on every revenue officer, capitals, granting a certificate of sale to the purchaser of immovable property sold by public auction to send a copy of the certificate to the registering officer within the local limits of the jurisdiction, within the local limits of the concerned, of the appropriate jurisdiction. Stop. The officer to whom the copy of the certificate is sent is thereafter under an obligation to file the copy of the certificate in book number 1, capital B. Stop. The impugned document in the present case does not consider the effect of section 89 within brackets 4 and the duty cast on the concerned revenue officer and the officer and the registering officer receiving the certificate of sale. Stop.
Well, one thing.
The impugned document merely directs the petitioner to the official website of the Directorate of Registration and Stamp Revenue to take the required steps. Stop. B. Arvind Kumar, B full stop Arvind Kumar. The Supreme Court in B full stop Arvind Kumar versus Government of India 2007, 5 SCC 745 makes it clear in paragraph 12 of the report, capital R, that that a sale certificate issued to the purchaser is evidence of title and also of the sale becoming absolute. Stop. The decision, the Supreme Court holds that an auction purchaser deriving title on confirmation of sale in his favor and having been issued a sale certificate is not required to take any further steps from a court in furtherance for registration of title. Stop. It was further opined that section 17 within brackets 2 of the Registration Act 1908 would not have any manner of application on these facts. Stop. Next, there is next, the above makes it clear that the impugned letter, the impugned letter, the above makes it clear, the impugned letter issued by the ADSR Rajarhat dated 28th July 2022 is hence not only contrary to section 89 within brackets 4 of the Registration Act, 1908, but also to the decision referred to above. Stop. Next, WPA 26463 of 2022 is disposed of with a direction on which one? Who is ADSR Rajarhat?
Respondent number 3.
He has not received any sale certificate, my lord, kindly.
Yes, to the respondent number 3 being the additional district sub-registrar, ADSR, Newtown, to file the document, namely the certificate of sale issued to the petitioners by SBI on 6th April 2022. Is the date correct?
My lord.
6th April 2022 in book number 1, capitals, book number 1, within a period of 2 weeks from the date on which the document is received by the respondent number 3. Stop. You are appearing for which one?
State, my lord.
State. The you will hand it up. You will make over the certificate to ADSR.
My lord,
You are in possession of it.
my lord, so far I have been instructed by my lord, ADC, respondent number 3. He has given instruction. He has not received the sales certificate, my lord.
How long will you take to make over the document to him?
My lord, then I, my lord, 1 week or 2 weeks, my lord, next. There are holidays.
You are appearing for all the state respondents. Then it's an internal matter. Yes, learned counsel appearing for the state respondents is directed to make over the document to the respondent number 3 within a week from date. Stop. Next.
Lordship, I am for the petitioner, Lordship. Lordship, I am for the petitioner. Lordship, in this matter, on the last occasion, state respondent authority submitted affidavit in opposition. Lordship, thereafter submitted opposition to me. Lordship, I am praying for 1 day's time to prepare the reply, Lordship. 1 day's time. Lordship, kindly take up the matter day after tomorrow. I will.
When did you get the opposition?
29th of March 2023, Lordship. Only.
So why do you can take 1 week? Why do you want 1 day?
1 day, Lordship.
Then you will ask for more time to amend that reply.
No, Lordship. Only 1 day's time. Give
1 day's time. Very well. Yes. Learned counsel appearing for the petitioner seeks a day's time, apostrophe S, day's time to file the affidavit in reply. Stop. List this matter. When do you want the matter to be listed?
Lordship, day after tomorrow, Lordship.
Is there urgency in the matter?
Lordship, because all money deposited money of the deceased husband has been disbursed to the person, Lordship.
What to the person? Whose person?
To the person, the bank authority said this is a nominee. Thereafter, Lordship, the bank authority disbursed the amount by without disclosing any fact to the.
You are the widow.
Lordship.
And who has the money gone to?
Lordship, money according to bank, money got by the father-in-law of the petitioner, Lordship. Thereafter, Lordship, bank authority.
Father-in-law, your father-in-law.
My father-in-law.
Yes.
Father-in-law of the petitioner. Lordship, the bank authority.
Very well. Yes. List this matter. Affidavit in reply to be filed by 13th April 2023. Stop. List this matter on 17th April 2023 as prayed for. Next.
Item number 15.
15, I'm led by Mr. Srijip Chakraborty. My lord, please to take up them the day after tomorrow. We have some difficulty, my lord.
My lord, I have completed my submission regarding that order. My lord, I have completed my submission. It's regarding that order passed on 22nd December. My lord, the undertaking was given. We will not take steps until. Yes, that one, my lord, he said he'll come with bullet points, my lord, the reply. My lord, I have also handwritten some bullet points, 1 page. What I have asked them to type it. So let him, I mean, if he wants day after he came with bullet, and I will also give bullet, my lord, some points. My lord, just 1 page, just to refresh your lordship's memory. So
yes.
That,
Adjournment is sought for on behalf of counsel appearing for the petitioners. Petitioner. Stop. List this matter. Why not tomorrow?
My lord, I was requested by Mr. Chakraborty to pray for day after.
List this matter on 13th April 2023 as prayed for.
Pray for.
You hand up your note on the next day, Mr. Bose.
Yes, my lord, it's handwritten anyway. I asked them to type it. So,
Yes.
Item number 16.
At item number 16, my lord, I appear on behalf of the petitioner. Lordship might recall, my lord, this matter Lordship has heard before. Here, my lord, I have an agreement with Monjusha. And the point taken, my lord, I have a monetary claim, my lord. And I have made that claim in this writ petition. My claim is about 3,98,000.
Yes.
Now, my lord, they took this point that the writ petition is not maintainable because monetary claim cannot be entertained in a writ petition. Lordship knows, my lord, starting from 1969, 2004 ABL and the latest 2023.
Gunwant Kaur.
Gurban Kaur is the first one. ABL 2004, latest Justice Joseph judgment 2023.
Yes.
All says it can be done. Even in case of a contractual obligation, now, my lord, if the state authority has acted arbitrarily, the writ petition is not maintainable. On this point, Lordship has fixed this matter today for arguing. Now, there is a subsequent development in this matter that, my lord, I must tell your Lordship. They, my lord, have made payment to me. That was, my lord, my claim. But
No,
not
but this happened after the last hearing.
after the last hearing. Kindly seize, my lord, the two documents. They have admitted, my lord, and at the same time, they, my lord, raised an issue about the quality of the work rendered by my client. Kindly, my lord,
So, no, how much have they paid you?
my lord, they have paid me, my lord, 3,50,000. 3,50,000, my lord, something after deducting a penalty of 10%. Kindly have a look at the letter dated 3,50,000, my lord. What they have paid, my lord, directly money has been.
Which one? Which document are you referring to?
5th April 2023, letter was written on behalf of Monjusha, my lord.
Yes.
Kindly have a look at this letter, my lord.
Yes.
Second paragraph, if I may read out, Lordship would find as per the terms mentioned in the purchase order, a penalty will be imposed on non-availability of item. Thus, the Board of Directors at their meeting held on such and such date has decided to levy penalty of 10% on your outstanding dues. Your payment shall be made after deducting the above penalty. Now, my lord, they have paid me 3,54,000. Now this.
So you have got the money?
Not the entire money. I am entitled to get.
No, you have got 3.54 lakhs.
3.54. Now, my lord, the alleged deduction or the purported deduction, if I may call it, my lord, 10%. My lord, this has been done arbitrarily, and I will show you on the face of it.
Mr.
They cannot
Dave,
deduct.
you have to, have you challenged that you have to file
No,
a
my
supplementary affidavit or something?
I filed a supplementary affidavit.
Because your claim in the writ petition was for the entire outstanding amount.
Absolutely. And what they have done, my lord, and what I.
How much was your total claim?
3,97,000. And my lord, what I brought, my lord, by filing a supplementary affidavit on record is the fact that after the writ petition was filed, my lord, they, my lord, cancelled the entire contract.
Yes.
Entire contract has been cancelled without giving me an opportunity. Arbitrariness and high-handedness is on the face of it, but possibly that I cannot adjudicate, cannot pray for adjudication because my prayer is not there. For that, my lord, I would be seeking my lord's leave, my lord, so that I can.
You have not challenged the cancellation?
I could not because that had happened after the writ petition was filed.
Very well.
And the ground taken in my lord, the cancelling the contract, you filed a writ petition. Therefore, we are no longer interested in pursuing with you the business activities. Now, my lord, I invested money. I'm a sole proprietor. My lord, a proprietorship concern, my lord, small scale industry. I survive on this. How can you do it? So that's the challenge, my lord. Lordship would grant me leave. I would do it afterwards. But so far as deducting 10%, my lord, that they can't do, my lord. And in fact, they have received the entire money. This is my instruction. If Monjusha has received the money from state for the work done by me, they are supposed to pay. And kindly have a look at one document.
How does the court know that they have received the entire money?
Two things can be done, my lord. I know Lordship will be asking this question. Lordship can ask them. They are being represented by an advocate, whether they have received or not, or else Lordship can direct the state government because the amount is paid by the state to Monjusha and Monjusha in turn pays it to me. I execute the work on behalf of the Monjusha. So if they have received it, they have to pay me. And one document kindly sees.
So you supply the goods of Monjusha to some others?
To some hospitals.
Hospitals.
On behalf of Monjusha as an agent.
Yes.
Now, my lord, kindly have a look at one document. Once the purchase order. Page 15.
What does the contract say?
But there is no formal contract. The purchase order, if Lordship sees, there is a clause for deducting, my lord, penalty.
Which
Page 15, page 15. And I have supplied. This is the admitted position.
Page 15, yes.
Yes. Kindly have a look at, my lord, the last 4 lines after the purchase order. May I read it out, my lord? The supply be made strictly according to the specification, measurement, quality, and finish as per the approved samples. In case of any deduction from the payment of this corporation by so-and-so due to deviation of whatever nature of quality, size, specification, etc., or non-delivery of articles partly or fully, a penalty will be imposed on you. So there is a condition.
So you're saying that first the CMOH Nondigram will have to deduct.
Yes.
Only then they can deduct.
And
take
there is a
penalty.
condition that there has to be deviation, non-supply. I have supplied the goods, admittedly. There is delay. I accepted, I clarified, then I supplied. So these 2 conditions, my lord, are not fulfilled.
What does the letter refer to any of the conditions?
No, my lord. Kindly seize the letter, my lord.
Says non-delivery of items.
Yes, delivery has been made. On the face of it, I can show to your lordship. I handed over the documents. I have made a representation, no reply apart from 1 single letter of October 2023.
Representation against non-delivery?
No, for releasing the money. Kindly have a look at 1 document.
No, that's fine. What's your next point?
My lord, that's the point, my lord. Let them pay 3,97,000. Kindly ask them whether they have received or not. My instruction is they have. If they say no, Monjusha, if they say no, then kindly ask the state.
Malad, 3 things.
Microphone, please.
3 things, Malad.
Yes.
1, Malad, the purchase order provides that if they don't supply or if there is a failure to supply the whole, I'll be entitled to impose a penalty. Now, my learned friend showed your lordship page 15. Kindly, Malad, take page 13.
Page
13. This is my letter dated 4th January 2023.
Yes.
Malad, I say, your organization has been entrusted with the job of supplying hospital linen items at DRS Nondigram on behalf of this corporation. It appears from the vendor portal that you did not supply the orders for coir mattress, mattress covers, slipper, white purchase order number so-and-so. It was also earmarked on our purchase order and instructed you to supply within 28th October 2022 at DRS Nondigram. Challans were also generated on 21st October. But these products were not supplied by your firm within delivery date. And all these orders were cancelled by the authority, and the reputation of our corporation is also hampered for your non-performance. Now, to this, he makes a reply. Kindly take page 14.
Yes.
I, Sri Shondipon Nag, the proprietor of Joyram Enterprise, hereby comply the show cause letter from your office. There is various causes for non-supplied the 3 items. So, Malad, non-supply of items is admitted. The most relevant cause that the time was Durga Puja ceremony, so I did not be able to collect the product from market and also from any other sources. Also, I tried to make the product from factory, but due to short time and also for vacation, I could not do so. So, 2 things, Malad. 1, that there was a short supply is admitted. My show cause, the show cause that I issued to him says that as a result of this, the purchase orders that were issued by the DRS Nondigram to me were cancelled. What he now tries to take the aid of is subsequently for the items that were not supplied under the relevant purchase order, a fresh purchase order was issued by the DRS Nondigram. Because DRS Nondigram is a territory that I had allotted to him, I again asked him to make the supply, and he made the supply on the 2nd occasion. But so far as the original purchase order which was issued by DRS Nondigram to me, that it is a fact that was cancelled because he failed to supply on time. Now, Malad, to say that I could not supply due to the vacations is also not something that can be sustained, because on the date when the...
Yes, Mr. Bose, the letter at page 13 for the supplies which were cancelled, did you receive the money from the state?
Whatever was supplied, I received that.
How much?
So you did not receive the money for the shortfall?
No. Now, I have a right under the purchase order to impose a penalty. Malad, good, bad, indifferent, the matter was placed before the board of the corporation. The board of directors have decided that 10% penalty should be imposed on him and he should be debarred from further supplies for 1 year. Now, that is a decision that has been communicated to him on the 5th of April. If he wants
that is after filing of the writ petition.
After filing of the writ petition. If he wants to challenge that, Malad, he either has to amend this writ petition or has to challenge it by way of
we are not on that anymore. And counsel said, Mr. Deb said that he's not on the challenge now.
Very well.
He's on the
So-
money.
So far as after deducting 10%
So
penalty
you're
and
saying that you
TDS,
did not receive 3.97
I-
from the state?
No, I could not have received what was not supplied at that stage. So far as the
Put
later.
it on affidavit, please.
Yes, Milord.
That you have
Kindly allow me
received
to.
only 3.54 and not
Well, kindly
3.97.
allow me to put everything on affidavit by way of a report by Monday.
Very well.
And my lord, only one
Yes.
thing, my lord, Lordship.
Mr. Deb, you have got 3.54?
3.54.
Yes, accept it.
3.50.
Let me see what they have to say
Yes,
about
yes.
Not receiving
Yes, kindly
3.97.
ascertain, my lord. And one more
3.5.
thing, my lord, I must tell your
Yes.
lordship. My specific case in the writ petition, they may controvert. That amount that I am claiming is the money which you have received from the government. I have other purchase orders.
Mr. Deb, there are two admissions from your end. A, that you did not supply some items, three items.
In
B,
time.
that there was delay.
Delay. I admitted. I submitted before your lordship.
Yes.
But subsequently I supplied. And that documents are there, bunch of documents.
Very well.
Which
If
will
you have
evidence.
supplied and you don't come under the catch of the purchase order, then you will get the money.
Absolutely.
The
I'm grateful to
remainder.
your lordship.
Yes.
My lord, I have received, I'm sorry, my lord,
So-
3.5. Exact amount of what?
3.5.
350,559 is what they have received.
3.50.
3.50 and odd.
350,559.
So you get 47 lakhs more.
My lord, 47,000.
47,000.
And that is probably they deducted on account of penalty.
Very well. Yes. Learned counsel appearing for the petitioner submits that the petitioner received a sum of rupees 3.50 lakhs from Monjusha, capital M.
My lord, may I, my lord? 350,559. Exact figure.
3,50,559 from Monjusha on or after 5th April 2023. Stop. This would also appear from a letter issued by Monjusha to the petitioner on 5th April 2023. Stop. The petitioner is, however, aggrieved by the penalty imposed on the petitioner amounting to 10% of the petitioner's outstanding dues. The penalty comes to approximately rupees 47,000. Stop. The petitioner claims, according to counsel, the petitioner should get the entire amount of lakhs for the items supplied to the hospital at Nondigram. Stop. Next, there appears to be the petitioner appears to have admitted to short supplies as well as of delay in supplying the articles by way of a letter dated 9 January 2023. Stop. Next. Hence, before any further payment is directed in favor of the petitioner, the court must see the facts as presented by the state from affidavits, as presented by Monjusha on affidavits. Stop. When? On Monday? Affidavit in opposition. The affidavit must be filed by 17th April 2023. Reply within 19th?
Yes.
19th April 2023. List this matter on 21st April.
Lord, one more thing, my lord, may I, my lord, pray? State is being represented separately. State has made pay.
Yes,
If lordship direct the state.
yes,
my lord,
the
that
state,
can-
who is appearing for the state? You. The state shall also file an affidavit bringing the payment made to Monjusha on record.
Grateful to your lordship, my lord.
Next.
Item number 17.
Summary of my submissions. Now, 2-page summary. Now, Lordship, kindly hear Mr. Kapoor. You want to make right.
Why, Mr. Mitru? Why you will not make submissions?
I have gone through submissions. I have given my notes, 2-page summary of my notes. Now, here, Mr. Kapoor, my lord, for additional submissions. Lordship's already heard the facts of the case.
Mr. Kapoor, microphone, please.
I only want to draw Lordship's kind attention to page 153. Let your Lordship kindly read this simple paragraph with me, which sums up all the facts and all the issues of the case. The penultimate paragraph, or rather the last paragraph, Millet, reading, however, in the instant case. Just that.
Mr. Kapoor, just give me the hierarchy, please.
I beg your lordship
The
pardon?
hierarchy of the decision making. This is by the who has said, I agree with recommendations of the committee.
And the general manager.
Very well. So just give me the hierarchy, please.
First, Millet, there is the principal PCEE, Principal Chief Engineering Electrical Engineer, and then there's the PFA, the Principal Financial Advisor. They are the two involved, and another gentleman by the name of Mr. Das. So, but your lordship will kindly see just one paragraph with me. However, in the instant case, the delisting has been done on account of malpractice, unethical practice, and the case is sub judice. So, my lord, criminal proceedings have separately been filed. Criminal proceedings are pending. Matter is sub judice, and no decision has been taken with regard to any conviction or anything of the kind. And it is not possible for the CLW administration to decide a time frame in which the legal procedures would be completed. Therefore, considering the representation of the firm, it is decided that the delisting period, of the firm would be as under delisting so and so. And he says at the bottom, I agree with the recommendation.
So this paragraph, last paragraph, is by the committee.
It's by the committee.
Committee formed by?
Formed by the general manager.
General manager.
Yes.
So general manager is part of the committee.
General manager formed the committee and then says, I agree with the recommendation of the committee. So he didn't participate, but he gave a decision. And the committee gave a decision or decisions.
So the general manager is not the next level.
The general manager is the next level. General manager is a superior.
Very well. So you have a decision of the committee, and then you have the general manager affirming that decision.
Right.
And below the committee is who?
Below the committee, there are three officers that I told you, Lordship.
Yes.
The PCCE, that is the Principal Chief Electrical Engineer. The PFA, that is the Principal Financial Advisor. And the PCE, the PCE. So three persons constituted the committee, and they made a decision or representation or anything of the kind, and he simply endorsed it. I agree with saying, I agree with the recommendation.
How is the decision vitiated, Mr. Kapoor?
Millet, with respect, there is no reason, first of all. No reason at all. Neither in the facts of the case, neither by the hearing committee.
Yes.
Neither by the hearing committee or by the general manager. I agree with the recommendation is an unreasoned order.
Yes.
No application of mine by the general manager. I would, with respect, crystallize the issues in this very paragraph itself. It talks of malpractice and unethical practice.
Mr. Kapoor, I remember Mr. Mitra's points on the last occasion. That is, one, no reasons. Number two, that there was no opportunity of hearing given.
Lordship.
To the petitioners.
Lordship.
And there was a point made about recommendation that the committee can only recommend.
We kindly set that for the moment aside. Millet, the story begins like this. There is an FIR file by the CBI. And straight away, is looking at nothing else, we are delisted. From 6 months, we have not been allowed to participate. In fact, there was no tender. When the subject of another tender came up, then matters started afresh, and all this hearing committee, etc., was done. But the three issues are these. Your Lordship has, with respect, crystallized the three issues in Your Lordship's interim order. The three issues are, kindly just permit me, with Your Lordship's kind leave, to place Your Lordship's interim order.
Date of the order?
Millet, kindly come to this. The 1st of December, my Lord's pleasure.
Yes.
Kindly go to page 2. The petitioner challenges the impugned decision of the hearing committee on several grounds. The most important of which is the breach of principle of natural justice. The petitioner is not given any hearing before the impugned decision was taken. The hearing by the hearing committee. Impugned decision is for delisting the petitioner for 1 year and subject to further review. Then it should be pointed out, please Your Lordship, that the cause of action first arose from a notice of 12th March. I'll just go to that. The next paragraph. The petitioner approached the appellate authority under procedural rules. The petitioner thereafter approached Punjab and Haryana High Court. The appellate court thereafter dismissed the appeal, sent it back to the court. The High Court proceeded to issue an order of 27th April directing that the matter should be heard afresh and the petitioner should be given an opportunity to present its case. The hearing committee thereafter proceeded to pass the impugned decision on 6th of May. The delay in the interregnum has been satisfactorily explained. The other point of challenge is more striking. With respect, it is apparent from the record that one of the authorities responsible for taking initial decision, delisting the name of the petitioner, was a member of the committee and passed the later decision. Even without hearing the respondents, this fact raises a presumption of bias. The grievance, may I then go to the next? The third flag is the handwritten endorsement of the general manager. Response number 2, the hearing committee simply stating that the general manager agrees with the recommendation of the hearing committee. Committee recommended delist. The facts taken together persuade this court, please Your Lordship, to grant the interim order. Now, these are the 3 points, and they are summarized with respect to Your Lordship's own order. And I am respectfully reiterating that it is borne out by this paragraph at page 153 that there is no hearing, and there is a gentleman in his own cause. But
the gentleman is one of the 3 committee.
One of the 3 members of the committee.
Right.
He was the deputy CC.
And which document would show that he was one of the
from page 131, please, Your Lordship.
Read with 169.
And another read with page 169.
So the same gentleman was there at page 153.
Lordship.
Yes.
This was issued with the approval of competent authority.
Competent
authorities.
Yes.
Lordship kindly sees page 169 also and page 153, 131 also.
Very well.
They're
Yes.
read together, they make the point. But Millet, the issue is this. Millet, can I respectfully draw Lordship kind attention to a document handed over without conviction, without any allegation? I mean, there is a charge sheet made without conviction. There cannot be any. There cannot be any. The rules say that there cannot be any delisting at all. Yeah.
Which are the rules?
I've just given you. I've handed up on the last occasion an office memorandum. और एक है आरेख दिए दे. Please, your lordship.
Yes.
Kindly see subject guidelines for debarment. Kindly go to a bidder shall be debarred if he has been convicted of an offense, not accused. So a mere accusation is nothing at all. And this should be an end to the issue at all altogether. A bidder shall be debarred if he has been convicted of an offense. A charge sheet possibly has now been filed. Earlier, FIR is pending from 9th of February. The charge sheet has been filed, but no action has been taken. And therefore, there is no conviction. If there is no conviction, there can be no delisting. And apart from the fact that the general principles that are very well known to the lordship, that blacklisting must leads to
Civil consequences.
Civil consequences. So these principles all taken together are all attracted in this very case. And this matter in this paragraph, he says it is sub judice.
What is
How
sub
long it will
judice?
take?
No, what is sub judice?
The CBI trial.
It's in a CBI court.
In the CBI court. And interestingly, may I respectfully add one point to your lordship, for your lordship. The company is not accused as a party. Two directors. No,
who are before the court? Individuals?
No,
Or
the company is before the court.
Yes.
The company has been debarred. The company has been delisted.
Yes. And the proceedings are against?
And the proceedings, those are against two directors. Now, some competitor has put somebody issued an anonymous letter to the CBI. CBI has started a case, and CBI has not charged me, the company. I'm not accused. There can be no conviction at all. So, your lordship, kindly, I'm able to reinforce the office amendment by saying that there is no prospect of conviction at all. No
Now,
prospect.
you're saying that a charge sheet has been issued.
Only charge sheet has been issued, and I'm not convicted. I'm not been convicted at all, and I cannot be convicted because I'm not accused. The company is not accused. A company, Eliande, should be made a party in CBI proceedings wherever they are, and then the matter can. So, it is all. Completely lacking in rationality. The matter is sub judice. There can be no conviction. Even then, I am being pursued with delisting or blacklisting, which, as your lordship has appropriately been pleased to observe, would lead to civil consequences and result in the entailment of the closure of my factory.
Kapoor, what is the final relief? Which prayer are you pressing for now?
I'm asking for D, I think.
G.
Please, your lordship.
No, not G. G is interim relief.
Kindly, please, your lordship. B, please, your lordship. All the issue in the real social RI to all the appellate order should be set aside.
No, so that is B.
B and it's B. B would. The hearing, all three should be set aside.
So you have placed the last one. Which are the other two?
The other two, 21st of May, 28th of May, and 12th of May. 12th of May.
Yes, so that's 148, 147, and 153.
Yes, lordship. All three of them. The hearing committee.
Yes, 147, 148,
147, 148, 153.
Yes.
And the answer is, that the CBI has not been made a party. Only answer. The CBI has not been made a party. So there should be there's non-joined of parties, and the writ petition should be dismissed on this ground. No answer at all to the merits of the controversy at all.
Yes.
Please, your lordship.
My lord, if your lordship kindly comes to my lord, page 16, my lord, paragraph 4, my lord, of the 16, my lord.
Yes.
Paragraph 4, my lord, page 16, my lord. This paragraph, my lord, in the affidavit has been stated to be true to the knowledge, my lord. My lord, it categorically says that the contractual and statutory obligations
Yes.
amongst the petitioner, company, and respondents are governed or regulated by virtue of procedure for vendor development for purchased products used in electric locomotives dated 7/1/2022. The photocopy is annexed herewith for
Paragraph
perusal.
4 is at page 14. Where are you placing from?
From the writ petition, my lord. It's at page 16.
Paragraph 4
Paragraph
starts
4
from page
starts
14.
from page 14, my lord. I apologize.
Yes.
At paragraph, the relevant portion is at page 16.
Yes.
This paragraph, they say, my lord, that it is true to my law, true to their knowledge, my lord.
Yes.
Now, my lord, my learned senior friends has relied upon the office memorandum, my lord, of 2021.
Yes.
And in the writ petition, my lord, my learned friends, senior friends have relied upon, my lord, this document, this particular document, my lord, this vendor procedure for vendor development, my lord.
Yes.
This is of 7/1/2022, my lord. Now, my lord, it starts from, my lord, page 154 of the writ petition, my lord.
Yes.
My lord, kindly see, this is procedure for vendor development for purchased products used in electric locomotives, effective date 7/1/2022 in the writ petition. And my lord, the relevant portion I beg to place before your lordship, it's at page 167, my lord. If your lordship kindly comes to page 167.
Yes.
My lord, at page 167, my lord, condition of delisting, it's at paragraph 6.4 towards the end of the page, my lord.
Yes.
And paragraph 6.4.2, my lord, specifically 6.4.2b, it says malpractice.
Yes.
Whenever any malpractice or unethical practice adopted by the firm comes to the notice of deputy HOD or railways, the case for delisting of firm's name from the approved list may be initiated.
Yes.
My lord, I beg to take your lordship now to paragraph, page 169, paragraph 6.4.3.
Yes.
My lord, it says that delisting shall be considered after communicating appropriate technical reasons with reasonable notice period, minimum 1 month to the firms for compliance. In cases where firms are not in a position to overcome the shortcomings in a reasonable given time, it will be advised to CLW for delisting. I humbly submit, my lord, admittedly, no notice for delisting was given, my lord. And there was no bar in giving the notice to the petitioner company. And that, in my humble submission,
No bar to giving the notice means what?
In giving the show cause notice, my lord.
No, you're saying that 6.4.3 contemplates 1 month's notice.
My lord.
Minimum 1
1
month.
month's notice, my lord.
So even without giving that notice, you can proceed. Is that what you're saying?
That is what I beg to state before your lordship. As an officer of the court, I must say that it was certainly a duty on the part of the respondents to have issued a so-called notice. That is what the all the decisions also say, my lord. But since we are bound, my lord, the petitioners and the respondents, we are bound, my lord, by this vendor purchase agreement, my lord. Now, in this, my lord, if your lordship kindly appreciates, my lord, 6.4.3, my lord, says that the reasonable that the 1 month notice is to be given.
Yes.
And the reason for giving the 1 month notice, my lord, that has also been stated over there. So for my understanding, my lord, that if there is a debarment or delisting only for the purpose of technical reasons, so for making good the technical reasons, that was absolutely necessary. Because the reason for, as is stipulated in 6.4.3, my lord, at the cost of repetition, I read, my lord, in cases where firms...
6.4.3 is very simple. It says that you have to give minimum 1 month's notice to the vendor,
my
or
lord,
whoever, to rectify.
To rectify, my
Basically,
lord.
to give that person or that entity a chance.
My lord.
You're saying that this was not done, admittedly.
Not done, my lord.
So do the rules provide for an escape route for you, that this notice period can be waived, or you can, under certain
Does not
circumstances?
specifically say, my lord.
Very
Only,
well.
my
So
lord,
then,
I humbly beg to state before your lordship, my lord.
So then 6.4.3 was not complied with.
It was not complied, my lord, because only of the reason, my lord, that there was no technical, I humbly submit before your lordship that there was no technical problem so far has arisen so far as the dealings on the part of the petitioner. The point was, my lord, absolutely of malpractice. And my lord, it was the CBI had already arrested to the two directors, and they had arrested an officer of the Chittaranjan Locomotive Works also. That has been placed in the writ petition only, my lord, as part of the reasoned order in the appellate authority.
So you're saying that, let us just, I like going by the rules and the law, please. Facts will come later. You're saying that 6.4.3 was waived in this, or was not complied with, because this was not a technical shortcoming.
My lord.
Do the rules provide for that departure, or for that other circumstance?
Does not specifically, my lord. Only I humbly submit it from a plain reading of this, my lord. My only submission is that, my lord, in this regard, is that, my lord, that there was no, it was done, my lord, only because it's malpractice. Whenever the malpractice comes to the notice of the HOD or railways, that can be initiated, and there was no reason, there was no
So you're relying on 6.4.2b.
my lord, and 6.4.3.
Yes.
And there was no scope for my lord, there was no scope for the petitioner to make good the shortcomings, my lord. On this point, my lord, I beg to submit.
No, but 6.4.2b says that delisting can be initiated.
My
That's
lord.
what B says.
That's
can
what
be
B says.
initiated, but in this case, you took a decision to delist.
My lord.
Yes.
This
very
is
well.
only I to be candid, my lord, on this point, I have no further submission. Now, my lord, if your lordship kindly sees the appeal before the appellate authority, my lord, I
Yes.
humbly say, my lord, that there was no whispering so far as the non-compliance of the issuance of 6.4.3 is concerned. There is no whispering, my lord.
What do you mean by no whispering? What no whispering?
Nothing was stated, my lord, in the appeal before the appellate authority.
Which page? Which page?
My lord, I kindly bear with me, my lord. My lord,
153.
My lord, kindly bear with me. For a moment, my lord, kindly bear with me. Appeal
153.
No, my lord, this is the order passed in appeal, my lord. I beg to take your lordship.
Just tell me,
to
give me the
appeal.
page, please.
I give you lordship, my lord. It starts from page 137, my lord.
Yes.
Page 137, my lord.
Yes.
Well, this is an elaborate appeal, my lord, but there is nothing has been that point has not been taken up in the before the appellate forum, that we had not complied with 6.4.3.
Very well. Yes.
And now, my lord, and my lord, if your lordship now come as to that members of the hearing committee, my lord.
Yes.
If you on that point, my lord, if your lordship kindly comes to page 131, my lord.
Yes. Yes.
This order of delisting, my lord, has been issued by the Deputy Chief Electrical Engineer. Admittedly, that is issued with approval of competent authority. And admittedly, the competent authority is the Principal Chief Electrical Engineer,
yes.
who is part of the hearing committee. Now, my lord, I beg to take your lordship to page 174 of the writ petition, my lord, towards the end of the page, my lord.
Yes.
Page 174, my lord, paragraph 7.8, my lord, deals with the provision of appeal for vendor delisted by CLW. My lord, it says the appeal can be made in case of delisting only and within 30 days of issue of letter for delisting. Whenever the vendor is not satisfied with the action taken, he may appeal to GM, who after seeing the merit of the case may decide or dispose of or refer the case to the committee consisting of PCC, Principal Chief Electrical Engineer, PFA, Principal Financial Advisor.
So it is the same committee as 153.
No, my lord, in 153, my lord, yes, my lord, this is the same committee. I apologize. And PCMM, my lord, that is the Chief Material Manager, Principal Chief Material Manager. The committee gives their observation and recommendation. The committee will verify that the case has been dealt with as per the procedure or otherwise. The same will be put up to GM for disposal of the appeal. My very short submission in this regard, my lord, since both of us admittedly are bound by this vendor purchase agreement, my lord, it has been very categorically stated over there. The members of the committee should be the PCEE principal.
Give me the rule which gives the hierarchy of the decision-making process, please. The hierarchy of the decision-making process.
This is, my lord, part of the writ petition only.
So you must have studied the rules. Just give me the rule which gives the hierarchy.
My lord, it was communicated. It was done by the deputy chief electric.
There must be a rule to that effect. Please show it to me. That the first decision will be taken by who, then which is the committee. Just show it to me, please. There must be. It must be in the rules, or this procedure, whatever it is called. That delisting, when you delist a person, there has to be three levels of adjudication. Very well. And your next point?
And that is that is the last point I beg to place before lordship, my lord, that the PCC, it was known to us, both of us, my lord, that the PCC will be part of the committee, my lord. So at this stage, my lord, with all humility, I submit, my lord, possibly this submission cannot be, I humbly submit, my lord, that at this point, maybe it's not possible to take this point, my lord, that the PCEE, my lord.
Not possible to take which point? Bias.
My lord, that.
Why?
My lord, because we are bound by this particular vendor
So I'm
purchase
asking
agreement.
you, that's why I'm asking you, show me the hierarchy. That's all. That for only to deal with that point of bias. That's why I'm asking you. When will you get ready and come back?
My lord, only on this point, my lord, I have to, I beg,
Whichever point you need to get ready. When will you come back?
My lord, on Monday, if your lordship.
Because you should have this. This should be in your memory.
My lord,
I
I apologize.
I don't know why you wait for the court to ask. Yes. Heard learned counsel appearing for the petitioner. Stop. A learned counsel appearing for the respondent, Chittaranjan Locomotive Works, has started her submissions. Stop. Lists this matter on 17th April 2023 for counsel to conclude. Stop.
Deeply obliged, my lord.
If you're saying that the bias point cannot be taken,
My
that
lord.
both of you are bound or whatever, However, you may want to wish to develop that point.
My lord,
Show me from the agreement.
I will, my lord. I'm deeply obliged, my lord.
একটা line লিখে করো তো petitioner. Council places the office memorandum, an office memorandum, capitals, issued by the dated 2nd November 2021, issued by the Ministry of Finance, Procurement Policy Division. Stopped.
Deeply obliged, my lord.
It was a petitioner council. Next.
Please, Lord.
Item number 18.
Lord, on last occasion, I appear on behalf of the private respondents, my lord.
Yes.
Last occasion, your lordship has asked me to file a report annexing those relevant papers which I relied upon. I have already filed the report and also supplied a copy of the affidavit, my lord. Lord,
Yes.
the allegations, my lord.
I can't hear you, microphone.
My lord,
Lord,
Yes.
may I place it first, my lord? No, I'm for the petitioner, my lord.
You have received the report.
Yes,
You wanted
the
time.
disclosing
That's
the
right.
documents, my
Yes.
lord, because this was given at the midnight almost.
Yes.
Now, my lord, there are two, my lord, documents, my lord, page 99 and 100. These we have questioned along with the other ancillary prayers we have prayed for, made. Lord, kindly consider this page 99. This has been issued by the Ideal Villas Apartment Owners Association.
Yes.
All the Ideal Villa apartment notified that 3 years tenure of the existing board of managers
Yes.
of the Ideal Villas Apartment Owners Association will be over by March 31st, 23, and 42 board of managers to be elected by May 31st, 2023, as per the provisions of the West Bengal Apartment Ownership Act 1972, read with the rules 2022. Therefore, for fair and timely election, the executive members suggest to invoke the provisions of section 16B of the Act of 1972 and get appointed administrator for the purpose. However, in case any villa owner has any better suggestion for holding fair or timely election, may please offer. Now, my lord, before this, my lord, placing this further on this basis, making further submissions, I tell you, lordship, this owners association registration has been questioned by us, and this honorable court directed to consider. This has not yet been
On the
considered.
basis of one document.
Only one document.
Saying that it's forged.
Forged. And other
Yes.
things I tell you, lordships, kindly consider the next page. So, my lord, by way of the document at page 99, they suggest to invoke the provisions.
Yes.
So this is not the, my lord, really the cause of action. Then get appointed and administrator. Kindly see the language, your lordships. Get appointed and administrator. That means they want appointment of administrator. Now kindly see the next notification, my lord.
So you are the existing board of managers.
I am the existing, my lord, association, my lord, formed under the Companies Act since beginning of this, my lord, property.
Since when?
Since 2012.
Very well. Yes.
And this apartment ownership association has come into picture, my lord, in 2019.
Yes.
2020. Now kindly have a look at the next, my lord. Notification, 16th March 2023. This has been issued also by the association. Now, my lord, please refer.
Which association? You or them?
They, the private respondent.
Yes. Yes.
My lord, my lord, the defaulter list in pursuance of the provisions of such and such. Now, my lord, pause here for a moment. I just, for your information, I tell you, losses, there are 125 villas. So there are 125 members. My lord, so far the members, my lord, except 5 or 6,
Yes.
all of them are with the petitions. None of them, my lord, contributing to this association.
You mean the villas or the members?
Villas or members, your losses, my lord, it's who are the villa owners.
Yes.
My lord, all are with us. I have annexed the documents, and the defaulter list is almost in respect of 115
Yes.
out of 125. Now, clause 1, your losses kindly considered.
So
Please-
defaulter as in payment of charges?
Non-payment of charges to the association.
Very well.
Now, clause 1, your lordship, please refer to such and such notification is to reiterate that as per the provisions of the Act of 1972, the next election is due by 31st May 2023. Now, the earlier notification says, your lordships, by 31st March.
Yes.
And now they say, my lord, 31st May.
Yes.
As no suggestion or proposal received by our association till date, it has been decided to invoke the provisions of 16B and complete all the formalities as required under the law. Accordingly, one of the requirement is being fulfilled by publication of this defaulter. My lord, I will take
What is publication of this defaulter?
defaulter means my lord, defaulter list.
Publication of this defaulter. says.
That's my lord, your losses, they have used the language.
Very well. Yes.
My lord, that should be according to me defaulted list.
Yes.
Now here your losses, my lord, kindly take up note. It has been decided to invoke. My lord, therefore the association is invoking section 16B. I will take your losses to section B just my lord after placing this.
Yes.
Then paragraph 2. Therefore, in the Ideal Villas Apartment Ownership Association is obligated under the Act and the rules to publish a defaulter list and complete all other formalities to prepare grounds for the fair election to constitute a fresh 42-member board of managers. Under the then paragraph 3, under the provisions of the Act of 1972 and bylaws 2022, pre-amended version, it was obligatory on the part of the property owners to make their monthly maintenance charges at their own. In other words, issuance of invoice for every month is not mandatory. However, demand by some of the villa owners, Ideal Villa owners have issued invoice to certain.
What is this Roman 4 every time? Which
Well,
is being
that's
used?
my lord, Ideal Villa Apartment Owners Association. In short, they have written like this.
4. Roman
I'm not IV.
AOA.
IV.
IV.
Very
This
well.
is,
Yes.
they have typed like this, it's Roman 4.
Yes.
To certain section of property owners. Then your losses in compliance with the provisions of the Act, the association commenced operation since January 1st, 2021, as notified in the notification dated such and such of 2020, provided all necessary maintenance services to regular monthly maintenance contributors. In order not to disqualify any of the villa owners under clause 12 of the bylaws from voting and contesting election for the position of managers on the board of association, hereby an opportunity is given to all the defaulter owners to clear their dues as shown in the table below against the villa members within 15 days. Now here your losses, kindly table your losses, kindly consider total due months, total recoverable amount up to 31st March 2023, total paid settled, total recoverable. Your lordships will find except 8 or 9, all are defaulted. Those who have been in the from the right hand column second, they have paid certain amounts, but rest of them have not. Then your losses kindly consider page 105, continuation of this.
Yes.
Now your losses will find, see, my lord, the villa, clause 7, the villa owners are requested to pay their due amount in the bank's account as detailed below. Then clause 8, in case any villa owner fails to clear their dues by March 31st, 2023, penal provisions will be invoked against him or her. Now your losses, thereby your losses, my lord, by this notice.
What are the penal provisions, Mr. Shannan?
The penal provisions, as I your losses find, my lord, that submit, my lord, if they do not your losses, they can take action under the law. They will be without, my lord, that's the penal provision clause 16A.
No, what kind of action?
My lord, I do not find any action they can take.
I'm asking you under the law, what action can they take?
My lord, they can at best take that I'm not only the member, they can stop all of my facilities.
That the act provides for all that?
My lord, that's to a certain extent provides. But Act is not clear on that also.
Yes.
Now your losses kindly consider section.
So then why are you afraid of the penal provisions?
No, my lord, I'm not on that.
If there are no penal provisions under the act, then-
my lord, everyone, my lord, wants to live peacefully. I have bought the property.
So if you say that the act does not provide for any penal provisions, then what?
Lord,
what is the
penal
problem?
provisions, I tell you, there are prosecutions under the Act. there are certain provisions. But your lordship, I want to live peacefully. There must be a proper
Want
association.
to live peacefully in a villa.
Of course, in a villa. They have purchased this property. Kindly consider section 16B. Your lordship, act now.
So you want to live in a villa and you don't want to live in a house. That is what you're
No,
scared
I'm
of.
not. I'm not so. What should I?
No, this property only has villas.
This only has
No,
villas.
that-
I have not been there.
No,
I
no,
don't know.
no
My
apartments,
learned
no
friend
houses.
probably will
nothing.
be able to tell your lordships.
Only villas.
Villas.
Only villas. You get what you deserve. Yes,
I deserve. Heart I have.
yes.
Kindly see section 16B. Whether these provisions can be invoked by the association.
Yes.
Subsection 1. If the association of apartment owners having right to be exercised by the manager or the board of managers fails to perform its functions under this act or the bylaws made thereunder, the competent authority may give it to such directions as the authority considers it. So therefore, my lord, in case of failure to carry out the provisions of the act by the association, my lord, the competent authority can take action.
So has that stage come as yet?
My lord, not, but they are invoking this section, the entire.
Yeah, they have threatened to invoke.
My lord, your lordships kindly.
If they do, then the competent authority.
My lord,
can
I
take
kindly
steps.
the language your lordships clause 3. I just retired at page 100.
Yes.
Kindly will look at your lordships. 2, they have published the defaulter list, and then under the provisions of the act, it was obligatory on their part to make their monthly installment. In otherwise, sorry, my lord, the clause 1, para 1, the last 3 lines. It has been decided to invoke the provisions.
Yes.
So they have decided, they have invoked. Now kindly see subsection 2 of the act, section 16B.
Yes. So
If the-
what is the action you're trying to save? You're trying to prevent?
My lord, I am wanting your lordships.
You want to stay on,
Kindly-
you want to stay on the board?
No, I'm not stay on the board. My lord, we are not in the board right now.
Then
We
what
are
are
not.
you?
My lord, I am in the, my lord, the companies under the my lord, association registered under the.
No. Who are you? You're the association.
I am the association, I'm the secretary and all other members.
Very well. And you're not the board of managers.
My lord, this is the managers in respect of association registered under this act. We are not registered under this act. The petitioners before your lordships and association of the villas my lord, registered under the Companies Act.
You're not registered under 1972 Act.
No, my lord, we are questioning the very registration because this was done, I tell your lordships, only upon the completion certificate.
No, but you're supposed to be governed by the 1972 Act.
Well, I tell your lordships that I want to take the provisions of the act. I am supposed to be governed.
Yes.
But only upon the completion certificate is issued, not before that.
Completion certificate by who?
By the Pradhan, the authority, either Panchayat or municipality or the corporation, as the case may be.
Pradhan, 1972 Act says that.
Yes, your lordship.
After amendment.
My lord, no, don't, my lord, I'm taking to your lordships today. But kindly have a look at the rules, 1974.
I thought Pradhan and all that has gone.
No, my lord, completion, this is within the Panchayat jurisdiction.
Yes.
The Pradhan is the, Panchayat is the authority to issue completion certificate.
Yes.
Panchayat is the authority to issue. Had it been in the municipal area, my lord, the municipal.
This is where? This place?
My lord, New Town, Rajarhat. Most of the area is still under the Panchayat.
Oh, so New Town is under Panchayat.
Certain portion still under the Panchayat.
Mr. Shanal, are you sure about that?
Yes, your lordship. See, Mamungata Gam Panchayat. We have made them parties.
Very well. Yes.
But kindly have a look at the rules, 1974.
Yes.
Rules 2A. The sole owner or all the owners or majority of the owners of the every property.
Which rules are you referring to?
The West Bengal Apartment Ownership Rules 1974.
Yes. 2A says the act means the West Bengal Apartment Ownership Act 1972. Rule 2A.
2 is definition, matlab 2 capital A.
Yes,
2
Yes.
capital A losses. Got it, your losses?
yes.
Now kindly see. The sole owner or all the owners or majority of the owners of every property shall submit his or their property within 3 years from the date of completion certificate issued by the competent authority. Similar period of limitation commences from the date
This
of
is
issue of the
submission of Form A.
Matlab,
This is
Form A.
submission.
Form is
A.
the for registration. Form A is for registration. Now I take your losses to the next provisions. Lord, kindly come to provision. The manner.
Mr. Shanal, specious case. What is the relief you want?
Lord, I really
You want to stall the elections?
no,
No.
no
You want the elections?
election.
Then what is it that you want?
One, the proper registration.
Of who?
Registration of the association.
Your association?
The apartment registration of the association under the Apartment Ownership Act.
You are the association before the court.
This is not been properly registered. This has been got fraudulently without the completion certificate.
My lord, may I?
So you're saying your association has got a fraud?
My lord, I tell you, losses. This is not the thing, your losses. My lord, the association.
You said fraudulent registration. Whose fraudulent registration? You have been fraudulently registered.
I tell you, sir, not me. My lord, the association has been fraudulently registered. My lord, some of the
Association is the petitioner. You are representing the petitioner.
no, my lord, this is the association representing by the petitioners who are registered on the Companies Act.
Mr. Shanal, I'm dismissing the writ petition.
My lord, kindly consider this, your lordship. My lord, this is the association
I'm
also.
dismissing it with reasons.
My lord, kindly allow me to place it, your lordships. I think I can, my lord, convince your lordships. My lord, this is
Absolutely not. I've understood now what you want.
my lord, I'm not. I want association registration, but with proper document.
Show me the prayers, please. Show me the prayers.
31 minutes.
Which prayer?
Prayer, my lord, your lordships kindly consider. Prayer B.
Not to give effect
That's your lordship.
to the 28th February, which calls for elections.
My lord, this not calls for election.
Which page? Show me.
My lord, kindly have a look at this. Page 99 and 100. This is the defaulter list.
Very well. You don't want to be declared as defaulter.
No, because 115 persons are paying to the petitioner association. They're still paying. They are maintaining.
Provided the petitioner before the court is properly registered under the 1972 Act.
I tell your lordships here.
That is what the petitioner must show. Why would the members or whoever the residents are of that complex give to the petitioners if the petitioners don't have a valid registration? That is why they're giving to somebody else.
I tell you, lordships, my lord, so long the registration is not properly made under the Act, the Act provisions of the Act cannot be applied. Am I clear to your lordships?
No, you're not clear.
My lord,
Please show me the law provision. Please, first,
law.
under the 1972 Act.
Right.
Microphone, please.
Yes. My lord, kindly have a look at first section 2H. My lord, section section 3H, small h. Declaration first. Declaration means the instrument by which the
Yes.
property is submitted to the provisions of this Act as hereinafter provided. Then your lordships, kindly K, property, comprises the land, the building, the common areas and facilities. And in case of complexes having different types of apartments meant for selling to people of different income groups, property shall mean the land, building, the common areas.
Mr. Shanal, just show me one thing. That for an association of any property complex, you don't have to be registered under the 1972 Act. Just show me that from the statute. Show me a window that you are not required to be registered under the 1972 Act. And that Companies Act registration will suffice, will do.
No, my lord, I'm not. I'm
Then-
not saying that. I'm saying that your lord.
Shanal, first and foremost, you must have a locus to approach the writ petition for relief. even if I decide to hold that the writ petition is maintainable, it's different from entertaining the writ petition and granting that relief. Second, you have to show that you have a case for grant of relief. You are not even registered under the 1972 Act. You are saying that you are registered under the Companies Act. So show me from the 1972 Act that you can exercise any of the powers of an association under the 1972 Act without being governed by the provisions of the 1972 Act. That's the only issue.
This answer is that unless the registration is properly made under the Act cannot be applied to any property.
Show me the section.
That's Act has to be read with the rules. Act only says declaration and registration.
Show me, there must be a section you're relying on.
Yes, your lordship.
That if the registration
Then
is
your
not
lordship
properly
kindly
made.
see section 10 and 10A. But I have to proceed with all the provisions, your lordships. Section 10
Mr.
and 10.
Shandal, you file a note. You file a note, I will read your note.
My lord, may I indicate, my lord?
Yes.
But in a piecemeal, I have to place his affidavit also.
You file a note. Then
Kindly
we will
allow
see.
me to place his affidavit. Otherwise, it will be
First, the note on the law. Mr. Shandal, the only thing I'm interested in is in the law, not on affidavits, pleadings, nothing. Nothing
My learned
matters.
friend cannot, my lord, I am taking your
First, the law. That's the only thing.
But I'm taking to the law your losses right now.
File a note. Because you're searching for the sections. File a
No,
note.
section, no, my lord, one by one, I will be placing it, your losses.
Just show me that one section, Mr. Shandal, which says that until whatever you're saying, I'm not with you, but I will give you that hearing, that until and unless you are properly registered under the 1972 Act, you cannot be called an association. Show me that.
My lord, that's, my lord, your lordship has to derive from the provisions.
No, I will.
Your
I'm not
lordship
with
has,
you
my lord,
there.
that should be the
File a note.
interpretation.
File a note.
My lord,
Yes.
may I indicate, my lord? There are two sets of
Microphone.
there are two sets of associations. One is belongs to Mr. Shandal's client, which was registered
There are two sets of associations now.
right now, my lord.
Very well. Yes.
One is registered under section 25 of the Companies Act, which Mr. Shandal is representing, and the secretary is also a party. Another set of association is not even a party to the writ proceeding. The secretary, the treasurer, and the president in the individual capacity have been named in the writ petition as the private respondents. Secondly, what Mr. Shandal is relying.
How can the building be governed by two associations?
My lord, that's what I'm telling, my lord.
Yes.
Initially, when this section 25, the association under section 25 was formed, that is at the behest of the promoters.
Yes.
At that point of time, no effective steps were taken by the members of the association, so this act, association under 72 Act was never formed at that point of time. Subsequently, initiations have been taken at the behest of my clients and several other members of the association, and thereafter 2019 or 2020, my lord, this association under the 72 Act was formed. But that even after this association as 72 was formed, then also this association was never been set aside or struck off, and they went allegation that the association has not been properly registered, because this has been registered.
Which association?
My association under the 72 Act has been not been properly registered on the pretext that I have applied for the registration of my association based on a completion certificate issued by a panchayat authority. My lord, on earlier occasion, I have shown a document, my lord, was the necessity of supplying a completion certificate by the panchayat authority was not there prior to 2022. Only
That's the issue to be considered.
That was pre-amendment.
That was pre-amendment. When my
Shandal, first, before attacking the others, you have to show that you have a right.
Well, that's I'm showing. I mean, I can right now.
File a note with regard to the legal provisions. Yes.
Prior to 2022, there was no mandate so far as completion certificate issued by panchayat was concerned.
Yes.
That only said completion certificate. While on basis of the requirements, I applied before the concerned authority for registration of my association. When this writ petition was filed, even my clients, being 7 and 9 respondent herein, was also shocked. And after that, they went before a RTI, made an RTI application. In the RTI application, we have specifically pleaded what are the documents relied upon by my clients for the purpose of registration of the association. My lord, that forms part in my affidavit which I have filed. My lord, from there are 4 documents. The completion certificate which this present, the association under the 72 Act have relied upon, that is the completion certificate given by the consultant, the architecture concern, and that is not the completion certificate, what they have relied upon, issued by the Gram Panchayat authority. If your lordship apparently see, this is a replica of the same thing apart from the letterhead. That someone must have forged the document and put it under the letterhead of the Gram Panchayat. Because, my lord, once again, I am repeating it.
No, I've understood. Next point.
My lord, next is, upon further inquiry, the members of the association initially deputed one lawyer to carry out the entire exercise for the purpose of registration of the association. Upon inquiry, we further inquired before the concerned advocate. The concerned advocate wrote a letter addressing to the competent authority that the alleged certificate issued by the Gram Panchayat authority was never being handed over at the instance of my client to that advocate.
Very well. Those are facts. On the law?
My lord, 10A, my lord, what Mr. Shanal was relying upon.
Very well. Mr. Chatterjee?
No, my lord, page 100, your lordship has seen, my lord, Indus Valley Apartment Owners Own Association. Now, the petitioner says the formation of this very association is wrong because this association has been formed on the basis of a completion certificate, which is forged according to the petitioner. On the earlier occasion, my lord, I had some, my lord will consider two things. Today, my lord, why this 16 March 2023 is the trigger. If my learned friend, the petitioner, were aggrieved by the very registration of this association, as it appears in page 100, he could have challenged the registration. He has not challenged the registration. He has only approached the court after this notification dated 16 March 2023, whereby an election has been declared.
Yes.
No, my lord, today, my lord, he is alleging the Gram Panchayat has issued a certificate to him, alleging that this completion certificate is forged. The writ court subject to correction, my lord, must not go into the forgery and details like that. Those, my lord.
No, that is something which will have to be decided.
Appropriate civil court.
Mr. Shanal, you file a note.
Facts are totally wrong.
I will discount whatever I have heard from them. Absolutely. You file a note on the legal provisions. All right. I have forgotten already what they have said. You file a note on the legal provisions with regard to your locus. Understood? Yes. No further.
The concerned certificate was also issued by their
Yes. Learned counsel appearing for the petitioners has made his submissions, has started his submissions on the legal position. Stop. According to the, it is the admitted position that the petitioners were registered as an association under the provisions of the Companies Act, 19. Which one? 56 or
56.
1956. Whereas there is a rival association, which has not been made a party to the writ petition, which has been registered under the provisions of the capital, the West Bengal Apartment Ownership Act, 1972. Stop. The petitioners say that the rival association, of who some of the members have been made party respondents, has not been, it does not enjoy a valid registration. Stop. The reason for this is is a certificate which has allegedly been obtained by fraud. Stop. Next, however, this court is of the view that the petitioners must first satisfy that the petitioners have a valid registration under the, that the petitioners are authorized to act in the capacity of an association and exercise certain powers under the 1972 Act. Stop. Next, learned counsel appearing for the petitioners is requested to file a short points on the returnable date, which is
Any day convenient to lawsuit, civil lawsuit, can take it to. Only, may I make one submission? The issue your lawsuit has formulated.
I have not formulated any issue.
I am not exercising any power under the 1972 Act.
Very well. When do you want to come back?
But tomorrow I can come back.
Very well.
এক সেকেন্ডের নোটস এক্ষুনি বসে তৈরি করবো বেশি আছে দুটোই তো প্রভিশনস মাথার
On, are you sure you have two in your favor or none?
my lord I can say my lord
Very well.
my lord I have the provisions you
Very
also
well.
right.
List this matter on 18th April 2023. Stop.
We are grateful to that.
Next.
It's difficult to my lord would you also say any other day convenient to all of my learned friends other
Tell
than
me, give me a date, please.
17
17th. As prayed for. Next.
Item number 19.
My lord, I'm appearing for the writ petitioners in this matter. Lordship, my lord, the last.
Microphone,
order
please.
Time now. Will I
Microphone, please.
Shall I hand over the order that was passed on the last day, my lord, 6th of February?
No, I have it here.
My lord, I am for the state respondent, my lord, led by Mr. Sushovan Sengupta. My lord, earlier there was a direction to file written notes of argument. My lord, has been yet been seeking for 2 weeks adjournment.
My lord,
but I am for the private the added respondents we have
You continue to be protected, Miss Mukherjee.
my lord,
Microphone, please.
my lord, they have been asked to hand over these documents for the last months. Lordship, kindly hear me and protect me.
You are already protected.
My lord, I am protected by an interim order, my lord, but the magistrate's order was for eviction. If it is my land, I have to be protected.
No, but you have been protected from eviction, isn't it?
No, my lord. My lord,
Show me the interim order, please.
my lord, I'll show you the interim order. And my lord, if we are not able to produce these documents, which my lord has been.
15th November 2022 of
Where is the direction for production, Mr. Shannal? Which order?
15th November 2022 first order of your lordship.
No, where is the direction for production of documents?
Amakote diye din.
My lord, production of documents your lordships
Very
that's the
well.
order,
Yes,
15th
by an order dated 6 February 2023, comma, the state was to indicate its points and also to produce documents in support of the contention that the land vested in the that the land vested absolutely in the state after invocation of section 4 within brackets 2 of the 1948 Act. Stop. Next, learned counsel appearing for the state seeks a fortnight's time to produce the documents directed by the order, by the last order. Stop. Next, the documents must be produced by, must be produced before the court on the returnable date, which shall be 21st April 2023. Stop. Advance copies of the documents must be made over to the parties to the writ petition by 20th April 2023. Stop.
we file our affidavit in opposition we have served upon them.
You are for who, Mr. Shannal?
Private response, added private response.
Yes, the affidavit in opposition of the added private respondent is filed in court today. Stop. Is there a direction for affidavits?
No, my lord, it wasn't. No directions were given the last.
Then why are you filing an affidavit?
My
in
lord,
opposition?
we have, my lord, I tell you, lordships.
Pursuant to which order?
My lord, I tell you. My lord, 12th December 2022.
That is affidavits in connection with addition application.
Lord, I have been added, I have been served the writ petition. My lord, December 12th, your lordship, the direction for affidavit.
That was regarding, my lord, the addition application.
I don't find that you.
You want
Addition has already been made.
That is on 6th
Very well.
February.
Yes. You want to file a reply, Mr. Ms.
My lord, on the next returnable date, I'll have it ready.
And this is the page 70.
My lord, page 70.
The petitioner's reply shall be filed by the returnable date.
My lord, I wanted to show you page 70 where I've been termed as
Let them produce the
encroachers.
documents, please.
My lord, your lordship is keeping it at 21st.
21st.
My lord, your
Yes.
lordship keep it on 25th or before that, your lordship. My lord, 21st to 24th, I have some difficulty.
25th,
Much.
as prayed for. Advance copies to be given by 20th of Hag. Yes.
I'm deeply obliged, my lord.
Call on the next matter, please.
Item number 20.
Learned advocate Mandal Siddhartha Shankar Mondol is appearing in this matter, my lord.
Sorry?
Learned advocate Mr. Siddhartha Shankar Mondol is appearing in this matter, my lord. He is not well. He has not come to court, my lord. I am praying for only not this week.
It's a new matter.
Perhaps, my lord. I have not briefed in this matter, my lord.
What is the memo dated 13th August 2020, Mr. Sen?
Lord, this is a person with disability. He seeks employment. Lord, he suffered a accident, road accident. Person
Yes.
with 100% disability. He's written to various statutory authorities seeking some sympathetic consideration by way of employment.
Very well. When do you want to come back?
It is commensurable next week on a Monday.
Yes, adjournment, learned counsel appearing for the petitioner, prays for an adjournment. Stop list this matter on 17th April 2023 as prayed for.
Okay.
Next.
Item number 21.
This is matter. Your Lordship, Lord, had directed us to file an affidavit indicating the particulars of, Lord, our expenses. Lord, the scrap products tender has been floated, Lord. This is relating to that matter. Lord,
Mr. Kormakar, come back at 2, please.
Lord, can it be taken up on tomorrow?
No.
Lord, at 2 p.m. a matter is fixed, Lord. I am addressing.
Then you choose the court, please. Or 2:30?
Lord, it will continue for some time. It's in 6:54. It will continue for some time.
Give me a time today.
Lord, the other thing I was indicating is, Lord, I have also preferred an appeal, Lord, against your Lordship's order, 2 orders.
Yes.
Lord, that appeal is also to come up, Lord, tomorrow. I have mentioned that matter.
Very well.
Lord,
Come
on
back
Monday.
at 2, please.
Item number 21.
My lord, I appear on behalf of the petitioner.
Your Lordship, Mr. Rahul Karmakar is appearing. He is engaged in court number 654 right now.
He's not required. He appeared before before lunch. Yes.
My lord, I'll just indicate to you the points, and if you want to give them
Yes,
time.
microphone, and which order?
My lord,
order?
I'll tell your lordship. My lord, your lordship may remember on the first day itself, a point was taken about certiorari cannot be issued, and last day's order that not to forfeit. My lord, the last day's order is not to, my lord, forfeiting the pre-earnest money. This is the order. My lord, your lordship may remember they took time saying that it is lying closed, my lord, so to furnish the particulars. And my lord, after that, next day we find they filed. That's my lord, they're right. Whether ad interim order.
Yes, the first paragraph of the order.
Yes, yes. Now, my lord, the good thing is that they have at least today filed the affidavit.
Lordship, I'm serving the affidavit.
Affidavit?
Affidavit regarding the incurred.
The loss which they have incurred.
Yes.
The loss which they have incurred. They have filed the affidavit. My lord, I want to let it not be contented that your lordship, my lord, your lordship has taken only a prima facie view. Your lordship has not given any relief in my favor in the writ petition. Let it not be contended, my lord, before the appeal court that your lordship is passing ad interim or without going into the question. So, my lord, I want the matter to be disposed of, and I'll just one 2-page note I will give you, my lord, why it is maintainable, why writ of certiorari lies, why.
No, what is the point of maintainability which Mr. Karmakar?
Firstly, my lord, he says that writ of certiorari does not lie. To that, my lord, my answer, it's not only writ of certiorari. I prayed for mandamus and prohibition. Secondly, my lord, what is more important, this is what
certiorari, according to him, does not lie because of what?
Because, my lord, it's a private contract. Okay, it's a private contract. Now, my lord, if certiorari does not lie, mandamus also doesn't lie, prohibition also does not lie in a private, my lord. Certiorari is basically.
In any case, 226(1) says writs in the nature of.
Yes. Now, my lord, that's what I wanted to say. When I tell your lordship about the maintainability point, I have to answer, because unless I am satisfy you with the maintainability point, there is no point going ahead with this matter. But your lordship has taken a prima facie view. Let me give you the two answers, quick answers. Why there is public.
Will you, are you in the matter?
No.
Very well. Yes. Yes.
Let me give you an answer.
All of you can take your seat, please. Yes.
Let me give you an answer why there is public law element involved. My lord, it is even in private contract, if there is public law element involved, and the public law element is involved if there is breach of any fundamental right of a person. Now, fundamental right which is being breached by a statutory authority are twofold here. One is that without notice you are forfeiting an earnest money. No person forfeiture can take place without serving notice. If there is violation of nature, there is nothing called, they have said it's an automatic forfeiture. Now, my lord, nothing in law exists as an automatic forfeiture. You must give a show cause that I'm forfeiting. That because of blah, blah reasons, my lord, whatever it may be. So, my lord,
that is provided under some rules here.
No, my lord.
Or you're just taking a natural justice point.
This is the natural justice inbuilt of forfeiture. Forfeiture is taking away whatever I paid. May not say it. It is inbuilt forfeiture in any contract.
Yes.
Now, my lord, this is first. The second is the second aspect is that how much will you forfeit? Will you forfeit the entirety or forfeit a part of it? Now, my lord, the question arises of interpretation of section 73, because the fundamental law is no statutory body can make a windfall, my lord, out of a breach of a private party. That is the second, my lord, reason, my lord, why there is public law element, because the statute, the law with regard to damages is not being followed, because damages are always two things. They must not be remote and they must be reasonable, and that is remote means they must be foreseeable. These are the law of Hadley and Baxendale, my lord, the first limb of Hadley Baxendale. They must arise naturally out of the usual course of things. Now, my lord, this is not a case of a special damage, because at the time of entering into the contract, you were made aware of future things which might happen. That is special damages. Now, my lord, in light of this contract, I'll give you some case law on this, my lord. And if you see the relief spread for in the writ petition, although they said, my lord, it's a argument was made on that day with regard to.
Mr. Bose, will you be more comfortable making your submissions without your mask?
My lord, now that it is, I got a little.
No, because I'm told that it is not good, not a very healthy thing to exert with your mask on. That's why I'm asking you.
No, this is now. If your lordship is otherwise,
No, why should
not,
I be bothered? I have.
no, here, that I have done, my lord.
Yes.
If your lordship otherwise cannot hear me or anything,
No, I can hear you.
no, please tell me. I'll
Yes.
open. It's just because I was not in Calcutta. I was enjoying some weekend holiday, and the moment I came back, I had this little bit so taking protection basically.
You're protecting others, you mean?
Yes, that's the normal way people do. That is, we forget that. We think that we are protect. The normal thing should be if you feel you should protect the others, which is what we do not do, and that is why we have to wear.
That's correct.
Yes. Now, my lord, so my lord, coming back, if you see the relief spread for India, and I give you a short note. My junior has prepared it, but I have not checked the cases. So you see the prayers in the reliefs in the writ petition, because at the end of the day, this is what your lordship will.
Mr. Bose, you give me that note next week. You have got it ready?
Yes, my lord, I am only saying
No,
that
next week, because
let it not be.
I am dictating 24/7. I just need to space out matters.
Oh,
So
no,
next week.
that is okay.
Yes.
I only fear let it not be contented.
Yes.
That your lordship, that the main matter is being heard by your lordship,
Yes.
and the issue is still open before your lordship, and we are making arguments. That is what my lord, if the matter is taken up, my lord, by the appeal court, although, my lord,
I'm hearing you.
yes, no, I'm saying it will be contended, my lord, as if, my lord, that your lordship brushed aside the question of you already, the view was prima facie. So I am prepared to argue and finish this matter.
Yes, so please do.
Yes.
Yes.
Therefore, my lord, regarding the
Mr. Bose, the way I like it, just give me the challenge, your grounds for that,
yes,
and why the order is not sufficient.
yes,
Obviously, the writ petition needs to be heard.
yes.
Just structure it for me. So
My
that I
lord,
remember.
that a writ
That's all.
petition, no more of affidavit exchange, because they have filed 2 affidavits. They have taken all the possible points. Now the only question is a question of law. They have also said what are the damages which they will, so they have quantified it. Now the question is, my lord, whatever they have quantified, whatever I said, I offered to pay the entire 25 lakhs, my lord, for conducting a new, for the frustrated auction, maximum, because of the agreement between them and MSTC. I said, I will even give you 2.5 lakhs to, my lord, conduct a new auction. I also said, I will give you the lawyer's fees for, my lord, for all this, and the processing charges. These are the maximum which I can, my lord, a person, my lord, kindly, there are 2 types of contracts here. One is, my lord, the furnishing or giving of earnest money. What is the earnest money for? Earnest money are given by all bidders to participate in the auction, and there is a clause that if the highest bidder is there, that his earnest money, he is supposed to enter into a contract. So the breach on my part is that I have furnished, I participated in the auction, but I have refused to enter into an agreement.
Yes.
So it is basically, my lord, the breach is that of an agreement to enter into an agreement. Because the clause says in the contract that the sale order or the contract would be executed after I put in the additional security deposit amount. And part of earnest money will be converted to security deposit. And I must do it within 10 days. Otherwise, I'm in breach. I have said before that time expired, I don't want to. So I am in breach, no doubt about it, of, my lord, the agreement to enter into the agreement. I will not enter into the agreement. Now, my lord, a fundamental mistake, which is there made in their affidavit in opposition, or first affidavit, is say they equate the earnest money as under section 74. That earnest money is not under 74. 74 arises for liquidated damages, and whether it's penalty or in terrorism or whatever it is, if there is a contract.
Yes.
This is an agreement to enter into an agreement. So I have breached the agreement to enter into the agreement. So, my lord, what are the damages following naturally in the usual course of things under section 73? I have frustrated any auction. I am compensating him for the loss. I am compensating for contesting all this.
And Mr. Bose, what are you trying to prevent?
I am trying to prevent that. I want refund of my money, the earnest money. Obviously, your lordship will not direct entire refund of the earnest money. Your lordship will direct refund of earnest money, my lord, after deducting the possible expenditure, the foreseeable damages, which are not too remote, which are possible under section 73.
Kailashnath says pre-estimate.
Pre-estimate, it has to be, my lord, because damages are suffered on the date of the breach. Assessment is done on the date of the breach. What will happen 2000 years ago? Suppose it's never sold. That is not foreseeable. That is the question of remoteness, my lord. Damages under section 73 has Hetty and Baxendale. There are three parts. One is remoteness. That is, you cannot predict what is going to happen in the near future. Then, my lord, is reasonable. It has to be reasonable. And that's it, my lord. Foreseeability is connected with remoteness. It is not foreseeable. What will happen, my lord, unless, of course, you make it a term in the contract, agreement to agreement, that it is my lord, which is unusual, that it is likely that a future auction you will not fetch a higher price. Therefore, we are making a pre-estimate. It is impossible.
No, that will fail for uncertainty.
That will fail. That is remoteness.
Yes.
That is foreseeability.
Yes.
My lord, special damages case, my lord, you must be made aware at the time of entering into the contract that this is the, my lord, that this is likely to happen. That is special damages. My lord, your lordship may remember the English case of that pigs dying, my lord. That is there were three cases. One is Victoria Laundry, one is Hadley Baxendale, another was this peculiar name, CZ or something like that. We call it the pigs case, my lord. In any event, you see the prayers in the writ petition, what I have claimed, my lord.
Yes.
My lord he focused on the first day. I did not interrupt also. My lord, kindly come to
What is this withhold any decision or withhold necessary clarification means what? Prayer B at page 15?
Prayer B at page 15.
Yes.
Well, that instant case to transmit the records so that conscionable justice may be.
Prayer B.
Prayer B.
B.
Yes.
No, prayer B at page 15, last 4 lines.
Yes, last 4 lines, it makes no sense. Main thing is the first part.
Yes.
So that conscionable justice may be rendered.
Yes, yes.
Yes. My lord, prayer C, D are also there. A mandamus.
So you've asked for Shashorarai and a mandamus.
Mandamus. Now, my lord, I am concerned with C at this stage.
Yes.
Now, my lord, there is no fundamental difference, my lord, in any prerogative writ. In prerogative writ are all discretionary. My lord, the question whether your lordship will grant, writ can be granted in any matter, The question is of self-restraint by the court.
It's a self-imposed.
It's a self-imposed restraint
Yes.
that you will not grant because there is alternative remedy. This is in the realm of private contract. That is why. Otherwise, there is no bar in granting, my lord. There are a number of decisions I will give your lordship. But the fundamental question is, at the end of the day, if I get over the first hurdle, the other things follow. The first hurdle being, is there a public law element involved in this private contract? And I've told your lordship the public law element involved, that no forfeiture can ever be done without serving notice, a show cause that I am going to forfeit. Here I have asked for refund. There is no notice at all. In the opposition, they say it is automatic forfeiture. There is no such concept in any contract.
And are you following some rules, some guidelines? What are you following? Or
No, my
just,
lord, law,
just
Supreme Court.
73, 74.
73, 74 and Supreme Court, that automatic, it cannot be done, law of forfeiture. No one's property can be taken automatically without, my lord, even serving a notice.
And what does the contract say?
My lord, contract doesn't say silent that it shall be forfeited. It shall be forfeited.
Doesn't give a
No,
notice.
no. It is silent. So does the contract envisage this? That any person's money, and I'm saying, what is the money for? My lord, that way, if this is the law, every person's earnest money deposit for breach of any tender condition, breach of tender, what is the condition in the tender? That highest bidder will enter into the agreement. So far as the other bidders are concerned, what is the agreement that they've entered into? That they will participate and not manipulate any term of the auction, where their money will be liable to be forfeited. We are all bound by the same terms. So many bidders were there. My lord, if the law is that you can just take away, suppose it's another bidder who contract was not for some other reason, it is just entire amount is forfeited.
Yes.
Does it lie in the mouth of the side to not to prove and say that no, entire amount will be forfeited, that too without notice? I will show you the clauses. The clauses are important. My lord, if your lordship sees the clauses, just 3 or 4
Clauses of what?
of the tender conditions, because
You're saying that it's silent.
no, about when contract is entered into, and what is the forfeiture for?
Show me the
Yes.
Show me the law first, please.
Yes. Now, my lord,
And Mr. Bose, how many decisions do you have?
my lord, there are many. Can I give you a short note as I indicated?
No, there are many. On how many points?
My lord, the first one,
On the proximate, that damages will have to be proximate and reasonable.
reasonable. On that, I want to give you a lot.
Foreseeable and reasonable.
And my lord, I want to give you at least 2 Delhi High Court following Kailash Nath judgments. My lord, what happened there? It was agreement for sale, 2018, and one is 2021. There was agreement for agreement to enter into an agreement.
Kailash Nath, Justice Nariman was 2018. Very well. Yes, whatever it is.
Yes, my lord, 2015.
2015.
Yes. That is for the proposition no statute can make a windfall.
Yes.
But that is essentially, my lord, on section 74. On 74, I am telling your lordship, there is whether it's a pre-estimate.
Yes.
But we are talking of an agreement.
You're on 73.
73 has to be, my lord, because it's an agreement to enter into an agreement.
Very well.
It cannot be 74 as such. But the principles of 74 are also embodied in 73. That is what I wanted to show you.
74 is not a problem for you, is it?
74, my lord, had it been, I could have said clearly that in the contract it's mentioned as liquidated damages. Therefore, sections say so. But here, my lord, I think 74 does not apply. Although, my lord, I must tell your lordship, they say, no, 74 applies. My lord, it's not me.
How does it make the case better?
No, it worsens their case. And my lord, but your lordship, whatever this law is, I must, whether it goes this way or that way, my lord, it doesn't matter, my lord. But the thing is that one mustn't make a mistake on whether 73 applies or 74 applies. When Kailash Nath itself says 74 has no manner of application in these cases, because there is no contract. My lord, the contract here is an agreement to enter into an agreement.
Yes.
I have given the earnest money
Yes.
to enter into an agreement, and that agreement never happened.
Yes.
So what is the consequence of that breach? That I did not execute the agreement. Breach happened when I refused to execute. Damages are assessed on the date of the breach. These are fundamental concepts, my lord, under section 73. And the other concept laid down more clearly by the Supreme Court, no statutory authority should make a windfall
Yes.
out of a breach, my lord. These are the two things.
So you're saying that if they withhold your earnest money, that would be a windfall?
That, of course, entirety.
Yes.
Entirety. Now the question arises, how much? My lord, how much? Will the,
What do you mean by entirety? Have they paid you something?
No, no, no. So entirety, I have asked for entire refund.
Yes.
Then the question is, why not? They must have suffered some damage.
Yes.
They-
So
they-
you offered to pay whatever.
Yes, yes, I offered because, my lord, I feel that a damages must be reasonable and foreseeable. That is section 73. Now a writ court does not go into all this problem.
Yes.
So I have to take whatever they demand,
Yes.
my lord, as the estimate of damages to be the probable, and say, okay, you enjoy. Maybe it's more, maybe it's less,
Yes.
but it can. Sorry, it's not. Maybe it's more. It's not more. It's much less. But now see, my lord, what they have said after the two affidavits have been given. I will give you the clauses, my lord, and if you see the two.
Why have they given two?
Because, my lord, on the first day, your lordship said MSTC to indicate,
Yes.
my lord, the bid amount and the agreement which they may have.
Right, right. Yes.
And, my lord, they were also directed to file some document.
Yes.
They produced instead their agreement with MSTC. The conducting person who is conducting the auction is MSTC. Now, if MSTC conducts the auction, there is an agreement. Now, my lord, the agreement clearly says that if for a failed auction, the maximum MSTC can demand is 25 lakhs. And for any new auction,
Yes.
it will be 2.5. I will show you those clauses.
Yes.
My lord, this is one aspect. My lord, will you please take that first affidavit? And then I will show you the next affidavit when your lordship made more specific that how much you indicate.
Kunta first affidavit dakho.
My lord, it is an affidavit affirmed on 24th March 2023.
Yes.
My lord, they have annexed at page 11 my lord, a memorandum of understanding for e-auction services for sale of movable and immovable assets, and this apparently has been executed on 25th May 2022.
Yes.
My lord, kindly come to clause 6Q at page 14.
Yes.
My lord, it says that the pre-bid EMD of successful bidder will be automatically converted into security deposit on My lord, on issuance of sale order, then says Stoke acceptance letter, but on no sale order has been issued, which I will show you from the contract.
No, what is a sale order or
That is
acceptance?
mentioned, my lord, in the contract. That I will show you. My lord, that is the contract. The sale order is the contract. That is why I said no contract has been entered into. This is an agreement to enter into an agreement.
And where do you?
I'll give you, my lord, please, my lord, may I go ahead?
Yes.
The above shall be transferred by MS2 after acceptance by the H1 by NJC. ANJC on its part will return security on successful completion, etc., etc. Then no interest will be paid. Then, my lord, service charges is 9. For providing its service.
Where are you reading from?
My lord, last
Yes.
service charge. MSTC shall be entitled to service charge of 1% of basic price of the amount realized. May not be in the, as the case may be. Then, my lord, kindly see straight away that clause, important. My lord, page 16.
Yes.
In case the successful bidder, has your lordship found that?
Yes.
Fails to make payment for the lot sold to it, MSTC shall be entitled to a service charge
Yes.
of 1% of the forfeited bid security, subject to a maximum of rupees 2.5 lakhs per auction. So it's 2 point. I said 1 is 2.5 lakhs. Then let us see 11. Since MSTC shall act thereby a service for all legal proceedings at the instance buyer or any other connected to the e-auction of shall be handled by principal at its own cost, even if MSTC is made party in such proceedings. In the event is required to defend, legal expenses which MSTC may be borne equally by principal and MSTC. My lord, in the new affidavit, they have said they have apparently incurred 7.5 lakhs. Very well. I have to accept, my lord, 7.5 lakhs. If this is the site, I told your lordship. Legal.
They as in NGMA or?
Yes, NGMA has said so.
Yes.
My lord, then, my lord, kindly see the another clause, go to 25. Yes, sorry. My lord, kindly see small o, page 15, small o.
Yes.
My lord, principal may view live forward auction through user ID. However, bidder's name will not be available during currency of auction. My lord, subject.
Where are you reading from?
My lord, it is page 15, right at the end. It's a small o. It is paragraph 9, small o.
Yes.
The principal may view live forward e-auction through its user. However, bidder's name identity will not be available during currency of the auction. Then, my lord, says subject to a maximum of 25 lakhs. My lord, I don't know. This is the agreement which they have said. So I said add another 25 lakhs. My lord, so I said, wow, this is a very peculiar clause, makes no sense. But I said add another 25 clause because somewhere it is appearing 25 lakhs. My lord, see their affidavit in the body. This is what says that no. Then kindly see, my lord, para 9 of this affidavit.
Yes.
Then, sorry, para 6. I say issue of forfeiture as demonstrated in the garb of 73 is completely misconceived. The said forfeiture was not in the form of compensation, but in the form of deterrence and penalty. The said forfeiture would get active on various situations indicated. Thus, 74 is applicable to the present case. Incorrect, absolutely incorrect. Then, my lord.
No, so that's why I'm asking you, Mr. Bose, how does 74 make their case better?
It makes them case worse. That's what I'm saying, my lord, because 74 says that, my lord, if it is a penalty, it must be reasonable. It must be reasonable. But if it is a penalty, If it is a penalty, then you judge the question of reasonableness of the amount. My lord, the same underlying principle is also there in 73. Only we use the term foreseeable, remote, and reasonable. My lord, this is the issue. The question is whether in 74 that is a pre-estimate of damages or not.
Yes.
So that way they want to say, no, it is a pre-estimate of damages, this earnest money, which can't be the case.
Yes.
It is. My lord, kindly see. Then it says, kindly see, para 8, it says, I say pre-bid was clearly indicated to liable in the case of failure for failure to fulfill any of the terms of contract of e-auction. Now, my lord says automatic. It is automatic. That's why that's a language use. Then says in paragraph 9, my lord, I say reason of putting in forfeiture, my lord, kindly see, is to curtail probability of cartelization and promote fair competitive bidding. It is only to ensure frivolous are excluded from disturbing. The said amount was indicated only to secure bona fide bidder. They are giving an interpretation of the earnest money. My lord, in this case, I said there's a difference of 5 lakhs. I also said if the other one is coming, obviously, my lord, in this video, my lord, who wants they want to have a go, my lord, he did not respond. I gave him a notice. Notice. Yes. My lord, kindly see in 8, last line. Further, after receipt of security deposit amount, respondent number 1 will issue the sale order. So contract will happen. My lord, paragraph 10 is also important. In absence of presence of any other bidders or their pre-bid amount on board. Why on board? Because they have returned the earnest money of all other bidders. The entire has to be scrapped because of conduct. Of course, it has to be scrapped. It is impossible to even, kindly see, even guess as to what would be the amount that the second auction would fetch. That is foreseeability, remoteness. In absence of pre-bid of any other bidder, no such bidder can be forced to shoulder the burden of, nor is there any stipulation in the NIT or MOU to such effect. My lord, this was to say, because I said, get the other bidder. If he had come, he would have showed this. You can't. My lord, 5 lakhs, no, you have to, I will forfeit the entire amount if I manage to get the buyer. Then, my lord, kindly see page 5. The petitioner is basically to evade the stipulation of NIT and cause severe damage to respondent number 1, which is impossible to assess in terms of money. Fortunately, they have assessed in the subsequent affidavit. My lord, then, my lord, kindly come to, yes, paragraph 13. I say issue of quantification of damages as pursued and submitted is impermissible in the writ jurisdiction. So, forfeiture has to be strictly honored and adhered to. And then say, my lord, this thing about by way of writ of the process, no adjudication was involved.
Mr. Bose, how many more paragraphs?
No more, my lord. I will come straight away to the second affidavit.
How many more? How many paragraphs from there?
There's
I don't
2
like
paragraphs.
that pleadings, just
No,
2.
just 2
Yes.
paragraphs. My lord, today's affidavit,
yes,
which has been filed, just paragraph 1 and 2 will do.
Yes.
My lord, kindly see this. I am furnishing details of expenses incurred for conducting the e-auction. My lord, just look at this. Charges of security service for conducting the e-auction. Then
Security services, this is MSTC's charges.
no,
Then what is security service?
my lord, their security, that plant is lying there, they have been security guard. My lord, kindly see overhead expenses, miscellaneous maintenance cost. They have been maintaining the plant. Then legal expenses, I cannot,
So this is
my lord,
7 lakhs 26,000.
72 lakhs.
Yes, 72 lakhs.
My lord, there is more.
Yes.
Next one is overhead maintenance. 2
Next
lakhs.
one is 2 lakhs 90,000.
Yes. Miller, I can understand 3, although I cannot dispute in jurisdiction.
Yes.
Miller, the legal cost. I
Yes.
cannot dispute it, although I have said 7.5 lakhs.
Yes.
Then insurance cost, Bargali premium. They have insured the goods, and this is arising out of the breach.
This is 45,000.
45,000.
Yes.
Then next one says for 1 year,
83 lakhs.
83 lakh. No, 83 lakh. 83 lakh 45. And for 2 years, 1 crore 66. Well, somehow or the other to consume the entire 2.22 crores.
That's the honest money.
Yes,
Two-
that's
two
the,
point-
that's
2.2
the honest
crores.
money. It's usually it's 50 lakhs or 20 lakhs.
So you're saying that
These are not, Milord,
neither foreseeable nor reasonable.
these are not reasonable and these did not arise naturally in the use. These are expenditure. Milord, I can give you the clauses in the contract if you want.
No, Mr. Bose, I don't want.
Next. I will
You,
give it in the note.
your purpose is served. You, when do you want to come back?
Milord, whenever it is, please note that on the question of maintainability, I have addressed your lordship. Otherwise,
Very well. Heard learned counsel appearing for the petitioner, petitioner, Akjon, at length on the issue of maintainability. Stop. It may be recalled that the respondent numbers 1 and 2, that learned counsel appearing for the respondent numbers 1 and 2 had raised a point of maintainability of the writ petition on the ground that a writ of certiorari will not lie with reference to the contract entered into between the petitioner, with reference to the agreement to enter into a contract between the petitioner and the respondent numbers 1 and 2. Stop. At a cursory glance, the writ petition, the prayers in the writ petition reflect that the petitioner has also sought for a mandamus and various other directions on the respondents. Stop. Next, counsel appearing for the petitioner has placed the paragraphs in the pleadings, as well as what else did you place? As well as section 70, as well as the implication of sections 73 and 74 of the Indian Contract Act, 1872. Stop. Next, list this matter on.
my lord, kindly record that pursuant to your lordship's direction, a second affidavit has been filed.
Next, it is also recorded that the respondent numbers 1 and 2 have filed a second affidavit, which is taken on record. A second affidavit in court today. Stop. Next, list this matter. Yes, Mr. Bose.
My
When
lord, whenever it is convenient to your lordship.
next week? Tell me a date.
My lord, I haven't. My lord, I think from 17th any day, which is possible. My lord.
Can't hear what you're
My
saying.
lord, from 17th any day, which is convenient.
Yes, list this matter on 18th April 2023.
Item number 22.
It is your lordship.
Respondent number 3, official trustee.
Yes, Mr. Mukherjee.
Lord, I am for the respondent number 3, official trustee.
The subject matter of challenge is at the instance of four, 5 persons, who owe some responsibility, in ensuring that a private Devotto trust, is, maintained, and, the parameters laid down in a decree of the civil court is adhered to insofar as election is concerned. Now, the immediate matter of challenge,
election to the,
the trustees, the board of trustees.
Yes.
Now, the immediate subject matter of challenge is, usurpation of jurisdiction by the official trustee, which, in my most respectful submission, does not have any power.
So you've asked for a quo warranto?
No, we have questioned a communication, a communication at page 98, which
No, you complete that other sentence, please. Usurpation of jurisdiction.
by the official trustee, the Administrator General and official trustee of West Bengal.
Yes.
That is the subject matter of challenge. The immediate challenge is that the thrust of my submission to your lordship is, that this entire exercise is without jurisdiction. It is, contrary to any law.
What has the official trustee done?
It has, first of all, it has said at page 98, in view of the order of the government of West Bengal dated 24th July 2022, I do not know what that order is, and pursuant to the complaints with regard to irregularities in management of the temple named as such and such Khorda, the present trustee board headed by Guru Sahay Goswami is hereby dissolved.
You are the this.
I am not Guru Sahay. Guru Sahay is the one of the respondents impleaded. We are the Shebayets. 5 petitioners, most of them aged 80, 72, 73. They are saying that in terms of page 60, which is a scheme, framed by the learned additional subordinate judge at Alipur, the page 60, is the scheme. The scheme for Sheba Pujo of Sri Ishwar Radha Sham Sundar Jiu Thakur of Khorda.
Yes.
This board of trustees is under this scheme.
And why was this scheme framed?
The scheme is the outcome of a litigation.
Yes.
Way back in 1938, a civil court had framed this scheme.
Yes.
By way of a decree.
Yes.
Now, certain things are against me, I must tell your lordship. First is, this document which I am seeking to throw a challenge to is of July 2022.
Yes. That's page 98.
98.
Yes.
Another thing which may immediately, be raised is, that who am I to throw, because I am apparently not affected because I am a Shebayet.
Yes.
My grievance is 4 at page 60. Election of trustees is earmarked in the scheme.
And why would this scheme bind the official trustee?
My lord, official trustee has no jurisdiction in this case. Bind or not bind is not the issue. Official trustee has acted contrary to everything. It is a private devottur. It's a private trust, my lord, and the entire management, everything is engrafted in this scheme, subject to correction, my lord.
Yes.
And my lord, this wrongful assumption of jurisdiction by the official trustee, purportedly on the basis of undisclosed complaints and, my lord, an undisclosed government order, my lord, is the subject matter, my lord, which is prompting us to bring 2-3 things to your lordship's notice. First is, my lord, this Mundir today is being run by complete outsiders at the behest of some manager. And, my lord, defalcation of funds.
No, and when did this outsider manager take over?
My lord, after this 98.
28 July.
After this 98, yes.
Yes.
The scheme says, Shebaits, it conceives of an election. My lord, I shall be grateful to your lordship, my lord, if today your lordship appoints anyone, my lord, to conduct this election in terms of this scheme, and the matter is over and out. My lord, this assumption of jurisdiction is beyond statute.
No, conduct the scheme means the scheme has not been conducted since.
One impediment is there.
No, when was the scheme framed?
1938.
So from 1938 till
this was going on. Last election took place in 2008-9. Admitted position is that, and it, my lord, envisages a 3-year election, every 3-year election. My lord, it envisages a 3-year.
Why did you not? Why were elections not held from 2012 onwards?
That is one impediment which is standing in my way, no doubt about it.
Yes.
And, my lord, it also prima facie appears, my lord, it's my duty, my lord, while assisting the court, that, my lord, no apparent representation. But the thing is, non-adherence to this scheme,
yes,
my lord, would have entailed a civil proceedings, which is already, my lord, at the behest of some other Shebaits, my lord, a civil court has been approached.
Yes. But that was in 1938.
No, civil court has been approached in 2022 or 2021.
Very well. As a precursor to the writ petition?
No, when a writ petition is challenging 98.
Yes.
Precisely 98.
Yes.
My lord, it is completely, my lord, because, my lord, the Official Trustees Act kindly sees.
বেঙ্গল অ্যামেন্ডমেন্টটা আছে তো?
দাদা মনে হয় আছে।
আমাকে একটা বই দিয়েছে যেটাতে নেই।
Now, please see section 7. I'm sorry, my lord. Section 7. General powers and duties of official trustee.
Yes.
My lord, here, subject to and in accordance with the provisions of this act and the rules made thereunder, the official trustee may, if he thinks fit, act as an ordinary trustee, be appointed trustee by a competent by a court of competent jurisdiction, etc. Save as otherwise hereby expressly provided, the official trustee shall have the same powers, duties, and liabilities to be entitled to the same rights and privileges, and be subject to the same control and orders of the court as any other trustee acting in the same capacity. My lord, here the court has, my lord, if your lordship looks into the plain and simple statute, my lord, the court has not directed anything. There is no order of any competent court of any jurisdiction, my lord, or rather, my lord, court of any competent jurisdiction, my lord, to, my lord, give this power to the official trustee. My lord, in any event, please see 8 now.
Yes.
Any person intending to create a trust other than a trust which the official trustee is prohibited from accepting under the provisions of this act may, by the instrument creating the trust and with the consent of the official trustee, appoint him by that name or any other sufficient description to be the trustee of the property, subject to such trust, provided that the consent of the official trustee shall be recited in the said instrument, and that such instrument shall be duly executed by the official trustee. Here, my lord, there is no such thing. Whatever is there, my lord, with all humility, my lord, it flows from the scheme. My lord, the official trustee's action, my lord, as has been very recently, my lord,
yes,
laid down, my lord, in a different judgment, but my lord, in the
So what does 98 say, that the trust is dissolved?
Yes,
No, the board is dissolved.
yes. Dissolved on the basis of undisclosed complaints and on the basis of a government order. Both, my lord, unknown. And I come to know of this, my lord, in 2022 December. That is my pleading, my lord, though the pleading is not very my lord, very happily worded. The pleading is, my lord, I came to know in the late part of 2022.
Yes.
It is not specific, my lord, it's a general pleading.
Mr. Bhattacharya, if you have lived with the order for almost 9 months, then what is the interim relief?
My lord, my interim relief is, my lord, your lordship will, my lord, may, after hearing, my lord, everyone, may, my lord, do either of the things, either stay the operation, even if it has lived. If it is an order patently without jurisdiction, it's a nullity in the eye of law.
Patently without jurisdiction under which section of the?
My lord, under the Official Trustees Act.
Which section?
And 11, kindly see 11. Power of private trustees to appoint official trustees to be a trustee of the property. It is the only provision which is existing. My lord, the
yes,
official trustee, in my most respectful understanding, I may be wrong, my lord, but official trustee, my lord, in my most respectful understanding, cannot, my lord, dissolve a trust, a private trust whose creation is.
So section 11 is your best section?
My lord, yes, yes.
Because I did not find anything in the others.
My lord, my only respectful submission to your lordship is, my lord, this entire assumption of jurisdiction, the entire exercise of this power does not flow from the act. My lord, we have learned, my lord, elementary, my lord, when a power to do a particular thing is envisaged in the act, it has to be done in that manner. When there is no power, the question of action does not arise. But there is no power.
Mr. Bhattacharya, as the 5 Shivaites, how are you affected by this order?
My lord, as the 5 Shivaites, my lord, we are finding every day, my lord, this mandir is being run, this Shiva Pujo is being done, and my lord, there is public money involved. Public money in the sense, my lord, people go and offer their, my lord, pranami.
You are not the trustees.
No,
you are
I am
the
not.
Shivites.
I am not.
So how, as long as you can go and worship or do whatever you want to do, then how are you affected as to who is, whether the official trustee has taken over?
With greatest of respect to your lordship, my lord, the scheme does not permit any outsider to run the trust. It has to be run within the parameters of the scheme. The scheme envisages an election.
So the trustees are not affected by this 28 July?
Trustees, even if they are not affected, my lord, whether they are affected or not, definitely, my lord, that question of locus will definitely come. But, my lord, prima facie, if your lordship is shown that, my lord, an action by a state entity is on the face of it, my lord, dehotes the mandate of any particular law, then, my lord, whether the trustees come or whether the private Shivaites come, my lord, perhaps that question will not be very germane for a decision, because it is against the scheme again. Because, my lord, we will be, my lord, this question would have come, my lord, I was discussing this, my lord, and my answer to your lordship very humbly is, my lord, if today your lordship appoints any officer of this court to conduct election in terms of the scheme, my lord, 2 meetings are to take place. And, my lord, in
these notices of July 2022,
yes,
they have not taken any steps till
not till date. The merely they are functioning, my lord, and, my lord, completely contrary to the act.
I thought it's only the official trustee.
The official trust.
So who is the
official trustee has, my lord, appointed managers, my lord, government representatives. My lord, we really do not know who is in operation.
Mr. Mukherjee, your short response to that.
My lord, so far as the power is concerned, I'm sorry, my lord. So far as the power is concerned, my lord, 25A, according to this West Bengal amendment, gives, my lord, the state government the power, my lord, to appoint
25A.
25A. I do not know whether it is there or not.
No, 25A is not here.
Well, Lord, your lordship may take file. Your lordship may take file. Lord, এটাও দিয়ে দিই একটু দিয়ে।
ওটা দাও।
এটাও দিয়ে দিন।
When did the amendment come?
No, it's the West Bengal amendment.
1965. What is the date, Mr. Mukherjee?
1965.
65.
That is, your lordship is saying that, my lord, the order passed by the state
No,
government.
no, whatever you've handed up.
Yes, this is 65. My lord, the state government, my lord, vested this particular, my lord, this trust, my lord, in the hands of the official trustee in 1965.
সেটা কোথায় পাচ্ছ?
সেটা আমার কাছে ডকুমেন্ট আছে তাই 65 সাল থেকে। This was a governor's appointment in respect of this.
No, where does it say? Where does it say that?
To sanction the acceptance by the official trustee of the proposed trust of the present board of trustee of Sri Sri Radhasham Sundar Ji of Korda for augmenting the Sheva Puja of the said deities on the express condition that neither the official trustee nor any member of his staff shall at any time be concerned or connected in any manner with the performance, supervision or control of any religious rites, Sheva Puja and other ceremonies or duties in connection with the trust. This is an exception. I have not, Lord. I received, Lord, numerous complaints, being the official trustee of mismanagement and siphoning of funds. I was compelled to lodge, Lord, a police complaint for diversion of funds. Now, Lord, after that, Lord, I appointed an ad hoc committee. The ad hoc committee consists of, Lord, the SDO and, Lord, there are certain other, Lord, government official, along with, Lord, those persons who have, Lord, the Shebites of, Lord, this particular trust offering, Lord, pujas. I've already prepared, my lord, a list of, my lord, the Shebites who can offer, my lord, their board. I have already, my lord, taken all steps, my lord, for formation of the board according to the trust deed. Therefore, my lord, I have acted in consonance with what, my lord, the scheme is there. I'm not acting contrary to the scheme. I'm trying to preserve, my lord, this particular, my lord, this trust and
25A, please.
Lordship.
But it's there in that page, my lord, it's there later.
And Lord, there was a public interest litigation by another Lord, the Shebayat, which has been turned down by the division bench of this honorable court pertaining to the same question. No.
Very well.
And there's a division bench order, Lord, turning down, Lord, that was also by another Shebai.
Same petitioners?
No, not by the same petitioner. Another, Lord, Shebai.
No, Shebai. Shebai.
On the public interest part,
On the public
element.
interest part about, Lord, the
Mr.
complaining about the official
yes,
trust.
Mr. Bhattacharya, affidavits.
Lord,
Yes.
election officer has already been appointed in, Lord, August 2022, and, Lord, the election is, Lord, we are preparing for the election as of now.
Lord,
His apprehension, Lord, is...
May I most, Lord, humbly, my lord, say this, Lord, since Reliance has been placed to 25A and on a document, my lord, showing vesting, Lord, may these documents be handed over, maybe come back on a particular day and answer your lordship's query.
No. This will be handed over by way of an affidavit within a limited period of time.
In
You
the
will get a
meantime, my
chance.
lord, kindly, Lord,
When
my
is
learned
the election? August?
No, election, he says, my lord, steps have been taken in August. Till April, my lord, at least I do not know about any steps.
The list of Shebayas, Lord, that is a huge list. We have already prepared that.
Yes.
After preparation, my lord,
So when
will
are
be
you
declared.
proposing to hold the elections?
I'll just take instruction. কবে নাগাদ করবি কিছু বলেছো? But I'll have to take instruction on this. But I'm told, my lord, that the voter list has been prepared from the Shebayats.
Very well. Mr. Mukherjee, from August, you have not taken any steps?
Yes.
So if the elections are to be held, you have to take expeditious steps now.
Surely, my lord, I'll do so.
And Mr. Bhattacharya, no,
Lord, expeditious, my lord,
that
kindly.
will not be part of my direction, just to tell them.
Let it be a part of, my lord, that is the precise reason. My lord, two-fold, my lord, kindly visualize, my lord.
Are 5 of you eliminated from the voters list?
Well, I do not even know. Nothing has been.
It has been published. Lord, they should
Published
know.
to-
Yes, it has been published.
Not that I know of.
Published when?
But I'll just give your lordship,
Nothing at least officially known.
1st October 2022.
21st October. Mr. Bhattacharya, you should have been aware.
2022,
What are you doing?
The 21st October 2022, if a publication is made, 6 months down the line, no election takes place. How will I know, I put this question to myself.
Very
Nothing, no steps taken.
Mr.
Let an outside limit be
can
made.
give him, all the chronology of events. There was appointment
Yes,
of auditor.
in 1
There are-
week in an affidavit.
I will do
All
so.
right. Yes, but Mr. Bhattacharya, no interim order. Yes, the petitioners claim to be 5 Shebites of private trust, namely.
I'll just give you a lordship the name. Kindly keep it.
Why you have to-
Ishwar Radha Sham Sundar.
Just give me the paragraph, please, of the writ petition.
No. Yes, the paragraph 1, page 4.
Paragraph 1 থেকে দেখে নেবে। Stop. The petitioners are aggrieved by a letter dated 28/7/2022 issued by the office capitals of the Administrator General and Official Trustee, West Bengal, by which the existing trustee board capitals headed by one Sri Guru Sahai Goswami was dissolved with immediate effect, with a direction that none of the committee members shall interfere or participate in the management and activities of the temple. Stop. Next, Learned Counsel appearing for the petitioners places the Official Trustees Act, 1913 to urge that the official trustee / Administrator General capitals could not have issued the impugned letter, since the said authority does not have any power under the 1913 Act to do so. 1913 Act to do so. Stop. This contention would, however, be belied by section 25A, capital A, which was brought into the Act in 1985. When was it brought in?
It was brought in 1985, but it is not retrospective.
Yes, which was brought into the Act in 1985 and gives and provides for the state government and authorizes the state government to pass orders as it thinks fit in respect of the administration of any trust property vested in the official trustee. Stop. Section 25A begins with a non obstante clause. That is, regardless of whether any power has been conferred on the official trustee to do any of the acts, including the one complained of in the present writ petition. Stop. Next. The petitioners have also not been able to show. Next. Learned Counsel appearing for the official trustee has also placed a letter issued by the Government of West Bengal dated 24th July 1965, which empowers the official trustee, which records that the governor, capital G, has sanctioned the acceptance of the official trustee, West Bengal, of the concerned trust to augment the Seva Puja, SEVA-PUJA, Seva Puja capitals of the concerned deities on certain express conditions stated in the letter. Stop. Next, even otherwise, comma, the impugned letter is of 28th July 2022, and the writ petition has been filed sometime in February 2023. Stop. The petitioners have evidently lived with the impugned decision to dissolve the Board of Trustees. Stop. The petitioners have also not been able to show, the petitioners as the 5 Shebites have also not been able to show any particular prejudice resulting from the impugned letter dissolving the Board of Trustees. Stop. Next, the submission made on behalf of the official trustee that a voters list of the eligible candidates was published sometime, was published on 21st October 2022. Also goes against the petitioners in the matter of grant of interim relief. Stop. Next. The respondents shall file their, who are the other respondents?
State is there.
The respondents shall file their, THEIR, their respective affidavits in opposition within 19th April 2023. Reply within, Mr. Bhattacharya.
20th keeps the matter on 20th. By 20th, we shall file the
19th, you will file it in one day.
Because we have grave urgency.
I'd like to time now. But something beyond 19th, there are 3 days of holiday.
So that's why it becomes easier.
21st April 2023, comma, reply within.
21st will be.
Is a Friday.
It's Eid. Maybe.
You tell me when you want to file a reply, Mr. Bhattacharya. Hurry up.
24th, keeps it on 24th.
Yes. List this matter on 24th April 2023. Stop. Reply in the meantime.
Point of maintainability may be kept open, my lord.
The point of maintainability shall be kept open. Yes.
I'm grateful.
No, the documents, my lord, may I request him to give me?
I'll furnish you within 21st.
Mr. Mukherjee, these two, not these two, there is only one letter. Please give Mr. Bhattacharya.
And there are a number of other documents also.
Very well. Just this letter which you have placed before the court today, give him a copy, please.
Very okay.
May I only request your lordship, the observations made by your lordship, would it be your lordship's pleasure to indicate it is prima facie?
Yes, yes, of course. Ki bollam jeta bollam, jekhane bollam ota prima facie kore. Prima facie.
Great.
Grateful. Okay, a copy there.
Yes. Call on the fixed matter, please. The part-heard matters. Mr. Chaudhary, which one are you waiting for?
This is one of the Kenilworth next one. I'll do it tomorrow.
The next one? Kalke ra diye do, Kenilworth.
Part-heard matters item number 160.
But there was a a compilation of judgments, which was
responding.
Yes.
That's what I asked this.
Eta hoche respond over lekha nei respondent. Yes.
We'll need the bunch of further respondents because I have to.
Yes, yes. my lord.
So Lord, just to get back, my lord, where we were. Lord, we'll recall, my lord.
Mr. Banerjee, microphone, please. Yes. Yes.
My lord, we'll recall, my lord, where we were, my lord. 38(4). My lord, our case is, my lord, that if there's a specific provision in the Act.
You're relying on 4 and 2 and they are on 3 and 5.
I'm only on 4. Because 38(4) says, my lord, only through regulations, the rates have to be fixed.
Yes.
And the regulations say there has to be a prior approval of the state government for the purpose of regulations. And they're relying on, my lord, 1 and, my lord, I think 5.
Yes.
They're saying their general power to pass orders to regulate clinical establishments. Therefore, that power should be implied.
And they're also relying on that unethical trade practices as defined
Yes,
under
yes,
that
yes.
section
Correct,
2 or
correct,
something.
correct. Absolutely, absolutely, absolutely.
Yes.
Now, my lord, now quickly, my lord, they have cited about 20 judgments. I'll try to, my lord, take them in a bunch. I'll just refer to 2 or 3 just to show, my lord, that how, my lord, some of them, in fact, my lord, supports me. So in most of these judgments, and I'll show that, my lord, we'll find that, my lord, they mostly deal with service conditions.
Service conditions as in?
My lord, say for instance, my lord, with regard to, my lord, appointment or, my lord, regulations with regard to, my lord, or, my lord, how, my lord, promotions would be done or how, my lord, salaries would be paid. What I'm saying, my lord, and I'll show that distinction here also. When, my lord, it comes to, my lord, right, my lord, under Article 19(1) in that sense, my lord, when it, my lord, it has a larger effect because you are really regulating fees that can be charged by private persons. You are really regulating their business. It can't be, my lord, done by way of, my lord, this fill-up regulations or, my lord, this fill-up directions. Because
It's easier in service jurisprudence
absolutely,
that there cannot be a vacuum.
there cannot be a vacuum. It's, my lord, it's an implied power to, my lord, the general power. And I'll show, my lord, most of them were general power cases where, my lord, there was no specific, my lord, regulation with regard to that. Barring, my lord, 2, then I'll, my lord, try and, my lord, distinguish that.
So what needed to be done could be done under those general powers.
Correct.
There was no need.
Absolutely.
Very good.
Absolutely. Ma. That's the. So, and when there's a specific power, then, my lord, it can only be done in that way and not any other way.
And in this case, you're saying that there's a specific power under 38(4).
Yes.
Which they have to follow.
Correct.
Yes.
So the rates have to be, my lord, under, because 38(4), my lord, is very clear. It says for rates. That's the power, my lord, which is given, my lord, under 38. My lord, it says make regulations with regard to fixing of rates or charges for indoor patient department and outdoor patient department treatment, including diagnostic, and also to ensure compliance with fixed rates and charges by clinical establishments. So, my lord, this is, my lord, really, my lord, the principle. Now, my lord, kindly take, my lord, there, my lord, this bunch, my lord, which they have given. My lord, first one, my lord, is this Muhammad Rezal Karim versus State of West Bengal. This, my lord, again, my lord, there's it was an.
Yes.
My lord, there was a challenge, my lord, to the West Bengal, my lord, Act itself, my lord, the Clinical Establishment Act.
Yes.
So that was, my lord, upheld. I don't think, my lord, that is really got to do anything with it. But in any event, my lord, kindly look at page 22, my lord, if the pages match, and, my lord, kindly look at, my lord, paragraph 45. This is not really relevant on the subject at all. This was a challenge, my lord, where it was the Act was upheld.
Yes. Which act was the Clinical Establishments Act? Yes.
Yes, challenge, my lord, to the Clinical Establishments Act. And there, my lord, will kindly look at para 45, my lord. Kindly see, my lord, in the middle. I'm just showing, my lord, in the discussing, my lord, the virus, my lord, saying that it is, yes, it is not ultra virus. In the given scheme, in the middle, my lord, will find just that one line I want to show. In the given scheme under the Act of 2017, there would be transparency with regard to the cost of services rendered. The state government seeks to prescribe uniform rates and charges. So the state government seeks to prescribe uniform rates and charges. So that is, my lord, how the understanding of the, my lord, constitutional court was with regard to, my lord, when the virus was challenged.
Yes.
My lord, now, my lord, kindly come to then, my lord, kindly come to the next judgment. My lord, this Narayan Prasad Lohia. My lord, this is on at page 25 of my lord's that my lord, this is my lord on a question, my lord, of the Arbitration Act. My lord, it's a waiver.
Have you cited this, Mr. Sen? I don't see it marked at all.
Yes, Lord, I cited it for the proposition that the statute may not always contemplate all contingencies.
But I don't have any paragraphs written. Which paragraphs?
Lord,
17.
Please to see paragraph 17.
17.
17, Lord. It's in the index portion also, Lord.
Very well. Yes. Yes.
My lord, my lord recalls, my lord, in the Arbitration Act, my lord, the act came in to say, my lord, there has to be uneven, not the equal number of arbitrators. In that situation, my lord, paragraph 17 was because, my lord, they had participated. It said, my lord, it doesn't cover all contingencies.
Very well.
So I don't know how, my lord, that is, my lord, relevant so far as we are concerned.
And the point was, Mr. Sen, that the a statute may not cover all contingencies. Very well. Yes.
My lord, to that, my lord, the simple, my lord, answer, if I, my lord, put that. First of all, my lord, this is not, my lord, Arbitration Act, my lord, is what was being considered here. And secondly, my lord, 38(4) in fact contemplates the situation and says what is to be done.
Yes.
Now, my lord, kindly come to. No. Your lordship's query to me was what happens as in this case where the commission has sent its regulations before the government, but the government has kept it lying. It is in that context, Lord, I had submitted that the statute may not have contemplated all contingencies. In this situation, your lordship's court, which is the constitutional court, has its arms wide enough to cover these situations.
Yes, very good. So you're saying, Mr. Banerjee, that 38(4) covers that, gives that specific.
So, my lord, whether, my lord, it's lying with the state or not lying with the state is really, my lord, not in neither here nor there, really. Whether the state will do it later or do it, my lord, tomorrow or, my lord, not, it's, my lord, not, my lord, relevant, my lord, if I may say so with respect. Question is whether, my lord, the statute itself gives power, my lord, to the state commission to do it. That is, my lord, what we are really, my lord, looking at. When the act itself provides 38(4) to say how it is to be done, whether the state commission could go ahead and, my lord, prescribe, then, my lord, give rates, fixing rates, my lord, for private, my lord, hospitals is, my lord, what really, my lord, is the question, whether that is, my lord, power is given.
Yes.
My lord, the next, my lord, is item 3. My lord, this is that 56 Hyderabad.
Give me the page.
I'm sorry, my lord, this is page 37.
Yes.
My lord, here, my lord, there was a question, my lord, whether a evacuee property, my lord, when, my lord, it was in jointly held with a stranger, my lord, could also be, my lord, termed as a evacuee property.
Mr. Sen, have you cited this?
Yes.
You're relying on the index when you're saying that these paragraphs are irrelevant.
No, I had also placed the judgment.
Very well. Yes.
Lord, perhaps not at that stage the compilation had not been made. Perhaps I had been handing over copies. Lord, it's
very well. Yes. Which paragraph did you cite?
Lord, I mentioned the paragraphs in my index here.
Very well.
Lord, Lord, I indicated
Lord,
my note. I don't know.
19.
Lord, the point why I had canvassed was if the power is given, it gives the power to do everything possible to effectuate that power.
Yes. Which paragraphs, Mr. Banerjee?
Well, Mr. Sen, my lord, at least has relied on 19, 28 to 31, 33, 42, and 43.
Yes.
My lord, it was a question, my lord, of interpretation of rule, my lord, 9 and 10.
Yes.
My lord, if my lord looks at paragraph 4, kindly look at my lord, paragraph 4, there are several allegations in the petition, but the main point at page 37. Main point is that the custodian cannot take possession of the property, however small, which does not belong to the persons covered by the definition of the word evacuee under the Administration of Evacuee Property Act 31 of 1950.
Yes.
Because it was jointly, my lord, owned, my lord, by a stranger as well. So there was question, my lord, was whether, my lord, under rules 9 and 10, it could be taken over. That was, my lord, what was the question, my lord, which was being.
Placed,
Para 4 I
37,
showed.
paragraph 4.
Yes, just to show, my lord, what was the question, my lord, which was being considered. And my lord, straight away, my lord, come to. My lord, kindly come to, my lord, my lord, paragraph 43 first, my lord, looks at.
Yes.
Thus, when the act in question has conferred jurisdiction upon the custodian to secure and administer evacuee property, it impliedly also grants power to take possession in proper cases of evacuee property, though it be joint property. Otherwise, his jurisdiction will be illusory when powers, privilege, or property are granted by statute. Everything indispensable to their exercise or enjoyment is also impliedly granted. Now, my lord, kindly come to page, paragraph 52. My lord, the rule is set out. The proviso to the rule. That's, my lord, what was being interpreted as having, my lord, being very wide.
52 does not. 52 sets out a rule.
My lord, proviso to the rule, my lord. Proviso to rule 10.
Yes. Yes.
The main argument for the granting of the writ is that the proviso to the rule is ultra vires for taking possession of property which does not come under the words evacuee property as defined in the act is not permitted by the enactment. The authorization contained in proviso to rule 10 is as follows. Now, can you see? Provided that where the share of the evacuee in such property exceeds 1/2 of the whole property, the possession of the whole property may be taken in the manner provided in sub rule 1 or sub rule 2, whichever is applicable. So that is, my lord, what is being considered. Interpretation of the rule itself. So in order to appreciate 53, appreciate the argument necessary to give a brief summary of certain section of evacuee property, section 2, clause D and 1, the words evacuee and property are defined. Then, my lord, they go into the definition. And, my lord, then, my lord, then, my lord, sorry, my lord, going back to, my lord, 45 and 46. Sorry, my lord, just going back. Then, my lord, kindly 45 and 46 at same page 42. In this connection, 56D of 56D of the Act, which empowers the government to make rules with regard to the manner in which possession of an evacuee property may be taken by the custodian, cannot be regarded as prohibiting the possession of joint property. Proviso to rule 9 is not, in opinion, contrary to the purpose of the Act, nor does it go beyond the scope of the Act. On the contrary, it limits to a certain extent the wide powers given to custodian, section 10. Therefore, in our opinion, intra vires. Detailed discussion, 19 if necessary. So, my lord, what I'm saying is it's an interpretation of, my lord, the rule to hold, my lord, that rule 9 and rule 10. Proviso, my lord, gave the power to the custodian, my lord, to go and, my lord, also take over, my lord, property in which a stranger also had a share.
Yes.
Now, my lord, the next, my lord, which is at AI 69 Supreme Court, page 47. AI 69 Supreme Court, page 430. That is at page 47.
Banerjee, at page 37.
Yes, ma'am.
Where do I get the complete rules or the act of which paragraphs gives me that?
Rule 9 type. It is at para 6, 5 and 6.
It says rule 9 is ultra vires, but which rule 9 of what?
Under the evacuee property rules. Kindly look at Evacuee Property Act 31 of 1950. Kindly look at 5. The reply of the custodian that the property in question belong to partnership under which entitled to fixed shares and such. Their share being 2/3, more than half, then the possession of property can be taken over under the provisions rule 9 of the evacuate property rules, and that the jurisdiction and the merits of decision rest with the deputy custodian.
Yes.
Argument 6 says, argument learned counsel petition that the proviso to rule and ultra vires beyond the authority to convert the legislation contrary to provisions in the act, and that it contravenes fundamental rights and such held. So the context was totally different.
Yes. Very well.
Then my lord, the next judgment, my lord, is 69 Supreme Court at my lord, 430 at my lord, page 47. My lord, they have relied on 6 and 7, but my lord will kindly come to my lord, paragraph 4. My lord, the question was whether my lord, the power to grant stay when hearing appeal, whether my lord, that is there or not. In paragraph 4, my lord will find at page 48.
Yes.
Section 255 gives the procedure of the appellate tribunal. Subsection 5 and 6 of this section need alone be noticed. Subject to the provision of this act, the appellate tribunal shall have power. Kindly similar, this is what was given. Subject to the provision of this act, the appellate tribunal shall have power to regulate its own procedure and the procedure of benches thereof in all matters arising out of the exercise of its power or of the discharge of its functions, including places at which the benches shall hold their sittings. This is the power given. Then my lord, kindly see my lord, 6, paragraph 6. There can be no manner of doubt that by the provisions of the Act or the Income Tax Appellate Tribunal Rules, 1963, powers have not been expressly conferred upon the Appellate Tribunal to stay proceedings relating to the recovery of penalty or tax due from an assessee. At the same time, it is significant that under the section 220, subsection 6, power of stay by treating the assessee and not being in default during the pendency of an appeal has been given to the income tax officer only when an appeal has been present under 246, which will in the appellant assistant commissioner and not to the appellate tribunal. There is no provision in section 220 under which the income tax officer or any of his superior department officer can be moved for granting stay in the recovery penalty or tax. It may be that under section 225, notwithstanding certificate has been issued to the tax recovery officer for the recovery of any tax, position will be the same with regard to penalty. Income tax officer may grant time for the payment of that. In this matter, he can probably keep on granting extension and disposal appeal by the tribunal. It may also be a matter of practice prevailing department. The commissioner or the inspecting assistant commissioner exercise of administrative powers can be given necessary relief of staying recovery to the assessee, but that can hardly be put at par with the statute power as contained in section 226, which is confined only to the stage of pendency of appeal before the appellate assistant commissioner. Then the argument is advanced, and then they say at 7, they go on interpretation of the statute, and then 13, page 51. Section 255(5) of the Act does empower the appellate tribunal to regulate its own procedure, but it is very doubtful if the power of stay can be spelled out from the provision. In our opinion, appellate tribunal must be held to have the power to grant stay as incidental or ancillary to its appellate jurisdiction. This is particularly so when section 226 deals expressly with the situation when an appeal is pending before the appellate assistant commissioner, but the Act is silent in that behalf when an appeal is pending before the appellate tribunal. It could well be said that when section 254 confers appellate jurisdiction, it impliedly grants the power of doing all such acts or employing such means as are essentially necessary to its execution, and that the statutory power carries with it the duty in proper cases to make such orders for staying execution proceedings as will prevent the appeal if succeeding from being rendered null. So the income tax officer had the power to state while it is pending.
So why was this cited, Mr. Banerjee? What point?
Say because he says the rule is silent, then there should be an incidental power which is available.
Yes.
For giving those directions.
Yes.
But our main case is there is no question of the rule or section being silent. It is specifically provided.
Yes.
So then you can't fall back on these implied powers.
Yes.
All these cases would have been relevant if 38(4) was not there. Now kindly look at the next.
Yes.
And this is important. I'll just show one paragraph which is very important here. This starts at page 52, 72, 2 Supreme Court cases. This was related to collection of excise for cigarettes.
Yes.
And my lord will find, my lord, paragraph my lord 12.
This was cited for which?
My lord, so for the same proposition.
That incidental powers?
Yes, yes.
Implied powers?
Yes.
Which paragraph?
My lord, paragraph 26, 13 and 30 was relied upon by them, but my lord, kindly come to my lord, paragraph 12, my lord, where rule 10 and rule 10A are there. Paragraph 12 at the bottom of page 60.
Yes.
Kindly see, my lord, rule 10 of the Central Excise Act. My lord, here, my lord, first, my lord, assessment was then made, and then, my lord, there was a further notice given. So kindly see rule 10, recovery of duties or charges short-lived or erroneously refunded when duties are charged short-lived through inadvertence, error, collusion, or misconstruction on part of an officer through misstatement as to the quantity, description, such and such, as to the quantity, description of value on the part of the owner, and when any such duty or charge having been levied has been owing to any such cause, erroneously refunded, person chargeable with duty or charge so short-lived or to whom such refund has been erroneously made shall pay the deficiency. Then, my lord, 10A, my lord, has a residuary power for recovery of sums due to government. Then, where these rules do not make any specific provision for the collection of any duty or of any deficiency in duty, if the duty has for any reason been short-lived or of any other sum of any kind payable to the central government under the act or these rules, such duty, deficiency, duty or sum shall on a written demand made by the proper officer be paid to such person, such time as a proper. Then, my lord, now looking at these rules, kindly come to, my lord, paragraph 22 at page 64. And this, my lord, I think, my lord, with the greatest respect, my lord, to Mr. Sen, my lord, actually, my lord, goes against, my lord, what he's been canvassing.
Paragraph 22.
22. Rules 10 and 10A placed side by side
Yes.
do raise difficulties of interpretation. Rule 10 seems to be so widely worded as to cover any inadvertence, error, collusion, or misconstruction on the part of an officer, as well as any misstatement as to the quantity, description, or value of such goods on the part of the owner as causes of short levy. Rule 10A would appear to cover any deficiency in duty if the duty has for any reason been short levy, except that it would be outside the purview of Rule 10A. If its collection is expressly provided for by any rule, both the rules as they stood at the relevant time dealt with collection and not with assessment. They have to be harmonized. In NB Sanjana's case, this court harmonized them by indicating that Rule 10A, which is residual in character, would be inapplicable. This is very important. If a case fell within a specified category of cases mentioned in Rule 10. So, my lord, my submission is, my lord, this goes against him by saying, my lord, that inapplicable if a case will be the specific category mentioned in Rule 10. It's like, my lord, we have argued, my lord, as.
So if the last line had not been there, it would have been fine for Mr.
Yes. My lord, we have argued before, my lord, with regard to, my lord, residual jurisdiction, code of civil procedure, my lord, 151 power. If something is specifically provided, then, my lord, 151 doesn't apply.
Yes.
Then, my lord, paragraph 30, for 30 also, my lord, kindly look at, my lord, page 66.
Yes.
Question whether there was or was not an implied part to hold an inquiry in the circumstance of case before us in view of provisions of section 4 of the Act read with Rule 10 of Senate was not examined by the Calcutta High Court because it erroneously shadowed consideration of the meaning and applied Rule 10A. High Court's view was based on an application of the rule of construction that where a mode of performing duties laid down by law must be performed mode not at all. This rule flows from maxims and such. But as was pointed out by Justice Wills in such and such, this maxim often a valuable servant but dangerous master. Rule is subservient to the basic principle. Courts must endeavor to ascertain the legislative intent and purpose and then adopt a rule of construction which effectuates rather than one that may defeat these. Then, moreover, the rule of prohibition by necessary implication would be applied only where a specified procedure is laid down for the performance of a duty. So here also we have, something, laid down. Then, more, and although rule 52, my lord. So, my lord, this, my lord. So, my lord, that's, my lord, what I'm, my lord, showing. Then, my lord, 6, my lord, can just make a note, my lord, the next one, Khargogram Panchayat Shumiti. My lord, this was a case, my lord, which, my lord, said, my lord, if the power was there, my lord, to give direction to hold, my lord, a hut, my lord, by the Panchayat, then, my lord, it necessarily carried a power to also fix date of that hut. Again, my lord, there was no specific power, my lord, provided. So that is, my lord, Khargogram Panchayat Shumiti, my lord, page 68. So I'm not, my lord, again, my lord, showing that. These are now, my lord, similar cases. Then, my lord, also 1996, 11 Supreme Court cases 23. This is, my lord, page 78. Again, my lord, it's a question, my lord, there, my lord, the National Commission, it was held, had the power to decide rival claims. My lord, when complaint is, my lord, made before the National Commission, question was, my lord, whether, my lord, they could decide, my lord, rival claims or not.
Yes.
My lord, there, my lord, the vessel had sank, and, my lord, the mortgagee and, my lord, the owners both, my lord, had made claims there, my lord, in that case. And, my lord, the question was whether, my lord, the National Commission, my lord, had the power to, my lord, determine that or not. That, my lord, is paragraph 8 and 10, my lord, pages 81 and 82. Now, my lord, all, so, my lord, up to, my lord, this.
So in this case also, it was a power given by implication.
Yes.
That it had rival.
Correct. So, my lord, when there is no specific power given, yes, power by implication, we understand. When, my lord, the circumstances, my lord, admit such a power to be given. But here, my lord, we are not on that issue at all. Then, my lord, the next set is, my lord, if rules are silent.
Next set as in?
My lord, sorry, my lord, from item 9, my lord, I'm sorry.
No, that's 84.
67 Supreme Court, my lord.
No, page 84. No.
Page 93.
93.
84, my lord, sorry, my lord. 84 is, my lord, it's a, my lord, my lord, that's, my lord, also 156(3) of CRPC, my lord, gives power to magistrate to register an FIR. This is, my lord, what was the issue? My lord, it was, my lord, said that power to investigate includes, my lord, a power to register.
Yes.
Now, my lord, the next one, my lord, is under the principle that, my lord, if rules are silent on any particular point, my lord, will find, my lord, the authority can fill up the gaps and supplement the rules and issue instruction not inconsistent with the rules already framed.
So, Mr. Banerjee, would you say that a Section 11 petition under the Arbitration Act
yes,
would also include a power to remove or substitute an arbitrator?
My lord, 14 is there. Specific power is there. 11 will not, correct. 11 will not have that. Absolutely.
So you don't need a 29A.
29A, my lord, that's the time, time limit. Yes.
So if an arbitrator fails that timeline, then he can be substituted.
My lord, 29A, my lord, again, my lord, deals with that specific provision. So 11, my lord, does not have the power, my lord, to remove. 11, my lord, would only have the power of appointment, my lord, when the procedure fails. So 11, my lord, also, my lord, will recall, my lord, how, my lord, we also read into, my lord, now, my lord, saying that when there's a 13-14 issue, then also we can make an application, my lord, in court to, my lord, have, my lord, that issue decided.
Yes.
14, when, my lord, there's a bias or, my lord, when it is otherwise ineligible, my lord, to act as an arbitrator.
Yes.
And 29A now, my lord, is the limitation aspect, my lord, which step
that's
specifically.
fast tracking.
Yes.
Yes.
Specifically put it.
Power is there to substitute the arbitrator.
In fact, my lord, that's correct. 29A, my lord, 6 also has the power to, my lord, substitute.
Yes.
And reduce fees. I don't know, my lord, how many times, my lord, court has done that. But, my lord.
Yes.
My lord, the next, my lord, so, my lord, AIR 67, Supreme Court 1910.
That's at which page?
My lord, that's at page 93.
And that was which paragraph 5 was cited?
My lord, cited was, my lord, paragraph 7.
7. On which point?
My lord, on the same point, my lord, that if rules are silent, then, my lord, the authority can fill up the gap.
Yes.
And supplement the rules.
Yes.
Now, my lord, all these cases, I don't know whether my lord also has one of the numbering,
Yes.
except my lord, numbering nahi, numbering nahi. In fact, my lord, we just তাহলে এখান থেকে ওখানে যা জন্ম আছে ও ওখানে থাকবে না। Item 17, I'll just make just one comment, my lord.
Chief is serial number 2 and 5.
Mr. Banerjee, this is the last case for today, and you conclude on the next day or whatever.
Yes, my lord, I can, my lord.
Yeah, because I will call the original site now. Yes.
My lord, just my lord, so my lord, what I'm saying, my lord, the next my lord, series of cases, except 2 of them which I need to my lord, deal with, are all my lord, service conditions my lord, cases, which means my lord, they're all restricted in their application.
That there was no specific power given.
No specific power given, my lord, and my lord, there are rules my lord, provided for it. My lord, in fact, straight away, my lord, if we show, yes, my lord, just to my lord, end on that, my lord, I'm taking my lord to a subsequent my lord, case 173, my lord. This is the principle I really want to argue. My lord, this is quoting my lord from T. Kaji. Correct. Let's just, this is my lord, part of.
No, where does it start?
My lord, it starts at 161. This is 1982, 2 Supreme Court cases, page 7, 161.
Yes. Yes.
This is on similar, my lord, saying rules are silent, but I just want to, my lord, I am, my lord, relying on this principle. And this is what, my lord, distinguishes, my lord, most of these cases, my lord, from our case.
Yes.
My lord, at 172, my lord, paragraph 21, my lord, will find, so long as, may I just start, my lord, I'm sorry,
Yes.
just take this paragraph and, my lord, 172, paragraph 21, so long as staff regulations are not framed under section 58(1), it is open to the central board to issue administrative circulars relating to service conditions of the staff in the exercise of powers under conferred by section 72 of the Act. In T. Kaji versus U. Jormanik CM, a district council was constituted on the 6th schedule to the Constitution for United Khasi and Jointia Hills district and tribal areas of Assam. The rules in the 6th schedule empowered the district council to make laws with respect to various matters regarding administration of district, including appointment or succession of chiefs and headmen. No law was, however, made regulating such appointments. Page 173, my lord. Even so, it was held by this court that the district council had the power to appoint or remove administrative personnel under the general powers of administration vested in it by the 6th schedule. Delivering the leading judgment of the bench. Now, my lord, can you just have a look at this, my lord? Justice Vanchu said that where executive power impinges upon the rights of citizens,
yes,
it will have to be backed by an appropriate law. But where executive power is concerned only with the personnel of the administration, it is not necessary that there must be laws, rules, or regulations governing the appointment of those who could carry on the administration under the control of the district council. The district council had therefore the powers to appoint officers by virtue of the fact administration was vested in it.
So makes a distinction between what? Yes.
What, my lord, is really affects others insofar as, my lord, right of, my lord, business is concerned, and, my lord, when, my lord, it comes to, my lord, framing rules to govern, my lord, personnel of the administration. Most of these cases, my lord, will see, my lord, that power was given, but, my lord, no rules to, my lord, appoint, no rules, my lord, to give promotion.
Yes.
And then, my lord, when salary, service conditions, most of these cases, except for 2, my lord, I'll distinguish them.
Yes.
So that is, my lord, a universal differentiation or, my lord, distinction, how, my lord, one can distinguish all these judgments, my lord, Mr. Sen has relied upon, and, my lord, in our case, apart from the fact that, my lord, there's a specific provision.
This is T. Kaji v. Jormanik CM, that one.
Yes, yes, yes.
What is the citation of this?
My lord, it is, my lord, 1961, 61 Supreme Court. I'll just, my lord, AIR 1961 Supreme Court 276.
The 5-judge bench.
Yes.
And, my lord, 5-judge bench, my lord, of.
Yes.
Justice Vanchu. So we thought, my lord, that is, my lord, quite a, my lord, it perhaps gives them genesis as to why the service cases seems to be slightly different than what the others are. So when you're affecting rights,
service matters don't have to be backed by statute.
there is a service, but when rules have to be filled in, it is easier to fill in service conditions than when it has to affect others. The administrative instruction have to govern those service conditions. If there's no rule to fill it.
Yes.
So that is what but here my right as a private hospital to run my hospital is being taken away without really the backing of law. That cannot be what I'm saying is cannot be under implied law.
Very good.
So I'll just come back on this. I'll finish it. We'll if
Yes.
another whatever gives me half an hour, I'll finish it on the next.
Learned counsel appearing for the petitioner has distinguished several of the cases cited on behalf of the commission, capital C. Stop. List this matter on Mr. Banerjee, 18th or 20th?
20th.
On 20th April 2023. Bish, Kuri.
I'm grateful.
Yes. Original site.
Grateful.
Ashona.
Original side, item number 1 to be mentioned, Shostika Steel.
You are for the petitioner? Can't hear you, microphone.
Yes, madam. I appear for the petitioner. Madam.
Yes, there was because I think somebody appeared on behalf of the petition. I could not follow what you were saying.
Well,
So,
Juliet appeared.
yes, so I will be this matter had been dismissed and rejected, the prayer rejected, but actually fresh order. Yes, this matter has been listed today at the instance of the court. Stop. The court had dictated an order upon hearing learned counsel appearing for the petitioners. Stop. However, before signing the order, certain documents before signing the order, the court came across certain documents. Stop. Counsel appearing for the petitioners is present today. Stop. Next, the petitioners were given leave to file an application for amendment of the writ petition on 16th March 2023. Stop. The application filed subsequently was not served on the bank, as would appear from an order dated 30th March 2023. Stop. The position remained unchanged on the next date of hearing, which was 4th April 2023. Stop. Council seeks. Council submits that the application for amendment does not contain a relevant document and seeks to withdraw the application on that basis. Stop. Is that the correct position? GA 1 of 2023 is accordingly dismissed as withdrawn with leave to file afresh.
To Hindustan Petroleum Corporation Limited versus the West Bengal.
Lord, I am for the private respondent, my lord.
देखिए last order था. No one, you're for the petitioner?
Yes.
Then why are you standing there? You're supposed to be standing in front of the microphone. What is this?
Sorry.
Yes, you have finished your submissions.
My lord, Mr. Dotto is leading me, my lord. My lord, he has completed his
Mr.
argument.
Dotto?
My lord, Mr. Kishore Dotto, my lord.
Yes.
So my,
Very well. Yes.
My lord, last occasion, my lord,
Speak clearly, please. Yes.
last occasion, my lord, I submitted the instant contract between the.
I can't hear you. Microphone, please.
In the last occasion, my lord, I submitted the contract between the my lord petitioner and the private respondent executed between the my lord. From the contract, my lord, I saw your lordships that the private respondent is a supplier and he comes under the definition of section 2N of the my lord MSME Act, my lord. My lord, in this regard, my lord, I cited one judgment, my lord. Dolapati Construction versus State of Andhra Pradesh reported in my lord 2022 SCC online on the Pradesh 2013, my lord. My lord, here, my lord, two paragraphs, my lord, I am submitting, my lord, paragraph 12, my lord. The last line, my lord, in paragraph 12, my lord, last line, my lord, once the said memorandum is registered with the said authority, the enterprise would be entitled to the benefits of the act. My lord, this, my lord, issue of this judgment, my lord, supported the decisions of the, my lord, Felicitation Council, which is at page, my lord, 407, my lord, at the writ petition, my lord. Kindly
I
come to,
can't
my lord.
understand what you're saying.
My lord, kindly come to, my lord, 407 of the, my lord, writ petition, my lord.
Yes. You are
400,
resisting.
405.
You are resisting the MSME Council from adjudicating, or what?
No, no, my lord. Adjudicate, I am not resisting by the my lord petitioner that since the instant contact is the works contact, so MSME has no jurisdiction to my lord to try this my lord adjudication, my lord.
Yes.
And that's why my lord they have challenged the my lord decision of the my lord MSME, my lord. My lord, in paragraph.
So that is the petitioner's position. What is your position?
My lord, my position is that, my lord, since I am a supplier under section 2N of the my lord, MSME Act, my lord, I am registered with the my lord MSME authority, my lord. So I am, my lord, the MSME has jurisdiction to my lord to adjudicate the matter under section 18 of the MSME Act, my lord. The reference to the my lord arbitration, my lord. And that, my lord, I am, my lord.
No, what do you have to say about the works contract?
Works contract, my lord. I say, my lord, from the instant contact, my lord, page, my lord, 186, my lord, at petition, my lord. It is not a works contract, it is a supply
186.
Contract. 186 of the my lord petition.
You just showed some other page.
186, my lord.
Yes.
This is the purchase order, my lord.
186.
186.
Yes.
My lord, kindly see, my lord. Please supply the following items.
Yes.
Please supply the following items service as per the terms and conditions mentioned below and in attachment, my lord. My lord, here we supplied my 67 items, my lord.
Yes.
Which the my lord HPCL, my lord, purchased from me, my lord. And my lord, it was delivered in a certain point, my lord. From this, my lord, contract, it is crystal clear that I am a supplier, and it is not a works contract, my lord. And And second, my lord, I have submitted, my lord, that in read jurisdiction, my lord, the read court cannot decide which contract is what's contract, my lord, which is supply contract. In this context, my lord, I am referring one judgment, my lord. That is, my lord, government construction versus executive engineer Sardar Sarovar Narmada Nigam Limited and another, my lord. It is reported in 2022, one Supreme Court cases 75, my lord, page 25, paragraph 25, my lord. Paragraph 25, my lord. My lord, paragraph 25, my lord, says, my lord, the Gujarat Act was enacted in 1992 with the object to provide for the constitution of a tribunal.
Which paragraph are you relying on?
Paragraph 25, my lord.
Yes.
The Gujarat Act was enacted in 1992 and with the object to provide for the constitution of a tribunal to attribute the dispute particularly arising from a works contract to which the state government or a public undertaking is a party. A works contract is defined under section 2K of the Gujarat Act. The definition of any of the definition of any of the works specified under this section. However, a plain reading of the contract between the parties indicates that it was for both manufacturing as well as supply of bricks. Importantly, a contract for manufacturer simpliciter is not a works contract under the definition provided under section 2K. The pertinent question, therefore, is whether the present contract, which is composite in nature, falls within the ambit of the works contract under section 2K of the
No, what is the Gujarat Act?
My lord,
what is the Gujarat Act?
the question is that the principal laid down.
I can't hear you. Microphone, please.
My lord, kindly next line, my lord, kindly come to next line.
What is the Gujarat Act? I can't understand. Which act does this refer to?
That is not say that Supreme Court laid down the principle that the question of
you are placing a decision. What is the Gujarat Act? That is paragraph 25. I'm asking you which paragraph gives me that act.
Lord, this is
which paragraph gives me that Gujarat Act?
Well, just a minute. My lord, kindly, my lord, Gujarat Act 1992 is connected with the object to provide for paragraph 3. Na?
Yes, but what is the act?
My lord, kindly, my lord, kind to paragraph 4 of Nana. 3. Responded 4 of it.
Mr. Pal, you are never ready in your matter. Never.
No, my lord.
Every time you will come up with some gap and then the matter has to be adjourned.
That the advocate agreed to conduct the
Yes, sir. Learned counsel appearing for the private respondent is not ready. Stop. List this matter. When will you be ready and come back? You are citing a decision. You haven't even read it. Just one paragraph you are banding before the court.
Day after tomorrow, my lord.
List this matter after a week. You never come prepared with your matters. Next.
Item number 3, item number 3, Indorama India Private Limited.
But this is my application, Lord. This is challenging a decision by the collector of stamp, by which Lord he has assessed stamp at 7% on the basis that it is a conveyance and not on the basis that Lord it relates to a scheme of Lord demerger. But special provisions have been made in the act, not with regard to demergers. He has completely not disregarded that. But if your lordship would not take
and why does the order record some pending appeal?
Yes, not. I'll tell you. I'll just remind your lordship. Not they kept seeking, and not I relied on a judgment which covers this not field completely. So my learned friends came up and said that they have preferred appeal against that order. And not on that basis, several adjournments were sought. So on the last date, I said, if required, not, I'll not rely on that. But the section is clear. So not that's where it
Yes,
stood.
yes, proceed with the, I will record that, what is the progress? I will record that and I will hear the petition.
The
Yes.
appeal was mentioned, my lord, it is not yet listed, my lord. But on the last occasion, my learned senior friend said that he will argue, even otherwise, my lord, on law, he will argue.
Yes, yes.
Now, I'm led by the learned advocate general in this matter, my lord.
Yes.
Not Mr. Bachchat starts not, he is arguing a matter. Mr.
You take down and sit down and take notes. Yes.
But my claim, Lord, is a very simple claim here, Lord. Your Lordship just needs to see that order first before I show your Lordship the section.
Yes.
But it's at page 15. I'll just tell your Lordship what it's about before that. But there's a scheme of demerger under which, Lord, which does not involve transfer of any property in West Bengal. That is
Page 50.
15. But before that, just 3 facts I give your Lordship. It may simplify matters a little.
Yes.
But it involves a scheme of demerger under which no property in West Bengal gets transferred. That is admitted in the order, number 1. Number 2, Lord, there is no cash conceit. There is no
property in West Bengal gets transferred means?
by virtue of the demerger. Lord, a company is demerged.
Yes.
Now, what is transferred, Lord, is not there is no immovable property in West Bengal involved in the matter at all.
Yes.
That's admitted. Number 2, Lord, payment is by way of not money. That is also recorded in the matter, in the order. Now, Lord, this will have a bearing when I show your Lordship the section. In the case of Dalgreen is shown to the collector. He not refers to it, but does not rely on it. These are 3 factors which your Lordship will see when I place the order, Lord, at page 15. Lord, very short order. Lord, if your Lordship would not please take it up, Lord. Page 15, 1
Yes.
5. Now, Lord, the first order is,
Yes.
as a petition is pending at the Honorable High Court about the percentage of stamp duty to be imposed, the applicant was given an opportunity of hearing. So this must be referring to the Dalgreen matter. A notice was issued, etc. Then, Lord, 4th November. The case is taken up today. Notice was served. Company Secretary so-and-so has appeared today, filed a hajira. Gone through the petition dated 10th August. Is the prayer for assessment of stamp duty on the scheme of demerger of divestment of business undertaking of Grasim Industries with and into Indorama resulting company. In the said scheme, there is no transfer of immovable properties in West Bengal. So, this is admitted. This will have a bearing on the rate. After sanction of the scheme by both NCLT Ahmedabad and NCLT Kolkata, final purchase consideration was determined at so-and-so. Heard the party. As per their claim, she stated that as per subsection B, under 23 capital A of Schedule 1A of the Stamp Act, stamp duty at the rate of 0.5% would be levied on the value of the consideration paid by the resulting company in the scheme of demerger. Now, Lord, the value is also not under dispute. She also mentioned about the judgment of the High Court passed in WP number 499 in the matter of Dalgreen Agro versus State of West Bengal. Now, Lord, from here is the finding. In reply, this is to state that in subsection B, under 23A of Schedule 1A, there is a provision to determine stamp duty at 2% of the value of immovable property located within the state of West Bengal, or 0.5% of market value of shares issued or allotted, and the amount of consideration paid for such demerger, whichever is higher. But in this particular case of demerger, there is neither transfer of immovable property in Bengal nor transfer of any share. The entire payment was made by way of monetary consideration. Therefore, provision under subsection B, under 23A of Schedule A was not considered for adjudication. Although this is what covers it, I'll show your Lordship. There are 2 provisions. There's a proviso there. The provisions under 23A of Schedule 1A, where it is mentioned that the same duty as conveyance, i.e. 7% of the aggregate market value of the shares issued or allotted in exchange or otherwise, and the amount of consideration paid for such company for reconstruction of or demerger is to be considered for adjudication of stamp duty. Now, 7% does not apply in any case of merger or demerger, that I'll show your Lordship. Therefore, it is proposed to follow a the direction as provided under 23A of the Stamp Act.
Yes.
So, my lord, one, he ignores Dalgreen, although there is no stay. Now, how a government authority, my lord, can do that is not something, my lord, I've understood. Can't be done. No reasons given. Does not say there's a stay. Now, my lord, this is also against the clear reading of the section. If I may just hand it up to your lordship, my lord. Copy.
Yes, stamp.
নাহলে আমি দিয়ে দিচ্ছি। দাও।
Yes. You're showing me 23A.
23 capital A. Now, my lord, please remember, this is not under Schedule 1A to the Stamp Act, which is these are all West Bengal amendments.
Yes.
Now, your lordship will also not know this, that Lord, Article 23 covers conveyances. 23A was an amendment brought in 2012.
Yes.
Now, my lord, these amendments were brought in. I'll just not give your lordship a small background, but these amendments were brought in because prior to 2012, there was a little uncertainty about the provision. And
Yes.
Lord, it was not clear whether a scheme would be covered as a conveyance or not. Ultimately, my lord, pursuant to litigation in various high courts and the Supreme Court, my lord, it was made clear that it is the order by which a scheme is being sanctioned, but that is what is liable for stamp. So, my lord, it is at that stage, my lord, that these amendments are brought about. Now, my lord, if your lordship sees 23A.
Yes.
Now, my lord, A is the description of the instrument. Lord, I'll not trouble your lordship. It relates to amalgamation, merger, reconstruction, demerger. Now, your lordship has seen, he also proceeds on the basis that 23A is applicable. Now, please go to the next column, which is not the proper stamp duty.
What proceeds on the basis that 23?
The order proceeds on the basis that 23A is applicable. Your lordship has seen that. He has applied the first part of 23A.
Yes, says, what is happening outside? When did the High Court become a completely? দেখো তো কি হচ্ছে বাইরে? Says, partial court. Says that 23A was not considered for adjudication of stamp duty.
Yes.
Middle of page
Yes, madam.
16.
The next sentence, madam, after that, the provisions under 23A of Schedule 1A, where it is mentioned that the same duty as conveyance number 23, i.e. 7% of the aggregate market value of shares, etc. That's what he considers.
Yes.
So it takes into account 23A only.
Yes.
So now, my lord, if your lordship looks at the applicable column, which is not the column with the heading proper stamp duty, my lord, if I may place that.
Yes.
The same duty as a conveyance on the aggregate of the market value of the shares issued or allotted in exchange or otherwise, and the amount of consideration paid. Now it makes not two categories. But category A is to do with mergers, amalgamation of mergers, which does not concern us. But then let's B, if your lordship sees,
Yes.
is to do with demergers, which is what not we are concerned with. Now your lordship sees B, by the resulting company for such reconstruction or demerger, provided, now Lord, the proviso, Lord, limits it. Proviso says, provided that in case of reconstruction or demerger, the amount of such chargeable duty chargeable under this item shall not exceed either 1 or 2, whichever is higher. And Lord, your lordship will find under 1, it is 2% of the market value of the immovable properties located in the state of West Bengal. And 2 is 0.5% of the aggregate market value of the shares issued and the amount of consideration paid.
So you will come under I.
No, double I.
No, whichever is higher.
Whichever is higher. Now, Lord, in this case, there's no property in West Bengal.
Very well. Yes.
So, Lord, I come within double I. Now, Lord, the first point which I was trying to show is, in either case, it is either 2% or 0.5%. But there is no scenario where 7% is payable at all. At all. So his finding of 7% is wrong.
And he comes to 7%.
I'll show you, Lordship. I'll show you, Lordship. Just one more sentence.
7% on the aggregate of the market value.
Yes. Now I'll tell you, Lordship, how he comes to this. Now, my lord, below 1 and 2, your Lordship has found which is higher.
Yes.
Now, my lord, this which is higher, whichever is higher, is, my lord, qualifying 1 and 2. It is not qualifying anything else.
Yes.
And this, my lord, I'm fortified in my submission. If your Lordship also sees A, similarly,
That has a whichever is higher as well.
yes, that also contains it. So
Yes.
it does not qualify, not the beginning words of the portion. Now he says it has to be the highest of not just 1 and 2, but of the opening words of the provision.
Which is?
Same duty as a conveyance. He ignores the proviso as if the proviso doesn't exist.
Duty as a conveyance is 23.
23A, not 23A, proper stamp duty payable, your Lordship finds the column, same duty as a conveyance on the aggregate market value, on the aggregate of the market value of the shares issued or allotted in exchange or otherwise, and the amount of consideration paid. But he is now proceeding on the basis that there is no proviso, completely disregards it. It's as if it's evaporated. The proviso limits it in the case of a demerger and a merger also. Whichever is higher, Lord, cannot relate to the opening words of the provision.
So he only goes on 23.
He goes on 23. 23A. He goes on 23A, which says same as 23.
Yes.
This is what that cryptic sentence of his means.
No, 23A, the two parts also say I says 2% and II says half percent.
Yes, 2% if there is property within.
No, that is 23A. So where is he getting the 7% from?
He said, no, not because the opening words of 23A are
Yes.
same duty as a conveyance. Now, for a conveyance, it is 7%.
Very well.
That's how he gets the 7%.
And where does it say 7%?
My lord.
Where does it say 7%?
But if your Lordship comes to, my lord, conveyance, which is 23, then, my lord, there are again, my lord, different my lord, categories. So, my lord, if it is within Howrah Municipal Corporation, it's one thing. If it's within KMC, it's another thing. But if your Lordship sees, Lord, in the case of 23, your Lordship will find 6% of the market value, where, my lord, it is in Kolkata. And if it is over 1 crore, it is 7%.
And this property is where?
But this property, there is no property in West Bengal at all. In our case, admitted, he records that in his order. And that's the reason he says 23A does not apply, because there is no property in West Bengal. But the second part of A and B also consider the situation your Lordship sees or the value of the shares. Now, if I may read, not between 1 and 2, there's a or.
Yes.
1 relates to a situation where property is within West Bengal. Or 2, an amount equal to 0.5% of the aggregate market value of the shares issued or allotted to the resulting company and the amount of consideration paid for such demerger. So I've paid a consideration. It has to be 0.5% on that consideration. And if it is not both, then in that case, whichever is higher.
Yes. So you're saying that an invisible line is drawn between 23A and 23B, which he disregards.
But he disregards the proviso altogether, as if the proviso does not exist.
Yes.
Now, just to make a reading of the section easier, I've taken one liberty, because I think that typed thing will perhaps make it a little easier for me. My way of explaining it may not be as good. What I've done is I've taken one liberty. I've typed it out exactly as the section reads.
But with alignment?
No. I have not even done that. What I've done is, your Lordship takes the sheet where only 23A is there once.
Yes.
Where the entire section is there. So this is
Yes.
the section as it is. I've made no change.
Yes.
Now the second sheet, if your Lordship takes,
Yes.
I've simply deleted A, because A is not applicable to us. I've only put in B in the upper portion. Now, my lord, in the lower portion, I've set out the same thing, only removing the alphabet B and joining it with the first part of the, not the opening words of the provision. So if your lordship would read, not, so this is only to show that I have done it accurately. Otherwise, I could have given your lordship only the second portion on the second page. So, my lord, if I may just place this once. So, my lord, how should this read? The same duty as a conveyance on the aggregate of the market value of the shares issued or allotted in exchange or otherwise, and the amount of consideration paid by the resulting company for such reconstruction or merger, provided that in the case of reconstruction or demerger, the amount of such stamp duty chargeable under this item shall not exceed either 2% or 0.5%.
No, which one are you taking as page 1 and which one are you taking
I'm
as
sorry.
page 2?
The one where 23 is set out twice is page 2.
That's page 2.
Yes.
Very well.
But
Yes.
one is setting out the section as it is.
Very well. Yes.
Then in the first part of the second page, I have set out the provision without A, because A does not apply to us.
Yes.
And then in the next step, what I've done is I've simply joined it together. That's all.
Yes.
So the words in B by the resulting company, I've joined it with the opening words. That's all.
Yes.
But if I may read it that way, the same duty as a conveyance on aggregate of the market value of the shares issued or allotted in exchange or otherwise, and the amount of consideration paid by the resulting company. So by the resulting company, I've just joined it together.
Yes.
For such reconstruction or merger, provided that in the case of a reconstruction or demerger, the amount of such duty chargeable under this item shall not exceed either 1 or 2, whichever is higher. This is how it reads.
Yes.
So in no case can it exceed 2%. In my case, it will be 0.5% because there is no property in West Bengal.
Yes.
So this whichever is higher, in the same formatting as it's in the Act,
Yes.
qualifies the proviso.
Yes.
So the two portions in the proviso. It does not qualify the opening words, which is what the collector has sought to do.
Yes.
So on a clear reading,
Yes.
the words whichever is higher qualifies 1 and 2. It does not qualify the opening words.
Yes.
But second submission is the words of the section are clear. There is no scope for misconstruing.
Very well.
Number 3, in reading it, he cannot ignore the proviso. That's an unknown way of reading a statute. He has proceeded on the basis that the proviso does not exist. And the proviso makes it very clear that I fall within 2.
Yes.
Because of the words or in between 1 and 2, he can't say because I don't fall in 1, therefore 2 is not applicable. If there was a and, I could have understood it. But because of the words or, the moment
I've seen that is disjunctive. Yes.
Yes. So given that the construction which he gives it is completely wrong. Number 2, your lordship has seen there are no reasons given for not following it. Number 3, there is no stay. He cannot simply say there's a matter pending, but I will not obey the judgment of the High Court.
As in?
Dalgreen, in Dalgreen's case, he says Dalgreen is pending.
Yes.
He says that there's a judgment there that's binding on him.
Yes.
He has to obey the order of the High Court. He can't simply say, look, I'll ignore it. And he has not said that, but he has ignored it in fact. Now, given this, my submission here is the section itself is clear. Given that his finding is cryptic, as my learned friend on the last day said, there is some confusion because of the wording of the section, but not when one places it in a proper perspective, but the meaning is very clear.
Very well.
Now, based on this, the difference in value is huge, 0.5% and 7%. It's 14 times.
Yes.
Now, the matter has to be decided whenever the learned advocate general comes and argues it's all right. But I was respectfully only playing this. Given that it is on the face of it 0.5%.
That you want to pay 0.5
deposit at the rate of 0.5%. I don't want it later if there's an increase in stamp duty or any other.
Deposit 0.5.
My lord.
Let him deposit 0.5.
Whatever interim order your lordship passes, I only pray if your lordship takes up tomorrow, so that my senior can address your lordship on this issue, since he has advanced his arguments tomorrow, if your lordship kindly allows.
Yes, heard learned counsel appearing for the petitioner. Stop. Council did not place reliance on the judgment of the coordinate bench, which is presently under appeal. Stop. This court was inclined to consider interim relief, but for the submission that the learned advocate general would like to make submissions in the matter and is not present in court today. Stop. Next, list this matter on Mr. Bachavat, 13th, 17th.
Whenever suits your lordship.
List this matter on 13th April 2023. Next.
Much obliged. Hey, I'll just give you a copy of this. I'm sorry, Munad, I forgot to hand over a copy to my learned friend.
Want to give it to him to confuse him further, Mr. Bachavat?
Munad, I think not. I was myself.
Don't tell him which one is page 1 and 2. It'll be
I'll write it down.
sufficiently confused.
Hold it.
Yes. Yes.
Item number 4, Sri Sandeep Kabra.
Yes.
Your Lordship, I'm on the responding on the last two. Yesterday, I was addressing the court on the maintainability point. Your Lordship, I have few authorities. And
why? On which point?
On the point of maintainability of the writ petition.
No, that I know, but on authorities on which point?
Doctrine of delay and laches.
Give me your best case, please.
The best case I will place. I have cited, I have that, then I have that.
So don't say decisions, just one. Give me your best case.
What's 1995, volume 4, SCC 683. This is the larger bench judgment. 3 judges of the Honorable Apex Court. Your Lordship, paragraph head note A, para 26. Your Lordship, the judgment is saying the Honorable Court has heard.
1 minute, let me have a copy of it.
Lordship,
Yes. Para.
Lordship, para 26. Your Lordship, para 26 on the doctrine of delay and laches.
Yes.
Lordship, thus, when the writ petitioner was the guilty of laches or undue delay in approaching the High Court, the principle of laches or undue delay adverted to above, this entitled the writ petitioner for discretionary relief under Article 226 of the Constitution from the High Court, particularly when virtually no attempt has been made by the writ petitioner to explain his blameworthy conduct for undue delay or laches. The High Court, therefore, was wholly wrong in granting relief in relation to inquiring into the allegation and granting compensation for his land alleged to have been used for sacristy relief road works in the year 1971-72. As seen from the judgment of the High Court, the allegation averred to above appears to be the common allegation 191 writ petitions, where the judgments were rendered by the High Court following the judgments under the appeal.
That is all. Which other paragraph?
Let's see, paragraph number 26 in this judgment.
That is all.
Lordship,
Yes.
Lordship, 1 or 2. I will not trouble your Lordship with more.
No, what delay and laches? How many decisions do you need for delay and laches?
Lordship, because I am trying to place the best judgments and the best paragraphs. I will not trouble.
Your next best judgment and your last best judgment.
Lordship. Lordship. 2004, volume 11, SCC 526. Let's say para 26 once again here.
Which page? Yes.
Page 538.
Yes.
Let's see, we may also notice the aspect of long delay in laying challenge to the validity of the impugned provisions. No hard and fast principle can be laid down
that under no circumstances delay would be relevant consideration in judging constitutional validity of the provision. It has to be rendered that the constitutional remedy under Article 32 is discretionary. In one of these cases, the court may decline discretionary relief if the person aggrieved has slept over for a long number of years.
Very well. That's all.
Identical to my case, Your Lordship. So, Lordship, my submission on the last occasion in 30 seconds. Admittedly, the willful declaration in the year 2018, publication in the year 2019, they slept over to challenge the same before the writ court, and only come before the writ court when the bank has issued LSE request and they had been prevented to go abroad in the month of December 2022.
Yes, December 2022 is the LOC.
Your Lordship. Prior to that, did not turn up to challenge this.
And willful default declaration is of
2018.
18 published?
Published in May 2019. And more, Your Lordship, kindly recall, there is another matter in the appellate side, Your Lordship.
And declaration by the both the committees.
Yes.
Yes.
But they did not challenge for 5 years.
Anything else?
My Lordship, in the writ petition, there is not a single word has been uttered. Why they have taken 5 years time?
Yes.
For approaching the writ court. So this is the afterthought product of afterthought. So my submission before the Lordship, if a litigant is slept over.
December 2022 is the LOC.
Lordship.
Very well. Yes, Mr. Shah.
My Lord, the question is, my Lord, if your Lordship sees, my Lord, the last judgment that my learned friend has cited, where it says, my Lord, it is not, my Lord, an absolute rule that, my Lord, for delay, the court will not exercise its discretion. And my Lord, it says also, depends on the nature of, my Lord, violation. That is, my Lord, what the judgment says.
Yes.
Now, my Lord, here, your Lordship will notice that, my Lord, now the Supreme Court has pronounced that, my Lord, this is something that ultimately interferes with the fundamental right. 19(1)(g) is violated. That is the case of jar developers. Now, my Lord, if today, my Lord,
This is something, which one? Not being able to travel?
No, the declaration of willful default. But that may be incidental. But, my Lord, when I, my Lord, challenge, my Lord, an action, and when I premise it on, my Lord, the challenge based on law, then, my Lord, the question is, my Lord, here, the, my Lord, guidelines that have been provided, guidelines are, my Lord, mandatory guidelines.
Take your seat. Yes.
There is no play in the joints available here. And the Supreme Court now, my Lord, while interpreting these guidelines, has said very clearly that these guidelines have to be very strictly interpreted and construed because, my Lord, they affect fundamental rights. 19(1)(g) is an issue. And, my Lord, that is why, my Lord, even, my Lord, there was an incorporation made by implication in the guidelines of 2015. Well, I did not cite the judgment, my Lord.
Guidelines, master circular.
Yes, my Lord. My Lord, kindly have a look at my. I did not. Well, this is jar developers. This is just one paragraph.
That's Justice Nariman.
That's right.
Yes.
Just one paragraph. Copy that.
Yes.
Well, just kindly have a look at paragraph, my Lord, 24 once. Lord, just after, my Lord, towards placitum C, paragraph 24. However, we are of the view that Article 19(1)(g) is attracted in the facts of the present case, as the moment a person is declared to be a willful defaulter, the impact on his fundamental right to carry on business is direct and immediate. This is for the reason that no additional facilities can be granted by any bank, financial institutions, and entrepreneurs, promoters would be barred from institutional finance for 5 years. Banks, financial institutions can even change the management of the willful defaulter, and promoter director of a willful defaulter cannot be made a promoter or director of any other borrower company. Equally, under Section 29A of the Insolvency and Bankruptcy Code 2016, a willful defaulter cannot even apply to be a resolution applicant. Given these drastic consequences, it is clear that the revised circular, being in public interest, must be construed reasonably. This being so, and given the fact that Para 3 of the Master Circular of 2013 permitted the borrower to make a representation within 15 days of the preliminary decision of the first committee, we are of the view that the first and foremost, the committee comprising of the executive director and 2 other senior officials.
Mr. Shah, I know that it goes on to the structure of the redressal mechanism.
And well, it says that so far as the willful default committee is concerned, you have to serve a copy of the order.
15 days
15
and all
days.
of that, yes.
Now, well, here, well, what I'm complaining of is that by a single order, well, today the willful default committee and the identification and the review committee have both disposed of the matter. Well, just one paragraph of the order, once again, well, if your lordship will kindly consider.
Yes.
Well, this is page. Well, the order starts as at page 51. 51.
Yes.
Well, I just want to show you, Lordship, page 54. Well, the third paragraph at page 54.
Yes.
Thus, the committee members are of the opinion that the above acts of the company and its directors fulfill the criteria of RBI, declaring them as willful defaulter. Then, the company and its directors have been afforded opportunity to explain their position and response thereto. Well, I will not trouble you, Lordship. Then, as per RBI guidelines, the above order of willful defaulter identification committee was placed before the bank's willful defaulter review committee of the board. And after reviewing the said order, the willful defaulter review committee of the board, where its resolution dated 15th August 2018 has approved for declaration of
Yes,
the borrower.
Mr. Shah, I remember.
Yes.
And you have published once only.
Lordship, the publication, what my learned senior is addressing before a Lordship on merits.
I am asking you, answer the question.
Yes.
Once.
Once.
And that is what the master circular says, that you will basically publish the pictures of the willful defaulters.
Yes. September 2016 RBI guidelines.
Well, the RBI guidelines, so far as this is concerned, I have annexed the guidelines also. And the
That is
guidelines.
2015. I am asking for 2016. Lordship, I am on the maintainability.
Wait, I have not asked you to make submissions. Yes.
Well, the guidelines clearly show in page 39 that this is the procedure to be followed. That is what Justice Nariman has also ultimately recommended. May I just read for completeness 39, clause C. Order of
Mr. Shah, I am familiar with this decision. Paragraphs 24 and which other paragraph?
Well, just paragraph 24 of JAR developers. Other paragraphs are not relevant because they talk about right of representation through a lawyer. No.
Yes.
Well, your Lordship has also ruled on it, but I'm not citing those judgments because I know your Lordship normally would not like to look into those. Yes. But here there's no explanation as to why the matter was so summarily dealt with. I give a representation. They deal with my representation by just repeating what they had stated earlier, without really dealing with my representation, and by a common order, they dispose of them.
Explanation, Mr. Shah will have to abide by the goose and the gander analogy.
Yes, of course. But that is of course. In fact, I cannot even ask your Lordship to sit on sitting appeal over the explanation that I have offered and the manner in which the bank has considered. I am ultimately confined to adherence to these mandatory rules.
Yes.
And particularly mandatory since they affect fundamental rights.
Very well. Yes.
Only so far as the judgments are concerned, my learned friends have relied on judgments. Well, I can only say.
I will discount. Yes. Heard learned counsel appearing for the petitioners and the respondent bank. Stop. List this matter. On 21st April 2023. Under the 24th column, under the heading for judgment.
Let's say I have already argued on maintainability. Let's say I was not argued on.
Don't feel so scared. Yes. Next.
Let's say, may I take your let's say.
I'm appearing for the petitioner. It's a very short petition.
Let the matter be called on.
Item number 5, Kanchun Dotto.
Yes.
So it has been served upon all the respondents.
But for the pro forma respondents.
Lordship,
Who is the answering respondent?
Lordship, the answering respondent.
Microphone, please. Who is the answering respondent?
Lordship, the answering respondent will be the assurance.
Assurance.
Inspector General of Assurances. That is respondent number 2. The answering respondent.
Who is appearing for that?
He is appearing.
Whether you have
It has been served. It has
on
been
the
served.
Mr. Sinha, advocate on record of the state of West Bengal.
Very well. When do you want to come back? After completing service?
Lordship, it has been served upon all the parties. I understand it has.
When?
Lordship, that is copy has been handed over. Copy nahi kiya, that's it.
All the named parties herein, it might have been served, Lordship.
3rd March. Very well. The answering respondent is not represented. The answering respondent, namely, the respondent number
Two and three.
two,
The Inspector
respondent numbers 2 and 3 being the Inspector General of Registration and the Additional Registrar of Assurances are not represented. Stop. The affidavit of service is kept on record. Stop. Give me a date and then you will have to inform them once again.
Lordship kindly keeps it a week later. In the meantime,
List this matter on 20th
next week.
April 2023. Stop. Learned counsel appearing for the petitioner shall serve them once. Petitioner shall serve them once again.
Lordship, I shall also.
Shall communicate this order on the answering respondents.
Lordship, I'm told that Mr. Parito Sinha is the advocate on record. So in that event, we shall, for the state of.
The petitioner shall also be at liberty to serve the advocate on record of the answering respondents.
I'm great.
Deeply obliged, my lord.